My lord, may I permitted to my lord extreme urgency, my lord.
No.
Bank has, my lord, locked the, my lord, house with
Please,
key,
okay.
my lord, educational, my lord, document, my lord, two children, my lord,
No.
everything is there, my lord.
For judgment,
My
item
lord.
number 1.
My lord, may I permitted to one?
My lord, matter is appearing, my lord, 165, my lord, of your lordship
Item
list.
1, hence WPA 21320 of 2021 is allowed, thereby setting aside the impugned rejection of the petitioner's claim for OBC certificate and remanding the matter back to the concerned block development officer for a fresh consideration of the application of the petitioner. The BDO shall, within 6 weeks from the date of communication of this order to the BDO, undertake a fresh inquiry by calling for a report afresh and giving the petitioner and or his duly authorized representative an opportunity of producing all documents in support of the petitioner's claim, and to deal with the inquiry report by furnishing a copy of the same to the petitioner and or his representative. Upon such opportunity being given, the BDO shall decide the issues afresh within the time as stipulated above in accordance with law. Thereafter, the BDO shall pass a reasoned order as to why the claim of the petitioner is either entertained or rejected. It is made clear that whichever way the BDO goes, it will be open to either of the parties to prefer a challenge against the BDO's decision before the appellate authority. None of the authorities in question shall be influenced in any manner on merits by any of the observations made herein, but will undertake a fresh inquiry in accordance with law as directed above. No orders to cause urgency.
Yes. Much obliged.
Thank
you. Much.
Next.
For judgment, item 2.
I'm for the petitioner, Lordship.
Hence, a detailed scrutiny of the law and the facts of the present case indicate that the bank is not controlled, financed, aided, or run by the state government for the purpose of coming within the purview of Section 6 of the West Bengal State Election Commission Act 1994 or other parliamentary statutes. Hence, it cannot but be observed that the deputation of employees of the Malda District Central Cooperative Bank for election duty in polling stations for the Panchayat elections is dehodes the law and cannot be sanctioned. Since in the recently concluded Panchayat elections, employees of the bank have already performed polling duties, which could not be helped since the present challenge was made in close proximity to the election, the said deployment cannot be reversed. However, it is hereby held that the state government does not have any jurisdiction or authority to depute employees of the above named bank for election duty in polling stations in respect of Panchayat polls. WPA 15513 of 2023 is disposed of accordingly. No rest to cause urgency.
Grateful, Lordship. Grateful. Grateful.
For judgment, item number 3.
I've held that the ROC does not have any authority to make these inquiries, but I've disposed of the petition. Accordingly, WPA 16947 of 2023 is disposed of by granting liberty to the petitioners to file fresh complaints pursuant to the present order, giving all known particulars regarding the alleged fraudulent transactions and share transfers being conducted by the struck-off shell companies, which are shareholders of the petitioner number 1 to the appropriate authority, including the respondent number 4, Ministry of Corporate Affairs and the SEBI. Upon such written complaints being made in terms of the present order, respondent number 4 and the SEBI shall act on the same, if necessary, upon giving further opportunity to the petitioners to elaborate on their complaints by holding an appropriate inquiry into the allegations made in the complaints. If upon such inquiry it is found that there is substance in such allegations, the respondent number 4 as well as the SEBI shall initiate proper investigation and will be free to depute appropriate investigating agencies to take corrective steps. No orders to cause certain certificate copies. Difficulties SEBI that representation has been annexed, which is the most detailed one, but SEBI is not a party here. That's why I could not direct SEBI. I did not impede the SEBI, which would stall the proceeding unnecessarily. I've given these liberties. Approach with the complaint before those authorities, particularly SEBI and Ministry.
I'm deeply
Thank you. Thank you.
We mention item number 4 for withdrawal.
My application seeking to withdraw the review application.
Without.
Without liberty. It is preferred an appeal.
Right.
Well, may I file my instruction received over email?
Yes.
Kindly records the instruction. Sent to my advocate on record.
My lord, I am appearing for the respondent in this
Yes.
matter.
Learned counsel for the petitioner submits that the petitioner seeks to withdraw the present writ petition in view of having
It's a
filed.
review application. Order seeking review of.
Oh, I'm sorry. Seeks to withdraw the present review application in view of having preferred an appeal against the order dated July 14, 2023, before the appropriate bench of this court. Full stop. In view of such prayer, comma, RVW 165 of 2023 is dismissed as withdrawn without any order as to cost. Full stop. The written instruction, the written printout of the email instructions given to the learned advocate on record for the petitioner, comma, handed over in court today, comma, be kept on record.
I'm so grateful, my.
Grateful, my lord.
Can such and such is accordingly disposed of as well.
Top item, item 5.
My lord, I am for the petitioner, my lord.
Yes.
Pursuant to your lordship's direction, my lord, I have served a notice, my lord, on Mr. Siddiqui.
Not appearing. Not
Not-
appearing, obviously.
Not appearing, my lord, today also.
So you can file that also.
My lord, this needs to be affirmed, my lord. This was, my lord.
During the course of the day, do it.
Yes,
What
yes,
is the
certainly,
order?
certainly, my
Yes.
lord. I am also led by Mr. Jayanthanarayan Chatterjee, my lord.
Should I keep it on some other day?
Your lordship, my lord, I can, my lord, proceed, my lord. If your lordship, my lord, my lord, this
If you
matter, my
proceed,
lord,
it will be finished in 10 minutes.
this matter, my lord, relates to remission. So, my lord, the state's absence, my lord, is somewhat, my lord, a difficulty, my lord. Lordship, may I, my lord, humbly pray before your lordship to keep it tomorrow, my lord. In the meantime, I'll again try
I
and
think
serve.
that
on-
will be easier.
my lord.
At the time of call, none appears for the state. Full stop. Let the matter stand adjourned for the day and shall next be listed tomorrow under the same heading.
Grateful.
Item 6.
6, my lord, I am appealing for the petitioner.
Yes, please. What is the matter?
My lord, in earlier occasion, your lordship directed to hold a, my lord, joint survey, my lord, for finding out new alternative, my lord, route
Yes.
from which
The private respondent had an objection regarding the route.
no. He given no objection, my lord, joint inspection report, my lord, handed over to me. My lord, in alternative route, my lord, they have no objection. And they given also statement is there that they had no objection. If in alternative way, the connection be
Yes,
made.
you also say so.
Alternative connection. My lord, may the report be filed.
You have to file the original report. Yes. Definitely. Keep it with you.
Yes.
Learned counsel for the WBSCDCL files a report as per previous direction. Puts up in the said report, comma, it is indicated that an alternative route was identified and agreed upon by both the petitioner and the private respondent, comma, for giving electricity connection to the petitioner. Full stop. A hand sketch map is also annexed to the report, comma, indicating the said alternative route, full stop. Since the parties do not have any objection to such alternative route, comma, WPA 16872 of 2023 is disposed of by directing the WBSCDCL to give a new electricity connection to the petitioner over the alternative route as indicated in the report filed today in court and the map annexed thereto, comma, which are kept on record. Full stop. Such connections shall be given as expeditiously as possible, comma, preferably within a fortnight from date and or from compliance of all formalities by the petitioner, comma, whichever is later. Full stop. Next para. I need not give
My lord, if
police.
any police assistance required, my lord, kind.
Why?
Well, because my lord, in alternative way, my lord, there must be some, my lord, obstacle given.
In
taken,
the
my lord.
event any obstruction is raised to the WBSCDCL in completion of such work, comma, it will be open to the said personnel to approach respondent number 3, comma, the inspector in charge of the Lilua police station for adequate police assistance at the cost of the petitioner. Full stop. The parties shall act on a server copy of this order for the purpose of implementation of the same.
Great.
No rest as to cost charges.
Great.
Grateful.
Item 7.
In this matter, my lord, I am for the respondent. In this matter, my lord, it's very simple. Prior, my lord, in the year of 2006, my lord, I took loan 6 lakhs. Thereafter, my lord, started to pay the loan, but sometime due to paucity of the fund, my lord, I did not able to, my lord, deposit the EMI. The SABYASACHI proceeding initiated by the bank. I'm not on that point, my lord. I'm not submitting before first staying the SABYASACHI proceeding. Nothing, my lord. Out of 6 lakhs, my lord, I praying before the bank to give the information of how much I paid, and 7 lakhs I intends to pay for settlement. If the bank agreed, my lord, settle these issues. If not agreed, my lord, rejected, my lord. That's why, my lord, I filed this case. My lord, page number 22, my lord, I made an application.
What is the stage of the SABYASACHI proceeding? Section
No, my lord, 13 several occasion issued. Number of occasion issued 13 3 or 4 times, my lord. Thereafter asked to come before the bank, my lord. I went to the bank.
Please decide on this application. If you reject
Yes,
it or allow it, whatever.
It has just been given on the last
Obviously,
month,
obviously.
late last month.
So
So
I'll incorporate
Lord,
the
I-
direction in my and in my order, and the writ petition I'll dispose of.
disposed of by
There is no
considering
scope of any other relief to them.
Well,
They are not also
by
paid.
considering the, my lord, my application,
Right.
page number 22, and will supply the information to ascertain that how much I paid in respect of my loan, because the loan sanctioned in the year of 2006, my lord, page number 9, page number 10. that has been
Learned
firmly given
counsel
anyway.
for the petitioner restricts the petitioner's prayer to a consideration of a representation, comma, annexed at page 22 of the writ petition, comma, praying for some installments in payment of the in repayment of the loan of the petitioner to the respondent bank. Full stop. It is further submitted that the bank be directed to furnish a breakup of the amount due as of today from
The
the
due amount, my lord, breakup submitted, my lord, page It has number already been 21. submitted, lordship.
then what?
How much I paid, my lord, in respect of the loan, my lord.
That is there in the statement, lordship.
That is there in the
Dues, my lord, out of 6 lakhs I paid, thereafter 31 lakhs dues, my lord. No,
এই last second portion টা কেটে
dues, my lord, supply.
যেটা বললাম যে ওই to consider. হ্যাঁ accordingly heard learned counsel for the parties, full stop, in view of the innocuous prayer made, comma, the writ petition does not remain adversarial and, comma, as such, comma, no affidavits are directed, full stop, it is deemed that the allegations made in the writ petition are not admitted by the respondents. Full stop, WPA 17284 of 2023 is disposed of in terms of the prayer of the petitioner to the effect that the respondent bank shall consider the representation of the petitioner for easy installments, comma, annexed at page 22 of the writ petition, comma, for repayment of the petitioner's loan. Full stop, next para. Upon such consideration, comma, which is expectedly to be done within a fortnight from date.
No, lordship, this is a for a large bank based in Bombay, so 1 month's time should be perfect. Lord.
But the more you delay, the more you'll be
Lordship, this is a 2006 loan. Anyway, it is to
expectedly within a month from date. Full stop. Upon such consideration being made, comma, the respondent number 1 bank shall communicate the outcome of such consideration to the petitioner. Full stop.
Much
More or less to cost charges.
much. Affidavit in service.
Evidence service file to be kept on record and communicate in writing. Communicate it's
Much.
Item 8.
I am for the petition. But I am for the licensing authority.
Affidavit of service yesterday.
But I am for the licensing
yes.
authority.
Lordship, petitioner is a tenant applied for a domestic connection, and lordship, due to the strong objection of the landlord, lordship, the CSC authority could not make inspection also, lordship.
yes, Mr. Scott.
12 to 13 electric meters already inside that premises. But there is always a question of street load. Let CSC decide on that.
Let them, yes.
My lord,
Yes,
according to my instruction, my lord, CSC is ready to give supply, subject to compliance of all formalities, including payment of charges, my lord. And my lord, since the private respondent obstructed, my lord, that's why, my lord, the CSC, in fact,
a
cannot.
direct eviction of the private respondent.
Lordship, another thing, ejectment.
Keeping in
notice-
mind the safety measures that I'll incorporate because of their apprehension.
Subject to my lord, they took the inspection.
Subject to everything else, yes.
Yes.
Ejectment suit is also pending against.
No, that was learned counsel for the petitioner contends that due to the obstruction of the private respondent, comma, the petitioner is not being able to get a new electricity connection, comma, despite having applied for the same. Full stop, next para, learned counsel for the private respondent submits that there are already several electricity meters installed in a cramped space in the premises in question, comma, which gives rise to apprehension of fire and electrical hazards. Full stop. It is submitted that such apprehension is the sole ground of objection of the private respondents. Full stop. Next para, learned counsel for the CSC Limited submits on instruction that the CSC Limited is agreeable to give a connection to the premise to the petitioner, comma, subject to the petitioner complying with all due formalities in law. Full stop. Next para, since the petitioner, comma, otherwise, comma, has a right to get an electricity connection under section 43 of the Electricity Act 2003, comma, the same cannot be interdicted unnecessarily. Full stop. However, comma, the apprehension of safety hazards raised by the private respondents is also to be incorporated in the exercise to be done by the CSC Limited. Full stop. Next para, accordingly, WPA 17774 of 2023 is disposed of by directing the CSC Limited to give a new electricity connection at the existing meter board position of the premises in question to the petitioner, comma, subject to compliance of all formalities by the petitioner, comma, within a fortnight from the date of such compliance. Full stop. Next para, while giving such connection, comma, the CSC Limited shall take into consideration all safety measures, safety and security measures as it is duty bound to maintain in terms of law. Full stop. In the event any obstruction is raised by the private respondents or their main and agents in the CSC personnel holding an inspection or giving such connection, comma, it will be open to the said personnel to approach respondent number 3, comma, the officer in charge of the Ekbalpur police station for adequate police assistance, which will be given by the respondent number 3 by acting on a server copy of this order at the cost of the petitioner. Full stop. If need be, comma, for such limited purpose, comma, the police personnel will be at liberty to break open any padlock or other hindrance if put up to prevent the access of the CSC personnel to the location of the meter board. No rest to cause.
But only one thing, but without prejudice to the rights and contentions in the.
The connection, comma, as and when given, comma, shall be without prejudice to the rights and contentions of the private parties in the to the writ petition in any pending suit and or otherwise.
Grateful.
Upgraded matter, item 9.
But I beg to appeal for the respondent number 2, Lordship.
Yes.
Second appellate authority.
You are for the petition.
Public Service Commission. Respond.
Yes. Please take the microphone.
Participated in the miscellaneous service recruitment, preliminary examination and final examination. Both examination petitioner done well and passed. In the interview, Lordship only get 18 marks out of 100.
Isn't this an education matter?
Lordship, under RTI Act, the petitioner applied for suppliance of the copy of the tabulation sheet as well as the original mark sheet awarded to the petitioner, Lordship, that the copy has not been supplied to the petitioner.
RTI Act, are you entitled? There are modalities fixed by the commission probably. Let me
Lordship,
hear.
I have filed application before the commission that is pending, Lordship. Since 18 June 2022, I have filed for early hearing and disposal of the application before the commission, Lordship. Therefore, the application has been filed, Lordship.
Yes.
Lordship, they have made an application under section 6 of RTI Act that has been replied, Lordship. Though it was little late, but it has been replied, Lordship. Lordship, the application is at page 41A, Lordship.
What is your reply? Refused?
No,
You have
Lordship, it was
answered.
not refused.
They have asked for the interview sheets duly signed by the members of the selection committee. Since considerable time has passed, Lordship, it was 2008 examination, Lordship. They could not provide the
Can you give an
interview
extra
sheet,
copy?
but they have given the answers categorically, Lordship.
Can you give an extra copy to her?
Lordship, it's been given to the petitioner. I don't have.
You have to give a copy to them also. They have to take instruction on this. This is their only grievance. They have come up
Lordship,
because
yes,
their
Lordship.
stand is naturally this has not been
Lordship,
given.
I don't have the extra copy. May I give my copy for their perusal, and in the course of this day, I'll supply the copy of the.
Very well. I'll dispose of the writ petition. Your grievance has been taken care of. If you are aggrieved by this, you can prefer an appeal.
Lordship, that is pending. I have against that.
Not
Lordship.
pending. They
But
have
that is on different score. That is on, did not get any information from the SPI or First Appellate Authority. That is why second appeal is prepared. Well, now the situation has changed. The cause of action has also been changed. But they have replied to. Now, if he is dissatisfied with this reply, he has to file the second appeal on this score only, not on this cause of action. So, earlier second appeal has got infructuous, since they have replied to.
As they have not supplied the information, Lordship, after.
they have supplied now. They've
Lordship,
given-
now they have supplied, Lordship. After expiry of the statutory period, I have already filed application before the commission, Lordship. That is pending. That to be disposed of, Lordship, within a certain time,
Where is
Lordship.
the application? Page 41A.
Yes, Lordship, the application has been filed, Lordship, at page 53 to 59, Lordship. On 16th August 2022, the application has already been filed, Lordship.
Yes, but what will be our consideration? Our consideration, we will direct the PSC to supply him the information only,
If they have satisfied all the queries, Lordship, they have to produce before the commission also, Lordship. As I have already filed application, Lordship, that
Cause of action is different. Cause of action will be different, Lordship.
Lordship, kindly see the
some
prayer of
queries
the
maybe
prayer of
filled
the
up.
writ petition, Lordship.
The prayer A, he is just seeking the information, He has not said that after the statutory period, I will not receive any instruction.
Prayers,
info-
I have prayed for hearing of the application before the commission, Lordship, at prayer C. I am pressing this prayer also, Lordship.
The grievance of the petitioner is that the petitioner has applied for certain documents pertaining to an examination taken by her. First of next para, a copy of the application dated April 27, 2022 is annexed at page 41, capital A. First of next para, learned counsel appearing for the Public Service Commission hands over a copy of a communication dated May 2, 2023, allegedly made to the petitioner, where the relevant information sought by the petitioner has been disclosed. First of next para, heard learned counsel for the parties. First up, the grievance of the petitioner is rather different from the information supplied, to the extent that by way of the query made vide application dated April 27, 2022, annexed at page 41A of the writ petition, the petitioner sought copies of mark sheets of secondary examination, higher secondary examination, etc.
No,
Whereas,
Lordship, I'm sorry, Lordship, to interrupt. Last paragraph of the application, Lordship, they are asking for the supply of the interview sheet, Lordship. That is at page 43, Lordship.
whereas, the information disclosed in the communication handed over in court, although refers to the relevant information which might be contained in the said documents, are not copies of the documents sought by way of the application annexed to the writ petition. First up, although the Public Service Commission has already given sufficient information, if the petitioner is aggrieved by non-furnishing of the documents categorically sought by its application, there is no bar for the petitioner to prefer an appeal. First up, this is the first authority, not the appeal.
First authority, thereafter I have already filed the second appeal lordship.
Next para.
But if the information is given by the SPIO, he has to come through the first appellate authority, then the second appellate authority, that is my client, will entertain his appeal.
After expiry of statutory period, I have filed already the appeal before the appellate authority. Therefore, that to be disposed of.
Since the petitioner submits that the petitioner has already filed a first appeal, you're not sure whether you have filed a first appeal or a second
The
appeal?
first appeal and second appeal, both he has filed.
That is the before the commission.
Very well, I'll keep it
Second
vague, just as your prayer. Since the petitioner submits that the petitioner has already preferred appeals against the alleged inaction of the authorities, comma, the appellate authorities are directed to dispose of the said appeals preferred by the petitioner as expeditiously as possible, comma, preferably within 1 month, Mr. Shah.
But the difficulty, my lord, he has filed the appeal during, my lord, when the commission was not functioning, my lord.
Preferably within 2 months from this date. Pushed up next para, it is made clear that the merits of the application of the petitioner have not been gone into by this court. Thank you.
Grateful.
Pending appeal.
As big as the prayer.
Let's say
Well,
appeal-
he has to prefer.
I've directed that to be disposed of, whichever way.
Well, nothing will help her, my lord. He has to prefer a second appeal challenging this, my lord, that this has been information, I am not satisfied.
let's
But the
say-
earlier second appeal is on the basis that no information
Now,
is
let us
received.
hear the next matter. Don't take advantage of being online so that I cannot thrash you personally.
Grateful, Lord.
WPA such and such is accordingly disposed of without an orders to cost.
Item 10,
Yes.
State respondents. Lord, I'll be very candid, my lord. Your lordship's order, my lord, till now has not been complied with. Previous your lordship kindly, my lord, let it be
What was the order?
to consider their representation.
Why not?
My lord, your lordship kindly passes that time-bound direction, my lord, so that your lordship's order may be complied with, and let it be the order of the court, my lord. Prayer C, my lord. Prayer C.
Please comply with and file a report in court. I'll keep the petition pending this time. Otherwise, your clients will never. Learned counsel for the petitioner submits that despite a direction of this court, comma, the representation of the petitioner was not considered and no letter of appointment was given in favor of the petitioner to perform duty of Mohammedan marriage registrar for the Dattapukur police station area. For sub next para, learned counsel appearing for the state candidly submits that.
Let it be the order of the court, my lord.
No, you have to submit that you did not comply.
Till now, my lord.
Candidly
candidly
submits that due to unforeseen circumstances, the state could not comply with the direction of this court, full stop, to ensure compliance of the previous direction, comma, the respondent authorities are directed to immediately give a hearing to the petitioner and consider the representation given by the petitioner.
My lord, my detention was already considered by him, my lord.
Where is that?
Page 13, my lord. Page 13, last paragraph.
Where was it keeping mum till now when he was submitting?
That no compliance of process. My lord, last paragraph, my lord. After selection, my name was nominated to the ITR by the.
কোনখানটা ছাড়লাম গো? Just কোনখানটা ছাড়লাম দুটো ওয়ার্ড বলেই হয়ে যায়। Petitioner on the score of why the petitioner has not yet been given an appointment as MMR for the aforesaid area.
Respondent number 3 may be directed.
Consideration shall be done by the respondent number 3 as expeditiously as possible, comma, positively within a fortnight from date, upon giving opportunity of hearing to the petitioner. Push up a report with regard to such consideration shall be filed in court on the next returnable date. অরিত্র এভাবে রাখলে কে দেখবে? উপস্থিত রেখে দাও। হ্যাঁ, thank you. Returnable date, that is on August 18, 2023, when the matter shall be listed fairly at the top of the list. Please file that report. After that, if they refuse to give you an appointment, then we'll consider your other document.
Lord, instead of 18th, your lordship kindly fix on 21st.
Yes?
Next matter is the same matter, my lord, so my lord, please.
আচ্ছা ওটা 18 না করে 21st করে দাও।
Extremely grateful.
Returnable on 21st.
Lord, extremely grateful.
Next matter,
Next matter is the same, my lord, my lord.
let it be called on. Yes.
11,
But I am not appearing in this.
Yes. Take the microphone. Please take the microphone. Don't take it away. I mean, use it.
Interning.
Any microphone will sound the same.
My lord.
Similar.
Yes, my lord. My lord was pleased to pass an order, page 15, my lord. Page 15, my lord, on 22nd November 21. On the same date, both the orders were passed, my lord. As on date, my lord, it was not considered. I served the copy upon all the respondents.
The petitioner sought for appointment as MMR for a particular area.
Born police station area, my lord.
Full stop. However, the respondent authorities did not issue such appointment, prompting the petitioner to take out a representation in that regard. Full stop. By an order dated November 22, 2021, passed in WPA 891 of 2019, a direction had been given on the respondent number 3, that is the district registrar, North 24 Parganas, Barashat, to forward the representation of the petitioner to the respondent number 2, that is the Inspector General of Registration and Commissioner of Stamp Revenue, West Bengal, who, in turn was to decide on the same in accordance with law. Full stop. However, it is alleged that such exercise has not been undertaken by the respondent authorities despite the specific direction of court. Full stop. Next para. Since none appears for the respondents despite service, a last opportunity is being given to the state to appear in the matter and contest the same. Full stop. The affidavit of service filed today be kept on record. Full stop. The learned advocate for the petitioner shall serve a further copy on the respondents indicating that the matter shall be listed on August 10, 2023, fairly at the top of the list. Full stop. It is made clear that in the event the state remains unrepresented on the said date, stringent orders may be passed against the respondents. Full stop. Yes. Please try to give a photocopy of the server copy of my order.
Yes.
Serve that copy, but serve it properly and file a proper affidavit.
item 12,
Petitioner?
Petitioner.
Yes.
I will go the state respondents.
Right.
And here, the petitioner constructed a portion of a road, Kanupur to Bahutali in the district of Murshidabad. State has taken a policy decision to pay compensation to all the contractors since the rise in the price of the bitumen. As part
Take half a minute. No difficulty.
Compensation subject to certain compliance of certain.
No, don't take advantage of it.
So, I'm just coming from court now.
If you stop for 5 minutes, does not mean you will submit in the meantime.
Court now from 550, I'm coming on this. But as per the calculation of the state, my lord, I'm entitled to get 94,17,140.
My compensation?
My lord, due to hike in the price of bitumen, my lord. My lord,
you have done the work.
I've done the work.
Where is the document whereby you are entitled to compensation?
My lord. No. My lord, page 32, my lord, it starts.
Yes.
Your
bill? Your bill? Next page.
The compensation they have calculated 94 lakhs, my lord. The calculation it
has not been reimbursed, paid to you.
Not paid. My lord, the identical matter, my lord, in respect of same work, my lord. My lord, the honorable
But the coordinate bench has been pleased to direct the authorities to consider our representation, my lord.
For that, probably
Same work, my
Since-
lord, same road, my lord.
এটা কপি পেস্ট করে দেয় জজের নামটা চেঞ্জ করে
No, my lord, the amount is,
অ্যামাউন্ট ইজ
amount
জেনারেল
is-
পাসে yes Mr. Ghoshal
Have no objection if the matter is being considered and disposed
the
of
the
according to the admissible accounts.
the petitioner submits that the petitioner is entitled to compensation with regard to a work done by the petitioner for construction of a road from Kanupur to Bohutoli. Full sub next para. Such compensation is due to the increase in the prices of bitumen and allied reasons. Full sub next para. Learned Counsel places reliance on the document dated October 12, 2017, annexed at page 29 of the writ petition, which is a communication by the executive engineer, Murshidabad Highway Division 1, PW within bracket roads, bracket closed D, which confers such right on the petitioner. For sub next para, the petitioner gave a representation for disbursal of the concerned amount, which has not yet been paid. For sub next para, Learned Counsel also places reliance on a coordinate bench order dated May 18, 2023, in a similar matter where compensation was directed to be paid. For sub next para, heard Learned Counsel for the parties. Full stop next para. Since the petitioner is entitled to compensation in terms of the communication dated October 12, 2017, there cannot be any reason why the respondent authorities shall not disburse the same. Full stop. In the event the respondent authorities have any objection regarding the quantum of the same, the respondents ought to have intimated the same to the petitioner. Full stop. In any event, where is their calculation?
My lord, their calculation page 32, it starts from page 32, my lord. The relevant portion is, my lord, page 34 and 35, my lord. My lord, compensation for rise in bitumen price, my lord, 21 lakhs.
Next para.
And my lord, the next page is, my lord, the care calculation good receipt sheet. That is appearing by 76.
The
Chart side by side, my lord. If your lordship kindly comes to page 17 of the writ application, my lord. The order for payment of compensation, my lord,
Yes.
point 2. The proposed compensation shall be considered for works or portion of works executed on or after 1/11/2005. And my lord, if your lordship kindly comes to page 14 of the writ application, my lord, the work has been executed much earlier. That is on 26/9/2005, my lord. So, my lord, let the
Only two has to be considered by you.
my lord. So, my lord,
If two is satisfied, then the quantum is.
so,
you
my
have to
lord, let the representation be considered. and
Not
dis-
representation consider. You have to pay only on consideration of two, whether two is satisfied. Otherwise, why not?
Subject to
Subject to two only.
subject to two.
কোন জায়গা কি বললাম? Had any objection? Next para. The petitioner has also annexed a chart of the compensation as per the rates of the respondent authority to the writ petition. For sub next para. Although the state respondent has raised an objection as to whether the petitioner is entitled to the proposed compensation, having executed the works on or after November 1, 2005, as per the order dated June 20, 2007, annexed at page 17 of the writ petition, the same cannot be an impediment simpliciter in payment of the amount, subject to the petitioner complying with such clause. Full sub next para. Accordingly, WPA 4176 of 2023 is disposed of by directing which respondent should pay.
But the respondent number 5, my lord, the chief engineer headquarter.
Directing respondent number 5, the chief engineer, headquarter, public works within bracket roads, to disburse the amount due to the petitioner for work done by the petitioner
Not admissible dues.
if
Milord.
any comma, no, I won't put in any further. If done in terms of clause 2 of the order dated June 2007, annexed to page 17 of the present writ petition, full stop, subject to compliance of such clause, comma, the disbursal shall be made to the petitioner as expeditiously as possible, comma, positively within a month from date. Full stop. Next para. In the event the respondent number 5 is of the opinion that the petitioner does not satisfy the clause as referred to above, comma, a communication in that regard shall be made to the petitioner by the respondent number 5 within a week from date, and the hearing will be given to the petitioner on such count by the respondent number 5 prior to disbursal of the amount. First, sir, it is made clear that in the event the respondent number 5 is of the decision that the petitioner does not satisfy clause 2 of the relevant order as referred to above, comma, the
Milord, the question is not only about clause 2, Milord. Milord, there are certain other, because the fact is that, Milord, yesterday in the evening I have received the brief. Milord, since the petitioner has told me that it will be order of consideration, so I haven't sought for instructions also, Milord. So this is the point. So, Milord, point 2 or any such other
clause number
considerations.
2 and or any other issue of admissibility, comma,
My lord.
Such decision shall be communicated to the petitioner by the respondent number 5 within a week thereafter. Full stop. The petitioner, comma, in the event of such refusal, comma, shall be at liberty to challenge the said refusal by way of a fresh writ petition. The question of clause 2 as well as admissibility question will be considered by them.
Grateful.
But as per their calculation, my lord, I'm entitled to get 94
Their
lakhs.
calculation, but whether you are entitled. But they are on the entitlement.
No,
unit.
my lord, that
Suppose you did not do the work.
no, my lord, they have
Or did not do it
the
after.
superintendent engineer has
To you.
calculated. Superintendent engineer has calculated in this.
Any admissibility for some
Fine.
other reason.
Grateful.
I've given you liberty to challenge that.
Fine.
Grateful.
Grateful.
Because at the last moment I saw that the coordinate bin direction was also to consider.
My lord.
Mr. Ghosh is right on that.
Yes, my lord. I also, my lord, prayed for my lord only. As you know. Grateful.
13,
May appear for CS Limited.
May I please your lordship? Well, I am praying for a new connection in my name, but such connection could not be obtained due to stiff resistance by the private respondent number 4.
What is the difference between helpless and hapless?
Helpless, my lord. I have no
They have
help
stated
from
in
inside,
paragraph
my lord.
15.
Yes, my lord. I am.
Anyway, so you are not getting the connection due to their obstruction.
It's obstruction private respondent number
Who are
4, my
they?
lord. They are the landowners, landlord of my lord.
You are?
I am a licensee under them. I have a license under their
Eviction
mother
suit
also.
pending. Eviction suit pending.
Eviction suit is pending, my lord, and a criminal case is also pending because they're trying to oust me. And in that course, they have assaulted me and my young
So
daughter.
they filed an eviction suit. You filed the criminal.
Yes, my lord.
Let us hear the distribution license
well,
first. Then I'll come to you. Yes.
We had been to the premises for inspection, but could not carry it out due to
Their obstruction.
their objection.
Yes.
My lord,
Need police help.
petitioner is not a tenant, my lord.
No, he's a licensee.
My lord, he is forcefully occupied in my veranda, my lord. That is why, my lord, the several in the local village. And it's.
It's not a village.
Sribhumi is not village.
It's not a village, my lord.
What delay?
Locality, my lord.
It's a municipal area.
The mass petition is there, my lord.
Lake
Several
Town.
mass petition. Kindly see, my lord.
I'll give the mass liberty to approach the district magistrate. If they have an objection, but they'll get the connection. What is the ground of objection
My lord,
of the
kindly see.
mass?
My lord, is দীপালি হাইট কিছু অসামাজিক আচার আচরণের দ্বারা পাড়ার পরিবেশ নষ্ট করে দিচ্ছে।
Oh, that is not a ground for refusal of electricity, sir. Get him ousted on the on other violation of law. Learned counsel for the. I'll keep this on record.
I'll
I'll
also
record
make
this.
the local police station a party. If necessary, my lord, order may kindly be given, my lord.
Learned counsel for the petitioner contends that the petitioner is not getting a new electricity connection due to the obstruction raised by the landowner, that is respondent number 4 herein. Full
But
stop,
this is
next
a
para.
commercial loop meter, not domestic.
Commercial.
Commercial meter. That's my instruction.
Forcefully occupying in my veranda, my lord.
Full stop, next para. Learned counsel for the CSC Limited submits that the CSC Limited went for inspection to give such commercial connection to the petitioner, but were obstructed by the respondent number 4 and his men and agents. Full stop, next para. Learned counsel for the respondent number 4 contends that the petitioner is in forceful occupation of a portion of the veranda of the petitioner and is not a lawful occupant. Full stop, that apart, comma, learned counsel for the private respondent hands over a copy of a purported objection signed allegedly by people of the neighborhood, comma, written to the president stroke secretary of the local colony committee, comma, making certain allegations against the petitioner. Full stop, next para. The tenor of the allegations disclosed in the purported complaint pertain to certain alleged antisocial activities of the petitioner. Full stop. However, comma, the petitioner has also preferred a criminal complaint, lodged a criminal complaint against the private respondent. Full stop. The private respondent herein has filed an eviction suit against the petitioner as well. Full stop. Hence, comma, there are allegations and counter allegations between the parties. Full stop. However, comma, the mere complaint, comma, purportedly having been written by certain people of the neighborhood to the local colony committee cannot be a deterrent, comma, by itself, comma, to the petitioner exercising the petitioner's right to get electricity connection at the premises. Full stop, next para. Accordingly, WPA 13232 of 2023 is allowed, comma, directing the CSC Limited to, you have held an inspection? No,
we could not.
to hold an inspection for the purpose of assessing the feasibility of giving electricity connection to the petitioner at the premises in question. Full stop, if feasible, if otherwise feasible, comma, the CSC Limited shall give such connection to the petitioner in accordance with law, comma, subject to compliance of all formalities by the petitioner. Full stop. Such inspection shall be held by the CSC Limited within a week from date. Full stop. In the event the feasibility goes in favor of the feasibility issue goes in favor of the petitioner, comma, the CSC Limited shall at the earliest thereafter raise an estimate, raise a quotation, comma, upon which the petitioner shall comply with necessary formalities for getting the connection. Full stop. Upon the petitioner complying with such formalities, comma, the CSC Limited shall give the electricity connection to the petitioner within a week from such compliance. Full stop. Either at the time of holding the first inspection or at the time of giving electricity connection, comma, if the CSC personnel are obstructed by respondent number 4 or his men and agents in giving such connection, comma, it will be open to the CSC Limited personnel to approach respondent number 3, comma, the officer in charge of the Lake Town Police Station, who will act on a server copy of this order and give adequate assistance to the CSC personnel for such purpose on both occasions, comma, at the cost of the petitioner. Full stop. If any padlock or other hindrance is put up by the respondent number 4 and or his men and agents to prevent the CSC personnel from having access to the location of the proposed meter, comma, it will be open to the police personnel to break open or remove such padlock for the limited purpose of giving access to the CSC personnel. Full stop. Next para. However, comma, it is made clear that nothing in this order and or the electricity connection, if given to the petitioner, comma, shall create any special right or equity in favor of the petitioner, and such connection shall be without prejudice to the rights and contentions of the petitioner and the private respondents in all pending proceedings. Full stop. No orders to cause urgent settlements. Thank you.
Grateful, my lord. People of blood, my lord.
Thanks.
Number
14.
But I am for the fix.
Yes.
Well, this is also loan agreement. My lord, I took some loan. My lord, admittedly 15,000 was sanctioned, but I was actually given 12,000. Sorry, 12 lakhs. out of which I have already paid about 5 lakhs.
50 lakh was sanctioned.
15, 1/5.
15 lakh,
Yes.
12 lakh.
But my lord, actually I was given, page 21, I have disclosed everything.
12.
I was given only 12 lakhs. Already I have paid, my lord, about 5 lakhs. Rest of the amount I am ready and willing to pay.
Addressee left.
But that is the problem. They are not receiving anything and I'm asking to vacate. My lord,
So without service of copy, you cannot move the writ petition.
then, my lord,
cannot
I
take up.
may.
Serve again, please.
Then in the meantime, they are trying to take possession of the, give some limited protection in I will solve and otherwise, my lord, I will be ousted. Poor, my lord, he is a poor hawker.
This is under this SABYASACHI Act.
Surface check that I know, but
You have a remedy.
no, I shall pay the amount. I am ready to pay the amount. I said that I have already paid 5 lakhs.
I
Just
cannot
take
do that.
rest
I
of the
cannot do
amount.
that. We cannot interfere in SABYASACHI matters. Unless there is something palpable, there is nothing
My
palpable.
lord, I am ready. Just, my lord, I
I'll
am.
give you liberty to approach the
Well,
with the same prayer. No.
My lord, what I am praying, my lord, I have already paid. I am ready and willing to pay the rest of the amount. They are,
Approach the tribunal with that relief.
but it is in Siliguri. My lord, it is a
Siliguri is nothing.
My lord, I am ready to pay.
No, no.
No, I will pay the rest of the amount.
You have several known advocates in Siliguri. Please call any of them.
No.
Assure them that you will pay them
No,
and ask them
no,
to
I
do.
am saying, what I am ready.
Writ court
ready
in
with
this fashion without notice, no.
Then I am serving a notice, my lord. I am ready and willing
But
to
then
pay.
the same order will be passed in their presence and they'll be knowing about it.
My lord, 9 lakhs I would.
Now I pass this order, I give you the liberty, they won't be knowing probably.
My lord, but-
Unless they're watching TV, I mean, not TV, the screen all the time.
my lord, what is my submission?
Cannot
They
interfere.
are asking 19% interest. I am saying you calculate on the basis of.
You agreed to whatever was it.
But in the agreement, my lord, there is no signature of all the parties.
That points you can take, you have to take before the tribunal. Writ court cannot decide those issues.
My lord, to cut
No.
short, I am ready and willing to pay them.
Cutting shorter. Learned counsel for the
You will
petitioner
have to go to
submits that
Siliguri.
the petitioner has certain grievances with the alleged amount of loan payable by the petitioner. However, the respondent authorities are trying to take possession of the property of the petitioner, for which the present writ petition has been filed. A perusal of the affidavit of service filed today shows that the same has returned with an endorsement which apparently indicates that the addressee has left. Next para.
But his agents are disturbing. They are going to the house.
As such, proper service has not yet been effected on the respondents. Next para. In any event, the reliefs sought by the petitioner in the present writ petition are required to be canvassed under the SABYASACHI Act 2002 before the tribunal before the debts recovery tribunal having jurisdiction. Next para. Hence, it is nothing is disclosed of an exceptional nature to instigate the court to invoke its writ jurisdiction and interfere in such a SABYASACHI proceeding, particularly since the petitioner has an equally efficacious, if not more, if not more efficacious remedy before the tribunal, where the petitioner can also urge questions of fact apart from law. Hence, WPA 13304 of 2023 is disposed of with liberty to the petitioner to approach the concerned tribunal with the reliefs as claimed herein. No address
But
to
in the
person.
meantime, some development has taken place. The district magistrate has issued an order that by 31st, he will take possession. So, my lord, kindly give some protection. I will go there.
By 31st August, we are on 2nd August.
Well, he will go
Send
to-
somebody there by day after tomorrow, have an order from the tribunal.
The person, my lord, is
No.
not, as your lordship, please. Because as he is ready and willing to pay, they are asking for
So,
20,
everybody becomes poor after you
No,
take
no,
a
no.
loan and
they are
don't
asking
repay.
for 20
Now
lakhs.
I'm learning that from the matter.
We are ready to
Previously,
pay.
I had some sympathies. I still have my sympathies for a person who is not being able to repay the loan. But at the time of taking the loan, you should have considered.
19
Otherwise, the banking system will fail.
Yes, yes. 19,
We have to see both sides also.
2019, he took the loan. 2021 in trouble. Now he is ready to pay. Well, he was asking me.
I have understood, but I can't.
He is
I
ready.
passed my order, Mr.
He is ready with
Call on the next one.
11 lakhs.
Item 15.
As your lordship, please.
Lord, item 15, I beg to appear on behalf of the respondent 1 to 4.
Second appellate
My
authority,
video is
Mr.
perhaps,
Shah.
Lord.
Videos and
Sir. Oh, yes. Mr. Shah is
Now
there.
it's all right.
Yes. What is the matter?
Your Lordship, here the petitioner, Your Lordship, had filed an RTI application under section 6, Your Lordship,
Hmm.
on 23rd of December, 2022. It was refused by the authority, Your Lordship.
First
Then-
appeal?
First appeal, then we have filed to the appellate authority, Your Lordship.
First appeal,
on-
what happened?
Again refused, Your Lordship. And
Is
then
there
we
second
filed, yes, Your Lordship.
This for
No second appeal. No second appeal is preferred.
For the second appeal, Your Lordship, we filed a complaint under section 8,
Yes.
Your Lordship. And that too has been refused.
No, not refused, Lordships. No second appeal is preferred. A section 18 Lord complaint has been preferred. Now the difficulty is in under section 18, the commission is supposed to make an inquiry why the information has not been given. But commission is not empowered under section 18 to direct the SPI or the first appellate authority to provide information.
Have you got a copy of the act?
Not at the moment, Your Lordship.
Kindly see the section 18, Lordship.
I think ছিল এখানে কোথাও।
The section 18 complaint is completely different with the second appeal under section 19.3.
Mr. Shah, have you got a copy of the act?
Yes, Lordship.
Can you read out for me, please?
Yes,
Section-
yes.
Just read it out once. Section
The
18.
section 18 power and functions of commission.
Yes.
Subject to the provisions of this act, it shall be the duty of the Central Information Commission or State Information Commission, as the case may be. Here it is State Information Commission, to receive and inquire into a complaint from any person. Now there are A, B, C, D, under which circumstances the complaint can be received. I'm reading it out loud. A, who has been unable to submit a request to a Central Public Information Commission or the State Information Commission, as the case may be, either by reason that no such officer has been appointed under this act. But it is not applicable here. Now B is who has been refused access to any information requested under this act. But this is perhaps the pertinent here. But there are other criteria are also there. C
Yes,
is there, who has not been given a response to a request for information or access to information within time specified. This is also applicable here. D is who has been required to pay an amount of fee which is or she consider unreasonable. That is not applicable here. E, who believes that he or she has been given incomplete, misleading or false information. That is also not applicable here. F, in respect of any other matter relating to requesting or obtaining access to records under this act. But perhaps this is also not relevant here. Now B and C.
No, you have to prepare a second appeal.
Yes, but
The scope of invocation of 18 by them. What is the scope of 18? You have sought for information that has been refused.
Yes.
You went up with
Without
first appeal
without any
refused.
information, Your Lordship. Yes, Your Lordship.
without any information that was refused on some ground or the other.
Yes, but we were not informed, Your Lordship, the ground under which they have refused.
So what is the ground of your first appeal then?
That the statutory limit has been failed by.
Oh, your ground in the first appeal
Yes,
was they
Your
have not given the information,
no
not
information,
responded.
No, and no grounds also mentioned.
So
Your Lordship.
where is the order of the first appellate authority? Show me that.
no order.
No order, Your Lordship. If you, Your Lordship, kindly check annexure, page number 14, Your Lordship. The envelope, they received it, they acknowledged it, and they have just written refused. But no grounds has been mentioned for the refusal.
Page 14.
Yes, Your Lordship.
Page 14 is the envelope. Now, where is the refusal? I don't see anything.
Your Lordship, if
Page 14 is this.
yes, Your Lordship, in there, Your Lordship, if you can, Your Lordship, kindly check. It says refused, signature, and the date is given.
This is refusal of your envelope.
Yes, Your Lordship. They did not. They have acknowledged, but they did not even tell us the grounds on which they are refusing.
You are for the appellate authority, Mr. Shah.
The second appellate authority, Milad, the West Bengal Information Commission.
First appellate authority is a party here.
Yes, Your Lordship.
Yes, I believe first appellate authority is the DPSC, District Primary School Council. He has made the first appeal before him, Lordship.
So your first appeal is still pending now.
Yes, Your Lordship, but they have not stated us any of the grounds by which, like, they have refused the application.
Have they said that they have decided the first appeal at all?
Your Lordship, kindly come to annexure 18, Your Lordship. Again, they have said refused and returned to sender.
You are not prepared in your matter, ma'am. Can't you tell me these are refusals of your postal services?
Exactly.
Refusal of the order. You have preferred a first appeal. There you have alleged that your information is not given.
That's what your lordship, they're not.
What is the
providing
outcome?
us-
I am asking you whether the
they're not
first appeal has been decided or not.
not providing any information, your lordship. That's what. They're not
Have
providing.
you applied for information from them whether the appeal is pending or not? I'm not satisfied on that.
All right, your lordship will just get the instructions.
The writ petition has been filed against alleged inaction by the respondent authorities on a complaint lodged by the petitioner under Section 18 of the Right to Information Act 2005. Full stop. It transpires that the petitioner applied for information which was not given to the petitioner, comma, being aggrieved by which the petitioner preferred a first appeal. Full stop. The communications made by the petitioner to the first appellate authority allegedly were returned with the endorsement within double inverted refused on the envelopes. Full stop. Next para. It is submitted that, comma, as such, comma, the petitioner is not aware of the first appeal having been disposed of either way. Full stop. Next para. A perusal of the reliefs in the writ petition indicate that the petitioner has sought for a direction on the respondents, comma, more specifically respondent number 6, to provide the requisite information sought by the petitioner. Full stop. Next para. However, comma, unless and until the first appeal, which has already been preferred by the petitioner, is decided either way, comma, it would be premature to pass such a direction. Full stop. Next para. Insofar as Section 18 is concerned, comma, the present case does not fall within the ambit of the same, comma, since the grievance of the petitioner is not within the contemplation of Section 18, comma, which is an independent provision, comma, but a non-consideration of the first appeal preferred by the petitioner. Full stop. Next para. Accordingly, WPA 13320 of 2023 is disposed of. Which is the first appellate authority? Which respondent?
The first appellate authority is the SPIO of Ghargram Mahadev State.
Which
Plan-
respondent?
Respondent number 6, your lordship.
No. He cannot be the first appellate authority. He is the SPIO. SPI is the first authority.
The first authority.
Then your
That's
lordship.
respondent number 5, lordship.
Five.
By
Respondent
directing
five.
the respondent number 5, that is the district sub-inspector of schools, come appellate authority, comma, Norghat circle, to furnish a report as to the fate of the appeal and or the current stage of such appeal, comma, which has been preferred by the petitioner against the non-furnishing of information by respondent number 6. Full stop. Such report shall be filed on the next returnable date with an advance copy to the learned advocate for the petitioner. Full stop. The matter shall next be listed on August 16, 2023, fairly at the top of the list. Full stop. The petitioner shall serve a notice on the respondent number 5 within a week from date, comma, communicating to the respondent number 5 the gist of this order, comma, along with a server copy of this order, comma, if possible. Full stop. A receipt stroke affidavit of service in that regard shall be filed on the next returnable date. Full stop. Please serve as early as possible a copy of the server copy of this order on respondent number 5. I have asked for a report. Let us proceed on that premise.
Oblige, your
Let us see what stand is taken by them, Mr. Shah, then we'll proceed.
Oblige, your
Grateful, lordship. Grateful.
16.
Well, I am for the petitioner.
Yes, please. What is the matter?
Lord, I'm appealing for the WPS.
I need to appear on
A
the
new
private.
connection of the petitioner premises, my lord. The petitioner is the owner of the property, my lord, by purchase, my lord. And the petitioner's name has been also recorded in the RS record of right and also under LR record of rights. He make the, my lord, application for constructing his house from to the, my lord, Panchayat authority. Panchayat authority, my lord, approved and sanctioned the
to make the construction, my lord. Accordingly, the petitioner constructing his house, my lord. Thereafter, my lord, petitioner application made to the electricity authority at page, my lord, 55. This is the application made by the petitioner, my lord. And that petition, after the after inspection and surveyor, the petitioners deposited, they sent the bill, my lord, and petitioner deposited the estimate amount, my lord. Page 69. Page 55, my lord, is the, my lord, application for.
Then what happened after that?
My lord, after that, my lord, what happened, my lord? The private respondent, my lord, always, my lord, obstructing at the time of install the petitioner's
You took a
premises.
144 order also.
Also 144 also, my lord,
That order is subsisting now.
that, my lord, may be or may not be, my lord, I could not, cannot, my lord. My lord,
Anyway, so who is the private respondent according to you?
the private respondents, my lord, they are neighbors, my lord. They are obstructing me at the time I install the petitioner's premises. And also, my lord, I am placing, my lord, my sale purchase deed, my lord.
No, sale deed I've seen, yes.
My lord, there, my lord, has been given
Electricity.
the petitioner will take electricity and also, my lord, pipeline.
Let's hear the electricity company first, then I'll come to the private respondent.
My
Yes.
lord, we have went there, my lord, for the giving electric connection. to
Obstructed
them.
by private
Obstructed by the private respondent, my lord. We have no objection, my lord, if
Very well.
we have tried at our level best, my lord. Twice we went there, my lord. But
Very
failed, my lord.
Yes.
Kindly take table to look at page 72 once, my lord.
Take the microphone. Page 72.
my lord.
Yes. 72.
The fact of the case is that,
My-
the fact of the case is that, my lord, he is trying to take the electricity over my plot. He is trying to use the wire over my plot. That is why the survey was done, page 72, kindly see. That there is no clear access to your premises.
That is our letter.
Yes, that is I am showing. And my lord, 144.2, there is the report was called for, but I have not got the report from the BHATTACHARYA. Although this is.
140.
But how can you obstruct them from getting electricity connection?
No, I am not obstructing, my lord. I am just submitting before your lordship that they should not take the electricity over by using my land or over.
Everybody says that how can they get electricity? Everybody will be saying that. People have to get electricity over some property.
My lord,
What is that? Your land is cultivable land.
Cultivable land, and my lord, kindly see.
They'll take it sufficiently above.
Common passage.
No, common passage.
No, my lord, common passage, my lord. My lord,
No, let me hear him first.
one
Yes.
Kindly see, your letter is say, sir. Your letter is said.
Yes, we have obstructed.
We
For the-
local data of the.
No, letter is
clear
something
access.
else. Letter is something else. Letter is they say local people are obstructing. That's why you are requested so proper access
No, my
because
lord,
of your
72
obstruction.
Kindly see 72, my lord. There
I'm
is
at
no
72.
clear access to your premises for new service connection. Kindly see page 72, my lord. And my lord, I have also made a representation
To whom?
to the
WBC.
station manager.
Acha.
WBC.
Yes, then I'll have to refer it to the magistrate. There's a dispute regarding the access.
Yes.
my lord, kindly page, my lord, page, my lord.
Reach code cannot decide
27,
this.
my lord, page 27, kindly,
Page 27.
page 27.
No, your deed cannot affect the rights of others.
My lord,
You have purchased the property, your vendor might have given you the right.
Yes, my lord.
I may give you right to take electricity connection. No doubt on that. Your title on that property is not in doubt.
No,
What is in doubt is whether you have a right to disturb somebody else's possession and take electricity over that. Now, these problems have to be under works of license rules, have to be referred to the magistrate.
well, 43, my lord, page 27 page.
When is the date?
Last, well, page 27.
What are you showing at 27?
Yes.
I told you just now, I prefer to that only.
Electricity.
Ashun একটা
So-
order নিন. Learned counsel for the petitioner submits that the petitioner has purchased a property and has got his name recorded in the records of rights duly. Thereafter, the petitioner started construction of a property of a building thereon and sought for a new electricity connection for such purpose. Full stop. Learned counsel for the petitioner places reliance on the purchase deed of the petitioner to indicate that the petitioner has also been conferred the right to get electricity connection over a passage. Full stop. Next para. Learned counsel for the distribution licensee submits that the said licensee went twice to the property but could not give electricity connection due to resistance of the local people. Full stop. It is contended that if necessary, electricity connection can be given to the petitioner over a common passage. Full stop. Next para. Learned counsel for the private respondent submits that the private respondents are opposing the prayer of the petitioner, since the electricity connection, if given, would have to be taken over the property of the petitioner, thereby causing immense hardship to the property of the private respondent. Private respondents, thereby causing immense hardship to the latter. Full stop. Next para. The nature of dispute raised is over the property through which, over which the connection is to be given to the petitioner. Full stop. There is no dispute regarding the petitioner's ownership or occupation of his purchased property in the present writ petition. Full stop. The limited scope of dispute is whether the petitioner is entitled to take electricity connection over the property in question, and as to whether such route for taking connection is a common passage or the private property of the private respondents. Full stop. The writ court is not equipped properly to comprehensively decide such issue by taking evidence. Full stop. Under the Works of Licenses Rules, 2006, it is the concerned district magistrate who is to decide such issues. Full stop. Accordingly, WPA 16380 of 2023 is disposed of by granting liberty to the petitioner to approach the concerned district magistrate having territorial jurisdiction over the area concerned with the dispute as raised in the present writ petition. Full stop. If so approached by way of a proper application, the magistrate shall decide such issue in accordance with law upon giving opportunity of hearing to the petitioner, the private respondents, as well as the WBACDCL and all other interested parties as expeditiously as possible, preferably within 6 weeks from the date of such application being made by the petitioner. Full stop. This court has not gone into the merits of the rival contentions of the parties, and the magistrate will be at liberty to decide the issues independently and in accordance with law. No other
If the magistrate decide in favor of the petitioner, the electricity connection shall be given within certain period also.
একটা line add করে দিন. If the district magistrate holds in favor of the petitioner, the WBACDCL shall give the electricity connection to the petitioner expeditiously thereafter, preferably within a fortnight from the date of decision of the magistrate, subject to compliance of all formalities by the petitioner.
Within fortnight.
Fortnight from that date.
And the date of the order, my lord?
If they win.
Order of the magistrate.
New motion, item 17.
My lord, I am appearing on behalf of the
Where is the brief? Move the matter. No time.
Instructed by my senior. Senior has not come yet.
So what? You have come. Take my file and move the matter. Okay, dao to eta. How long are you practicing?
6 months.
Oh, sufficient. The.
Lordship,
Tell me your prayer. Read out the prayers. Yes, read out the prayers.
A writ in the nature of mandamus calling upon the respondent authorities, each of them and their men and agents, to give compensation in touch with the encroachment about the landed property for construction of National Highway 32.
What about service you don't know? Copy service on the other side?
Affidavit of service not completed yet. So
Very well. Affidavit of service is not yet complete. as submitted by learned counsel for the petitioner. Full stop. Accordingly, let the matter stand adjourned and shall next be listed in the monthly list of September 2023. Next monthly list. Next means September monthly list. Next matter.
18,
18, Your Lordship, I'm appearing virtually. My Lord, at the very onset, I must apologize for appearing virtually instead of being in court. My Lord, before I begin, my learned junior, my Lord, is present in court, Ms. Shaha. She'll hand up the affidavit of service, my Lord. My instruction is that the service has been completed.
Good service on all?
Yes.
You're not sure. Yes, what about the matter?
Lordship, what has happened in this case, my Lord, is that my writ petition is against an order passed by the identification committee, the willful defaulter identification committee. Before I take your Lordship to the facts, I'll clarify to my Lord.
You are appealing for the respondent. Respondent is not represented.
Bank of Baroda is the respondent, my Lord.
The absence of the respondent, can I pass an order? Are you challenging the willful defaulter identification committee?
I am challenging the order of the identification committee. I must disclose to your Lordship, my Lord, that under the master circular, it's a two-tier system. There is a review committee.
Review committee, yes.
No, I cannot. I'll tell you, Your Lordship, why. I have bypassed the review committee, directly filed a writ application. So naturally, there is a question of an alternative remedy also. The reason I have not gone before the review committee, my Lord, is because this order has been passed, number one, without giving me a show cause opportunity. The order records that there is a show cause notice that has been served upon me, whereas my stand, my Lord, is that the show cause notice has never been served upon me. That is the first stand. The second, my Lord, is this order by itself is also non-est because the constitution of this committee is an absolute violation, my Lord, of the master circular. I'll take your Lordship to the master circular, which states, my Lord, in regulation number 3, which states that it has to be a 3-member committee. The 3-member committee has to be presided over by the executive director or somebody of an equivalent rank, along with 2 other members who's.
Please give another notice to the bank and come back. I don't want to take up the matter in that.
I would have done that, my Lord. The difficulty, my Lord, I'm suffering is there's an emergency. Given the situation that there is an order which has already been passed against me, they will publish it. In that situation, would it be a Lordship's pleasure to
Then go before the
kindly
review committee. Go before the review committee. It has not yet attained finality. Go before the review committee.
Lordship, I cannot, because the order which is passed, I cannot lose a forum. Lordship understands that I cannot have a fair appeal to an unfair trial. The order passed, my Lord, is non-est because it's absolutely nugatory, because they have not constituted the committee properly. The order has been passed by one individual. It has to be 3 individuals. I'll take your Lordship to
a copy of that order?
Yes, the order is annexed. My Lord. That's the only annexure in my writ application.
Right.
Lordship kindly looks at the letter dated June 12, 2023. That's the first annexure, my Lord, right after the affidavit page. The next page, my Lord, is the order. Before I take your Lordship to the aspect of the show cause, Lordship will come at the last page of the order once, my Lord, where the signature, my Lord, appears, and the date 2nd of June 2023. As your Lordship found it, this should be page number 21, my Lord, 21 of the writ application.
$21 is a postal endorsement.
So then the previous, the copy I have is unpaginated, my Lord. The previous page, my Lord. The
Probably
page,
the pages have been reversed. Is it dated 2nd of June?
Yes, my Lord. 2nd of June 2023 is the date of the order.
Right.
This matter I'm appearing on behalf of the respondent, ma'am.
Very good. Yes.
Lordship
They
looks at the
2 points basically. They have taken 2 points basically. One is that 3-member committee has not passed the order. 1 member has passed. 1. Secondly, you have not given a show cause. What is your answer to these?
Lordship, I have to take instruction from the bank counsel. Lordship paying for some time, so I can come back with the proper
Take instructions, but don't publish in the meantime.
Sure, Lordship.
When do you want to come back?
Day after tomorrow, Lordship.
Primarily, 2 points have been taken for challenging the willful defaulter identification by the first committee of the petitioner. Full stop. The first is that only a single member had passed the order of the identification committee, whereas the concerned RBI circular stipulates that there has to be at least a 3-member committee. Full stop. Secondly, the petitioner alleges that no prior show cause notice was issued to the petitioner. Full stop, next para. Apart from the other grounds, comma, learned counsel insists that the above 2 points are sufficient for interference by the writ court, comma, even without the petitioner exploring the remedy before a review committee, comma, which might be illusory at the outset. Full stop, next para. Learned counsel for the bank seeks some time to take appropriate instructions on the said issues. Full stop. On the prayer of the bank, comma, the matter is adjourned till tomorrow.
Day after tomorrow, Lordship.
Adjourned till August 4, 2023, when it will be listed fairly at the top of the list. Full stop. The respondents shall not upload or publish the petitioner's identification as a willful defaulter till August 11, 2023, or until further order, comma, in terms of the impugned order of the first committee, comma, first committee. Full stop. Thank you.
I'm deeply obliged.
Yes, Your Lordship.
Till August 11 or until further order করে দেবেন, whichever is that. Thank you.
Grateful.
19,
I am appearing on behalf of the petitioner, my lord. Our affidavit of service has not yet been completed.
Affidavit of service not prepared, not yet prepared. Full stop.
Kindly take it on.
Let the matter stand adjourned
Tomorrow, my lord, kindly.
till
Service completed or affidavit of service?
till next monthly list. Next month,
Kindly.
August.
I'm good. to go.
Till next monthly list. But till next week করে দাও. Till next week. ওটা
Receive the report, my lord, may I submit that?
file on the next date.
Well, I am ready with the matter, but affidavit of service has not.
Next week is monthly
I'm
list.
good.
item 20,
I am for CS.
You're for the
I'm
petition.
referring for the petition, my lord.
Yes.
My lord, to be very candid, my lord, this petition is
Not maintainable.
no, my lord, not mental. My lord, there's a mercy petition, my lord. If my lord kindly
What
take-
about service on Delta and all?
my lord, affidavit of service, my lord, it has been hand served, my lord,
Very
hand delivered. May that be kept.
Yes. Dr. Shara, have some mercy.
Mercy, the question that we have made enough mercy on that issue.
Let us hear him.
Now-
Yes. Let us hear Ullar.
Ma'am.
Yes. What have you challenged here?
My lord, it is not a challenge, my lord. We are not challenging the quantum that they have claimed. My lord, the only prayer, my lord, is 8 equal installments for payment of the electricity dues, which is amounting to, my lord, around my lord, 1 crore 61 lakhs and odd, my lord. My lord, we have prayed that if my lord kindly takes page 9, paragraph 20, my lord. My lord, my lord, the petitioner is a jute mill, my lord, having more than 3,000 workers, my lord.
Yes. What do you say, Dr. Shara? Jute mill.
Yes.
Already we are losing jute mills.
It's not the case. They are doing a lucrative business right now. What happened, your lordship, kindly see that the petitioner before your lordship is not a registered consumer. The registered consumer is the private respondent. And they have taken sublease from that registered consumer. Now, what happened if your lordship kindly come that we have given them ample opportunity. Initially, there was a default since February 2022 onwards.
This is regarding the pro forma respondent.
This is a profile
Yes,
because
madam.
it's
Yes.
registered by the,
But
this is the
Yes.
beneficiary.
They're not in
There
there.
was no, they were there. I will tell you what's it. They were there in February 2022 onwards. There was a default. There was a huge amount of due, and there was initially contractual load was 60 kilowatt. And thereafter, they have cleared this petitioner cleared the dues in February 2023.
88 lakhs.
And thereafter, they have enhanced the load to 750 kilowatts.
With permission.
With permission. They have done that because it is now on record to in 750 kilowatt. Now, lordship will find that again there was a default since March 2023 onwards. Till June 2023, the payment has not been made. We have given series of notice, and the last notice, if your lordship kindly come, to page 222, page 22, Lordship. That is on 19th June 2023. Lordship, this is the notice where we have specified that there is an outstanding due of March as well as April. If in the bottom, your Lordship, see that that is the total outstanding dues. We have given them an ample opportunity. We have then on 12th of the notice has been given on 19th of June 2023. They didn't pay any heed to this notice. On 12th of July 2023, we have disconnected that line. Now they have come up that they are willing to pay that. So this is an admitted fact. Again on, if your Lordship kindly come to page 39. Page 39. Lordship got it?
Yes.
That is the notice dated 17 July 2023. In their response to their letter, we have specified what are the outstanding dues, and not only that, it is also required for replenishment of the security deposit also, Lordship. And Lordship, kindly come to page 40. Contractual load was 750 kilowatt, which they have enhanced. Now, when we have found that it has come to
Lordship, we are not
130 to
disputing any
1.6 kilowatt.
Well, we are not
But this
disputing
is the
any
way.
If they're not agreeable, I don't have the mercy jurisdiction.
But the
How
law
can I
says
do
they
it?
have to pay the entire amount, Lordship.
My lord, some installments. my lord,
Miss, Dr. Shahara, you will be only getting the money. I mean, if these people are outside, the employees
No,
are outside.
I am not on that.
I
Lordship.
understand you have given several opportunities. They have once repaid. Their antecedents are not so well.
I just leave up to your Lordship. Kindly consider the gamut of the situations. But they are the habitual defaulter. Again, they will pay. Again, they will be
my
habitual.
lord, there was a lockout, my lord, in the factory for more than 1.5 years, my lord. My lord, the petitioner was not getting any PCOS from the Jute Commissioner, my lord. Now, my lord, we have approached the Honorable High Court, my lord. We have obtained an order in our favor for issuance of PCSOs. My lord, we have received the orders, and my lord, we are unable to work, my lord. My lord,
Till now, you are unable to work.
yes, my lord.
At
Then you
present,
won't be able to pay.
yes.
How can you pay?
My lord, if the electricity, my lord, is not
Unable to work due to the electricity.
yes, my lord, I am manufacturing jute bags, my lord. That is the difficulty. And my lord, there is a deadline that I'll have to supply the jute bags within, my lord, 7th of August.
I'll give them 4 installments, Mr. Dr. Shahara. If they can't, then they can't. That'll be
Along
first.
with that, because your Lordship, they have to
I'll
replace
specify
that
this is the
security.
last chance.
My lord, my lord, my lord.
Learned counsel for the petitioners.
And one thing, and they should have revised the load. Other formalities they have to comply with. Your Lordship, kindly see.
My lord, we have
750
revised the load, my lord. We are paying the extra security
They
deposit.
will
of
have to comply
33
with all
lakhs.
formalities.
Yes, comply with all the formalities.
But you have to intimate them the
But
formality.
that has already been in page 40. Your Lordship, kindly see the notice dated
Page.
39 onwards. Page 39 onwards.
So
17
I'll stipulate that
Page
they
40.
will comply with
Compliance, lordship. On
Learned
compliance.
counsel for the
On-
petitioners submits that the petitioners have taken leasehold interest in a jute industry and have been operating the same by paying electricity charges, full stop. However, subsequently due to the lockdown, the petitioners were suffering from dearth of work, resulting in non-payment of electricity charges, full stop. Subsequently, the CSC Limited has issued a notice of disconnection and thereafter disconnected the electricity supply of the petitioners, for which the jute industry, which employs about 3,000 people, 3,000 workmen, is out of business. Full stop. Next para. Learned counsel for the petitioners, in his usual fairness, submits that the petitioners have really moved this court by way of a mercy petition. Full stop. Next para. Learned counsel for the CSC Limited submits that despite having given several opportunities, the respondents have repeatedly failed, the petitioners have repeatedly failed to pay electricity charges. Full stop. It is submitted that the respondent number 4 is the actual consumer from whom the leasehold interest has been taken by the petitioners. Full stop. It is submitted that further grant of installments may not be financially viable for the CSC Limited. Full stop, next para. It is seen from the records that on previous occasions also similar non-payment of electricity charges had resulted in notices being issued by the CSC Limited. Full stop, however, comma, on earlier occasions, comma, the petitioners had cleared some of the amounts of dues. Full stop, next para. Hence, comma, it is seen that the antecedents of the petitioners are not totally bleak. Full stop, in any event, comma, the 8 installments sought by the petitioners cannot be granted, comma, since a balance has to be struck between the fate of the several employees connected with the petitioner's jute industry, as well as the financial interests of the CSC Limited. Full stop, next para. Accordingly, comma, keeping in view all the relevant factors, comma, WPA 18032 of 2023 is disposed of by directing the petitioners to comply with all formalities as indicated in the communication dated July 17, 2023, made by the CSC Limited within bracket annexure P5 at page 39 of the writ petition, bracket closed. Full stop. The petitioners shall, comma, apart from compliance of such formalities, comma, pay all the area dues to the CSC Limited, comma, as per the bills raised by the CSC Limited, comma, by 4 equal monthly installments. Full stop. The first of such installments shall be paid within the 15th of this month.
So grateful.
Full stop. The next 3 installments shall be paid by the 15th of each of the succeeding months. Full stop. In default of payment of even one of such installments, comma, the CSC Limited shall be at liberty to disconnect the electricity supply of the petitioners. Full stop. However, comma, in case the petitioners comply with the formalities as indicated above and pay the first installment, comma, the CSC Limited shall restore the electricity connection to the petitioner's jute mill within 48 hours, within 24 hours upon such.
Kindly make it 48 hours, His Lordship.
Within 48 hours after such payment. Full stop, next para. It is further clarified that the merits, no, it is further clarified that this is the last chance which is being given to the petitioners to avail of such installments. Full stop. In the event the petitioners fail to pay any of the installments, comma, apart from the consequence of the CSC Limited disconnecting the electricity supply to the petitioner's jute mill, comma, the petitioners would not be entitled to any further similar relief in future. Full stop. No address to cause administrative.
My lord, reconnection, my lord, if it is done, my lord, after
If it
4
is, if you pay, no, it will be within 48 hours of your payment of the first installment.
My lord, I'm so grateful.
And it will be subject to your subsequent.
Lordship.
I'm deeply obliged, Lordship.
Grateful. Grateful.
We'll come back in 10 minutes for the next one.
Grateful.
21,
But I beg to appear on behalf of the petition.
Yes.
This is a second round of litigation.
My lord,
It's
I am
not-
for the state.
Yes, for right.
It's not in respect of plot number 296 and 297. Well, it's against the irrigation department only. But, the petitioner has purchased this property. My lord. The purchase deed is being annexed.
Affidavit of servicing.
My lord, affidavit of service. My lord, only the state respondent is answered. Now, my lord, these two plot is being purchased by two deeds. There is no dispute on that. If your lordship straight away come to, my lord, page 60 of the petition, your lordship will get.
Please take your seat, Mr. Singh. Mr. Singh, please take your seat. Yes. Page 60, Mr.
That's 60.
60, yes.
Yes, but your lordship will get the record of right. Your lordship will get blood 296. It's recorded as Bastu. 297. It's recorded as Danga. Blood these two have blood certain bearing in the matter. Now, blood after this, blood I am blood paying taxes. Blood my name is being recorded in the record of rights. There is no dispute on that. But I applied for sanction building plan also. Blood if your lordship takes up blood the my sanction, blood that will lordship's brief blood page 81. Because just few gap there is a Suez Canal that is maintained by the irrigation department. While granting sanction,
Yes, sorry. Please continue.
Yes, while granting sanction, the authority granting sanction has given a rider to me. That is at page 81. Your lordship will get this is the resolution by virtue of which the panchayat is granting sanction building plan in my favor. The top portion is important. সরজমিনে তদন্ত করে দেখালাম যে আবেদনকারীর আবেদনটি সত্য আবেদনের যে দাগ নম্বরটি উল্লিখিত আছে তা সত্য উনি অঙ্গীকার করিলেন যে সরকারি নিয়ম মানিয়া বাড়ি নির্মাণ করিবেন এবং উক্ত জায়গার পাশে যে জল নিকাশি রইয়াছে তাহা উনি ছেড়ে বাড়ি নির্মাণ করবেন এবং 8 ফুট জল নিকাশি ছেড়ে বাড়ি নির্মাণ করবেন sanction granting authority my lord gives this rider to me. Now my lord kindly takes up my lord the RTI information reply to the RTI information my lord by the authority my lord that will appear at page 77. My query my lord is my lord page 74. If your lordship takes up page 74 my lord first. My lord, my first query at page 74 is in respect of these two plot whether it belongs to irrigation department or not. My lord, I am not on my lord canal right now. Whatever the Swiss gate is there. My lord, that is my specific query. At point number 1, if your lordship tally this with my lord page 77, which is their reply. My lord, the first paragraph of page 77. Has your lordship got it? My lord?
Yes.
The information of para 1. Application stated by you, the Pakka construction carried out by such and such, being the power of attorney holder of Shopon Shau, village such and such, plot numbers 296 and 297, Khatian number such and such, district Paschim Midnapur, kindly marks does not belong to irrigation and waterways department. But the form of work along with the Pakka construction is being carried out by him with grabbing both the wing wall of Ajuria Suisse, which belongs to the irrigation and waterways department. So this is their allegation. The permission granting authority gives me a rider that yes, whatever the side rear space I will have to require to be leave. Apart from that 8 feet, I will have to require to leave from the Suez Canal is question. There is no allegation with regard to the permission granting authority. He is the authority who can issue the stop work notice, demolition as per section 23 of the Panchayat Act. Nothing of that sort till that. In the meantime, this notice is being issued by the authority that is at page 88, which was subject matter of the earlier writ petition. Page 88.
Yes.
This notice is being issued, by the irrigation department, directing me to demolish my construction.
This is the architect.
Yes. He has issued this notice, Polash Pai Khal.
It's not in the letterhead of irrigation.
No. But this was being, this is the notice issued by the one of the authority of the irrigation department directing me to demolish my construction.
You are challenging this also.
This was being challenged in the earlier writ petition. Kindly see, your lordship's order, at page 90. Why, my lord, I will harp on it. My lord, that was the first query of your lordship. Despite query of the court, the learned counsel appearing for the irrigation department fails to cite any provision of law conferring authority on the irrigation department to issue notice in the tune as that dated 19th May 2022. So, my lord, thereafter your lordship protected me, my lord, for a limited time. My lord, the interim order was granted not to give effect. Direction of affidavit was being passed. This order was being, my lord, extended, and the final order of the petition, my lord, if your lordship takes up page 124.
Yes.
But here also, my lord, the point is the petitioner is enjoying the interim protection by way of an order dated such and such passed by the coordinate bench. By the said order, the impugned notice dated such and such from the respondent number 5 being the overseas assistant engineer, Department of Irrigation Waterways, asking the petitioner to remove the alleged unauthorized construction was stated. The reasons given by the learned judge was that the petitioner was not given an opportunity of hearing before issuing the impugned notice. That is one of the ground. Another ground was they do not have authority. Ultimately, my lord, if your lordship turns over the page, the second paragraph, however, since the petitioner is willing to participate in the hearing before the concerned authority, WPA such and such is disposed of with a direction upon the respondent number 3 being the executive engineer, West Midnapur Division, Department of Irrigation and Waterways, to call the petitioner for hearing on the alleged encroachment, as well as the statutory provision, including Rule 22 of the West Bengal Gram Panchayat Administrative Rules 2004. I shall rely on it because they wants to rely this provision of law, saying that this provision will not attract, and I may not have given the sanction building plan by the concerned panchayat. But till date, no challenge is being thrown regarding my sanction before my sanction granting authority. Because the law is similar for all. Even if they are aggrieved by my sanction, they will have to approach the sanction granting authority because the law says that. But till that date, since the things not get sorted out, this direction was being passed, and the interim order is like this. The respondent number 3 will come to the reasoned decision within a period of 2 weeks. The interim order will continue until a fortnight after the decision is being communicated to the petitioner, which is expiring today itself. Right? Now, my lord, if your lordship takes up, my lord, the reasoned order now, that will appear, my lord, to your lordship's brief at page 138 onwards. I will not trouble your lordship the entirety. The relevant portion only. The reasoned decision, it's 15th of June 2023. Has your lordship got it?
Yes.
Kindly similar the third paragraph of this. The petitioner Shapon Kumar Shao approached the office of the local Gram Panchayat for obtaining a sanction building on 2 occasions, and in both occasions on the basis of inspection, the Panchayat directed, kindly marks, my lord, to keep adequate space. They are not mentioning the adequate space is of 8 feet, which they have mentioned, from the concerned drainage canal and switch structure. This was, my lord, the, now, my lord, if your lordship turns over, kindly takes up, my lord, the hearing, my lord, the middle of page 139, hearing on 6th of June 2023 before the executive engineer. This head, my lord, this start with the petitioner was unable to furnish any site plan that clearly shows his building plan showing boundary of his land with respect to the road, switch drainage and canal. This was not submitted on that day. The matter was being adjourned for giving me opportunity to cite that site plan. The site plan now will not be annexed over here. 134 of your lordship, please. For the timing, your lordship need not. Kindly, my lord, turns over the page, the last page. 140. The sentence started with top, my lord, the petitioner submitted a map showing his site plan, building plan, and mandatory of his boundary of his land with respect to the road, switch drainage, canal, etc. Respondent number 4 of subdivisional officer Ghatal Irrigation. It is their, my lord, officer. Subdivisional Department Irrigation Waterways submitted a report dated such and such, along with photograph and section of the switch bed level and column foundation. Respondent number 4 and subdivisional officer Ghatal Irrigation Subdivisional Department Irrigation Waterways express his concern on safety of the structure considering the foundation level of the columns and bed level stroke 4 level of the switch structure. As mentioned above, the Panchayat in both of their inspection report directed the petitioner to keep adequate space. I have shown before your lordship again.
Show me the rule, Mr. Mukherjee.
Yes.
That's it. If you put in RCC columns and foundation on the bed of the drainage channel itself,
No, Milord, again, Milord,
so
I'm
if that
saying
is the allegation.
that is their allegation, sanction granting authority.
If
no
that is the
consent.
allegation, don't do have an independent power, the irrigation authorities, to take any
Milord,
proceedings?
the law says, Milord, it has to be by the permission granting authority, whatever inquiry. I am not on that also, Milord. I have
Anyway,
shown
let us
before
come
your
to-
lordship, my construction is within that plot number. They have stated that this plot is not belongs to irrigation department. Milord, I have shown before your lordship, they are itself, they under the Right to Information Act stated, this plot is not belongs. Milord, may I ask this question
Yes,
to
they
myself?
did, yes.
If, Milord, waterways is required for the purpose of maintaining a canal, whatever their allegation, then they cannot do so without, Milord, acquiring my land. As on today, the land is being recorded as Danga and Bastu I have shown before your lordship. Now kindly see, Milord, Rule 22, which they wants to heavily rely on. What is Rule 22? Milord, I have handed over, Milord, the bunch.
Yes.
Yes. Your lordship will get, Milord, Rule 22 at A170. Milord, yes. Restriction on construction over tank and water body. A Gram Panchayat shall not give permission to any erection or construction by filling up. Now, Milord, the Gram Panchayat is the permission granting authority. By filling up any tank, pond, or other water body, marshy, land, and abandoned brickfield or sand quarry, coal mine, mineral quarry, or any other water area, and shall take such steps as may be considered appropriate. Milord, the opening language, everything has to be by way of a tank, water body, or, Milord, the sand quarry or mining. Milord, in my respectful submission, these two plot, when they have stated the irrigation department is not belongs to irrigation department, my construction is on my plot. In addition, there is a rider by the permission granting authority that I have to leave 8 feet. Whatever I, as per law, Milord, your lordship knows, I have to leave, Milord, whatever my land 3 feet as a side rear space. But in addition to that, to protect them, Milord, 8 feet, Milord, in addition, Milord, the side rear space is being granted by the permission granting authority. There is no dispute on that. There is no allegation from the permission granting authority that I have not left that 8 feet which I have committed to. Now, Milord, in my land which is recorded, my, Milord, property is being recorded as Bastu and Danga, which they said it's not belongs to them. Whether for the purpose of, Milord, taking a plea that this will require for the purpose of this, Milord, flowing of water without initiating any acquisition proceeding, being one of the instrumentality of the state, whether by their own whims and fashion they can say, no, I will not permit you to make construction, rather I will demolish it. Till date, Milord, the permission granting authority has not come to a conclusion that I have not adhered to their rules. And say, Milord, this Rule 22 is not at all applicable to me, because the entire plot is being recorded as Bastu and Danga. Kindly see, Milord, the decision now. Milord, I have stopped there. So, Milord, but from the drawing submitted by the petitioner on such and such, the report of the respondent number 4, this is their authority. It reveals that the petitioner has constructed RCC column and foundation on the bed of the said drainage. Milord, this is a very vague term. On the bed of the drainage, how far it is bed, as per the irrigation department, how I will know? It's my property, my land, which they have admitted not belongs to them. I am making construction upon permission over my land. And is the irrigation department thought that the bed of this canal will say stretch for 10 kilometers? They will not allow anybody to, Milord, construct this without acquiring the property. May I ask this question to myself, Milord? And decision with, Milord, this decision is as per considering all aspects, it is necessitated the structure that has been constructed directly on the bed and slope of the drainage canal. Again, it's, Milord, vague. To be removed by the petitioner to provide sufficient waterways maintained by the drainage canal to keep the sluice gate property operational and functional for the public interest of the drain. How, Milord, this assumption of jurisdiction is there, Milord, by the, Milord, irrigation department? But this is my submission.
Yes.
My lord, this is not the question of the unauthorized construction of the building. Is the water channel is there, my lord, the drainage. The main complaint is the, my lord, a pillar being constructed on the drainage. That is the main complaint. And that too also beside the sluice gate. Lordship knows it very well in the village area, my lord. Drainage system is as such, because it takes the entire, the responsibility to drain out the water the villager, the village as well as where the, I mean, my lord, the other passages are also there. Only complaint is the pillar being constructed on the, I mean, drainage. My lord, lordship has seen the order passed by this honorable court directing our authority to hear out the matter after giving the service. My lord, entire report I am not reading aloud, my lord. My lord, come to page 139.
130?
139.
Yes.
Because at the time of hearing, my lord, my learned client could not produce any such paper.
Yes.
They're denying that the pillar has not been constructed on the drainage. My lord, you see, my lord, hearing on date was been fixed on 6 June 2023 before the executive engineer, West Midnapur Division, irrigation of the Waterways Directorate. It's under the instruction of this honorable court. The meeting was being held. The petitioner was unable to furnish any site plan. That clearly shows his building plan showing boundary of his land with respect of the road, sluice gate, drainage, channel, etc. He couldn't produce. He could not say.
On the next day he did.
My lord, even on the next day, my lord, it's not there, my lord. According to me, I may be wrong, my lord. The learned referred to the petitioner, Mr. Prita Ghosh,
I think
because
6th of June order is unnecessarily we need not go into 6th of June. They were directed to produce, they produce. Let us come to the next order.
Next order.
Next date, yes.
Hearing on 15 June 2023,
Yes.
before the executive such and such, according to the second hearing held on today, that is on 15/6, in presence of the petitioner such as giving, my lord. Next page, my lord, 140, my lord. And the petitioner submitted a map showing his site plan, building plan, and boundary of his land with the respect to the road, drainage channel, etc. My lord, what he has submitted, a map showing the building plan. Building plan cannot be shown as such. According to our instruction, my lord, the Panchayat has not granted the building plan till today. That is the instruction, my lord, I have upon instruction, my lord. Drainage channel, etc. Respondent number 4, the sub-divisional officer, Ghatal in irrigation such and such, irrigation department, dated 15/6/2023, along with photograph of section of the sluice gate, bed, level and column foundation, respondent column foundation. Respondent number 4, the sub-divisional officer, Ghatal such and such, whatever express his concern on safety of the structure considering the foundation level of columns and bed level of the floor level of the fully structure. So there also, I mean, under they have some responsibility, my lord. Whatever my learned friend has said, I mean, according to the, I mean, care and control, the construction has been made, nothing has been done. We are also in concern with their construction.
The question Mr. Singh is not
My lord,
about the construction.
The observation part.
So whether you have authority under Rule 22 to
And my lord,
take this step.
Yes, my 20 sub-rule 2 under Panchayat Act. But the 20 sub-rule 2 says.
That confers power on the Panchayat to take steps for drainage facility in the
I don't know if the Panchayat has been served or not, my lord. They have been made a
Panchayat,
party.
why should they serve Panchayat? You should have moved the Panchayat
No, my lord.
for them to take
Panchayat has
steps.
made a party to this petition.
They need not make a party of the Panchayat at all. You, before taking this, what confers on you the authority to pass this order? You don't have any authority in law. Which law confers you to do this? You could have approached the Panchayat or even challenged the sanction plan. Not even without challenging
We
the
are not
sanction
on
plan.
that, my lord. We are, the safety and
Suppose you are
security
not on challenging the sanction plan. You are on their unauthorized construction. As per rule,
not the construction, madam. Where is
the construction on your drainage.
We are considered drainage because the drainage been covered by a pillar.
If you are concerned by that, Mr. Singh, you have to resort to Rule 22, which says a Gram Panchayat shall not give permission such and shall take such steps as may be considered appropriate for drainage facility in the locality. This is the provision you have cited here, 22B.
My lord.
So 22B also says the Panchayat has to do it. You should have moved the Panchayat. Mr. Singh, even if they have committed a wrong, the Panchayat has to take steps against them. We don't have authority. So this is without jurisdiction. That is the difficulty. That is the only difficulty.
My lord, that I've seen.
If somebody puts a pillar on a drain, definitely that has to be removed.
No, under the order of this honorable court, is there been empowered?
Court did not empower the authority to
No,
issue
no.
such a notice.
Just
Court directed you to give a
the
hearing.
issue.
Yes, you have
Decide the
decided,
issue.
which is beyond jurisdiction.
No,
Court
no,
did
no.
not confer jurisdiction on you. If I direct a particular court, subordinate court, suppose, to decide an issue, that does not mean I am conferring power on the court. The issue was directed to be heard out, and you are directed to pass orders. You have passed your orders, which is without jurisdiction. You could at the best have referred it to the panchayat, as per Rule 22 also. But it is surprising that the irrigation department does not have any such power to do it. They should have some power.
My lord, whatever the order being passed, my lord, may
It is without jurisdiction. That is the
No,
difficulty.
may I do it once. Just to clear my mind.
Definitely.
However, since the order says, since the petitioner is willing to participate in a hearing before the concerned authority, it is the writ petition such as is disposed with the direction on the respondent number 3. The West pass the order, my lord. Being the executive engineer, West Bengal Midnapur Division, Department Irrigation and Water, to call a petitioner for a hearing on the alleged encroachment as well as the statutory provision of including the Rule 22 of the West Bengal Panchayat, Gram Panchayat rules such as or any other act, rules which may relevant to the facts of the instant case. So I have been empowered to consider so far at the time of any consider that's Rule 22.
Can a court of law empower if the law does not?
This is my
No, you tell me this.
Understood.
It's your argument, Mr. Singh, that by the court order, even if I pass this order, all the same, if a court passes an order, can that confer a jurisdiction which is not there on the authority under law? Tell me that.
Because your lordship knows the.
If you tell me that is a proposition of law,
No,
Mr. Singh, I'll record that and pass it on.
I cannot. With the officers, generally they've been order being passed as such, officer, but they are also very much, what I will
They
say.
should have referred the matter to the panchayat immediately. So I'll give you that liberty, but this order cannot send.
Only one thing, Milord, may I clarify?
No, one thing. Yes.
My learned friend says it's about one pillar or two pillar over the Swiss gate. Milord, your lordship has noticed, Milord, initial order of demolition is not being set aside by this honorable court. This was being suspended till the decision being arrived. The suspended, Milord, order is at page 88, which directs me to demolish entirety of my construction. It's not about specifying any pillar.
Anyway.
Yes.
The petitioner, being aggrieved by an order dated June 15, 2023, passed by the executive engineer within bracket I and W, capital D, small t, E, full stop, bracket closed, West Midnapur Division, Midnapur, has preferred the instant petition. Next para. By virtue of the said order, the executive engineer, apparently taking resort to Rule 22 within bracket small b of the West Bengal Panchayat within bracket Gram Panchayat Administration, bracket closed rules, 2004, directed the petitioner to remove the structure which has allegedly been constructed by the petitioner directly on the bed and slope of a drainage channel, to provide sufficient waterways and maintenance of the drainage channel. Full stop, next para. Learned counsel contends that upon obtaining a valid sanction from the local panchayat, the petitioner started the construction in issue. Full stop. However, thereafter, the Pradhan of the local Gram Panchayat gave however, thereafter, sentence the local Gram Panchayat, it is contended, in the sanction plan, clearly put in a rider that the petitioner has to leave the drainage area which is adjacent to the plot where the construction is being made to be left aside. Full stop. That apart, comma, the petitioner was to leave apart 8 feet wide drain prior to making the construction. Full stop. Next para, it is argued that the petitioner has been making the construction in strict compliance with the said sanction. Full stop. Thereafter, comma, the architect of the irrigation authorities, comma, by a notice dated May 19, 2022, communicated to the petitioner that the petitioner has made an unauthorized construction in front of a sluice, SLUICE, gate on the drainage system, comma, for which the same was to be removed by the petitioner. Full stop. In default, comma, it was indicated, comma, legal action would be taken against the petitioner. Full stop. Next para. The petitioner, comma, thus aggrieved, comma, moved court, and an order was passed on August 24, 2022 in connection with WPA 9666 of 2022 directing affidavits to be filed. Full stop. It was observed in the said order that despite the query of court, comma, learned counsel appearing for the irrigation department failed to cite any provision of law conferring authority on the irrigation department to issue a notice such as that dated May 19, 2022. Full stop. The operation of the said notice was also stayed for a limited period. Full stop. Next para. The matter, the writ petition ultimately came up for final hearing before a coordinate bench on April 26, 2023, when it was disposed of by a direction on the executive engineer, comma, West Midnapur division, comma, Department of Irrigation and Waterways, comma, to call the petitioner for a hearing on the alleged encroachment as well as the statutory provisions, including Rule 22 of the 2004 rules or any other act or rules which may be relevant to the facts of the said case. Full stop. Next para. In compliance thereof, comma, hearing was given to the petitioner at least on 2 occasions and the impugned order was passed. Full stop. Learned counsel argues that the petitioner has been constructing in strict compliance of the sanction plan issued by the Panchayat. Full stop. Since the Panchayat, that is the sanction issuing authority, comma, itself has not have any grievance regarding such construction, comma, it is beyond the jurisdiction of the irrigation department to take such steps as impugned herein. Full stop. Next para. That apart, comma, it is argued that the sanction plan required the petitioner to keep sufficient space beside the drain in question, comma, 8 feet in width, comma, which has duly been kept by the petitioner. Full stop. However, comma, the irrigation department in its impugned order proceeded on the premise that the petitioner has made constructions on the bed of the drainage channel itself. Full stop. Next para. Learned counsel also places reliance on the relevant extracts of the records of rights where the concerned land has been shown to be within single inverted Bastu and within single inverted Danga. Full stop. Next para. Moreover, comma, under Rule 22 of the 2004 rules, comma, it is argued, comma, the irrigation department has no authority to take any action. Full stop. At the best, comma, it is argued, comma, the irrigation department ought to have challenged the sanction plan issued to the petitioner like every other litigant. Full stop. Next para. Learned counsel appearing for the respondent authorities places reliance on Rule 22 of the 2004 rules itself and submits that in terms of the same, comma, steps can be taken, comma, as considered appropriate, comma, for drainage facility in the locality. Full stop, next para. It is submitted that the irrigation department, comma, through its concerned officer, comma, produced photographs and sections of the sluice bed level and column foundation, comma, which clearly clinched the issue against the petitioner. Full stop. It is submitted that the executive engineer, comma, in his impugned order, comma, clearly referred to all such materials and came to the specific observation that from the drawing submitted from the by the petitioner and the report of respondent number 4, that is the irrigation department, comma, it is revealed that the petitioner has constructed RCC columns and foundation on the bed of the said drainage system itself, comma, which violates rule 22 within bracket small b of the 2004 rules, comma, obstructing the drainage facility in the locality. Full stop. Next para, it is, comma, thus, comma, submitted that the executive engineer acted well within his authority to pass the impugned order. Full stop. That apart, comma, it is argued that the coordinate bench by its order dated April 26, 2023, comma, had specifically observed that the petitioner was willing to participate in a hearing before the irrigation department authority and directed the executive engineer of the irrigation department to call the petitioner for a hearing on the alleged encroachment as well as the statutory provisions, including Rule 22. Full stop, next para. Hence, comma, after having participated in such hearing, comma, the petitioner cannot stand around and dispute the authority of the executive engineer himself. Full stop, next para. Upon hearing learned counsel for the parties, comma, the order dated April 26, 2023 is required to be considered first, comma, since the same was the genesis of the consideration by the executive engineer, comma, which ultimately led to the impugned order. Full stop, next para. Upon considering the submissions of parties, comma, the learned single judge had disposed of the writ petition with an observation that the petitioner was willing to participate in a hearing before the concerned authority, which had then been fixed by the notice impugned in the said writ petition. Full stop, next para. The executive engineer of the West Midnapur division was directed to give a hearing to the petitioner on the alleged encroachment as well as the statutory provisions, including Rule 22 of the 2004 rules, comma, or any other act or rules which may be relevant to the facts of the case. Full stop, next para. It is further seen from the said order that nothing was finally decided by the court with regard to the authority or the merits of the case. Full stop, next para. It is well settled that a direction on a particular authority to decide an issue cannot, comma, per se, comma, confer jurisdiction or authority on the said instrumentality, comma, which is not conferred on it by law. Full stop. The order of the coordinate bench merely directed a hearing to be given to the petitioner, and the executive engineer was directed to advert to, within double inverted, any other act or rules which may be relevant to the facts of the instant case, double inverted close, comma, even apart from Rule 22 of the 2004 rules. Full stop, next para. A mere reference to such rule or other acts and statutes does not, comma, in any manner, comma, tantamount to a direction, tantamount to an observation or conclusive finding as to the authority of the executive engineer to pass an order as the impugned order. Full stop, next para. Upon a consideration of Rule 22 and the other acts or rules, comma, the only option before the executive engineer in the present case, was to come to a finding either way as to the legality of the construction made by the petitioner and, at best, to refer the same, if held illegal in the perception of the executive engineer, to the appropriate authority having jurisdiction to pass an appropriate order. Next para. However, it cannot be said that anything in the said order of coordinate bench dated April 26, 2023 conferred any jurisdiction or authority on the executive engineer on a particular aspect of the matter which has not been conferred on the said authority by law. Next para. Rule 22, in no uncertain terms, provides that a Gram Panchayat title is the authority which shall take such steps as may be considered appropriate, for drainage facility in the locality. Next para. In sub-rule 2 of Rule 22, it is stipulated that in case of illegal filling of any tank, pond or other water body, etc., or any other water area, the Gram Panchayat shall immediately report the matter to the executive officer of the Panchayat Samiti and the police station for taking appropriate action. Next para. Read in conjunction, the two sub-rules of Rule 22 clearly confer a limited power on the Gram Panchayat, even if satisfied that there has been an illegality regarding drainage facility in the locality, to refer the matter to the executive officer of the Panchayat Samiti as well as the local police station for taking appropriate action. Next para. Rule 22 within bracket 1 within bracket small b, which has been quoted by the executive engineer, does not authorize the executive engineer itself to pass an order of removal of the unauthorized construction, if any. Hence, the impugned order is palpably without jurisdiction. Next para. Even on facts, there is some doubt, since there is a contradiction between the initial notice dated May 19, 2022, which was never revoked by the court, as rightly argued by the petitioner. Next para. In the said notice, it was clearly indicated that the petitioner had allegedly made illegal construction on the drainage channel sluice, and that the entire construction was unauthorized and illegal. The petitioner was directed to remove the entire construction. However, the construction, as per the petitioner, is going on in terms of the specific sanction which was issued by the Panchayat authorities, which have not taken any adverse view against the petitioner in the present case, clearly directing the petitioner to leave 8 feet space beside the sluice channel. Next para. Hence, there is nothing on record to indicate that any construction is being made on the bed of the drainage channel itself, apart from the order impugned herein. Next para. In any event, if the petitioner is making any unauthorized construction on the drainage channel, the authorities are definitely entitled to take steps in that regard. However, in view of the above observations, the impugned order of removal of the construction passed by the executive engineer is dehodes the law and bad for lack of jurisdiction. Next para. Accordingly, the said order ought to be set aside. Hence, WPA 18077 of 2023 is allowed, thereby setting aside the within double inverted reasoned decision, double inverted clause, dated June 15, 2023, taken by the executive magistrate within bracket I and WDTE bracket closed, West Midnapur Division, Midnapur, Paschim Midnapur of the irrigation department, full stop. It is, however, made clear that nothing in this order shall preclude the irrigation department of the state to refer the matter to the local Gram Panchayat for the purpose of the Gram Panchayat to ascertain its own views on the same. In the event the Gram Panchayat is satisfied that there is substance in the contention of the irrigation department regarding alleged unauthorized construction by the petitioner on the drainage channel itself, the Gram Panchayat shall immediately report the matter to the executive officer of the Panchayat Samiti and the police station for taking appropriate action. Full stop. In the event any action is taken consequentially against the petitioner, the petitioner shall be given adequate opportunity of representation and hearing, and to produce the petitioner's relevant documents, prior to taking any coercive steps against the petitioner on such score. Full stop. No rest to cause urgency.
Would it be your lordship's pleasure to set aside the earlier order also, which was not being touched? That is 19th of May 2022.
যেটা বললাম, setting aside the order, the recent decision dated such and such, as well as the notice dated May 19, 2022, within bracket annexed at page 88 of the writ petition, bracket closed, issued by the assistant architect, what is Sech Upabhukti? Translate it for me. Of the irrigation department, Ajuria branch. বলো বাকিটা কন্টিনিউ করছি, মানে ওই রিজন ডিসিশন প্লাস এটা দুটো কি সেট আছে।
Liberty may be given to communicate my lord's order. Today is the last day.
Mr. Singh is appearing.
Grateful.
Thanks.
Extremely.
May I please your lordship?
Yes, Mr. Court.
I am for respondent number 9. Supporting Mr.
9 supporting us.
I need lot of supporters.
From respondent number 8.
Who is opposing Mr. Court?
For the respondent.
Mr. Chaudhary also with Mr. Court?
Yes. I said I need a lot of support.
Mr. Dey, you are for the
For
others?
the respondent.
You win. Yes, Mr. Court, what is the word?
Lord, the petitioner before your lordship,
Right,
is a company which is incorporated under an appropriate law.
Only one thing, my lord, before my learned senior friend starts, my lord, and subject to correction and subject to the fact that your lordship will not take me amiss. This writ petition pertains to the actions and inactions under the Customs Act. And as per my humble submission, my lord, this writ petition will come under Group 4, subject to what my lord says, my
Group
lord.
2 is Group 2 is customs.
Group 4 is under Group 4 Customs Act comes, my lord, and Group 4 relates to revenue matters.
Thank you.
Lord, let me place.
Why should I take you amiss? I should welcome your submission. Yes, Mr. Court, if it's pertaining to our customs.
It's absolutely not. Kindly, my lord, let me place the facts at least, because my learned friend, my lord, he has taken his point. The other point is with regard to maintainability. I will also meet that. Lord, the petitioner before your lordship is a company which is not incorporated.
I'll take note of that, Mr. Dey.
I will, Lord, because in course of my submission, I'll show your lordship why, Lord, it has got nothing to do with the applicability of the Customs Act. It is basically, Lord, inaction of the customs authorities, which I am alleging. I am not saying, Lord, there is any violation of any.
If it is in terms of any, that inaction, if the action, proposed action by you is in terms of any provision of the Customs Act, then Mr. Crow, I think his.
Lord, I tell your lordship, I am an exporter. I have, Lord, I have sent certain goods. I have hired a vessel. These goods have reached the sand head. Now, Lord, the importers have put in their documents, the manifest, their bill of lading, everything is there. But Lord, at the stage of landing of the goods, they have refused to accept the goods. So, Lord,
they have also applied for cancellation of their document. We have also applied for cancellation of the document. I want to take the goods back. This is not the sum and substance of the cause of action. And Lord, there is that the ship is still lying at the sandhead. Lord, it has not entered, Lord, the customs territory. It is lying, Lord, at the sandhead, because unless these documents are cancelled, it can't sail. We are seeking permission to sail. This is the cause of action. Lord, really speaking, Lord, it's an authority which is not, Lord, acting. Lord, unless, Lord, the goods are imported, there is no Customs Act, Lord, applies. This is.
Do you have a right under the Customs Act on that score?
I have a right under the general law. Lord, I am exercising my right under the general law. I am saying that, Lord, the importer who has imported, he doesn't want. There is a contract which is mutually cancelled. I have recalled the documents from the bank.
Mr. De, can you show me from the cause list which court is taking up, so that I want to see the language once?
Court number 2, Lordship, before Justice Nizamuddin.
Justice?
Before Justice Nizamuddin. Court number 2.
List that. At a list,
just check the language once.
Let me also, my lord, have a look at.
Yes. 459.
Page 459.
That refers to group 4 only. Group 4 anywhere.
This is not revenue and tax law.
So this is not revenue or tax.
Nothing to do with revenue and tax law. Group 4, Lord, is revenue and tax law. Lord,
Yes.
this is not even, Lord,
No.
having any nothing. No, there is no demand by the customs.
Justice Nizamuddin is taking up group 4 matters which pertains to revenue and all this.
Revenue matters over there, custom matters under the Customs Act are adjudicated before Justice Nizamuddin, court number 2.
But that must be, Lord, relatable to some revenue and tax.
Over in the instant case, they have imported the goods. Importation is further processed, and every step is being taken under the aegis of Customs Act.
Lord, importation.
So Customs Act has been conferred to Justice Nizamuddin?
No.
I don't think so. Revenue is there.
No.
Group 4 is revenue. Revenue per se is not customs.
But generally, my lord, subject to kind sanction of your lordship, Customs Act matters are taken up before.
Only revenue.
You are supporting Mr. God.
Custom Act.
I won't tell you.
In general, as a lawyer also.
Custom Act matters are taken up before court number.
Mr. Kaur, probably I'm doubtful whether Mr. Kaur or Mr. Chaudhary would be aware of these.
Absolutely not. I concede. Absolutely not.
Mr. De, are you? Have you ever seen the list of Justice Nizamuddin?
I have.
Tell me the truth.
It is group 4.
Group 4 I also know. What is in group 4?
Group 4, it's revenue matters. And we are regularly doing customs.
Show me something about customs.
I tell you, lordship, from my experience, we are regularly appearing custom matters before Justice Nizamuddin.
Where revenue is involved.
So those matters, the petitioner will now ask for release.
Even relating to custom matters, Customs Act.
Group 4 kothay ekhane? No. Revenue and tax laws under group 4, not at all. Eta kar amader কোন page? No, Mr. De. I'll record that submission of yours first and then take up the matter. At the outset, a point of determination is taken up by learned counsel for the respondent number.
For the respondent number.
Such and such.
One.
It is submitted that the matter pertains. Yes.
2, 3, 4, and 5. 2 to 6, my lord.
Respondent numbers 2 to 6. The matter pertains. It is suggested that the matter pertains to the Customs Act and ought to be heard before the bench taking up group capital Roman 4 matters. Next para. However, it is seen from the cause list that the bench taking up group 4 matters of the classification of writ matters is taking up those matters pertaining to revenue and allied issues. However, the dispute involved in the present proceeding does not touch upon any revenue issue. As such, in the opinion of this court, this court has ample determination to take up the matter, and the matter should not be unnecessarily released on the ground of determination. The matter is taken up for hearing now.
Now,
Yes.
Lord, may I just indicate, so far as the maintainability point is concerned, I shall deal with it, because a foreign company, it is now, Lord, a settled law that even a foreign company can maintain a writ petition, but only with regard to fundamental rights, which are, Lord, restricted to the citizens, Lord, of the country. Those rights, Lord,
Article 14 is covered.
Article 14 and 21.
21.
Both, Lord,
Only 14 and 21 have been settled.
Absolutely.
Yes.
Lord, this is settled.
14, 21 is general for
Yes.
every human
And
being.
I am not, Lord, asking for
19 you are not
19,
asking.
I am not asking.
19 you cannot.
I cannot.
You are not
I cannot.
asking. Very well.
So, Lord, I'm 19, Lord, I am not
But
asking.
19 is directly connected here.
Not really. I tell your
Very
Lordship,
well.
not really. Because, Lord, my contract is with a private party. 7, 8, and 9. They are not the importers. These import contracts have been terminated. After, my lord, the vessel has reached the sandhead, and before it has entered the customs, my lord, area. So, my lord, at this stage, Lord, the documents which were filed, these were filed in anticipation that the vessel will unload the goods. Now, my lord, the question of unloading of goods in the customs area would not arise. So, my lord, we are really asking for, Lord, cancellation of these documents and permission to sail. I tell your lordships, if your lordships, Lord, kindly take, Lord, a few documents. First, Lord, the sales confirmation, these are, Lord, relatable to lentils. Lord, these are food grains, Lord, which are perishable. So, Lord, these contracts are at page 30 to 34. Your lordships will find. These are the contracts. Page 30 to 34, in fact, till 39. Because, Lord, there are 3 importers. And, Lord, there are 20, Lord, the bill of lading, there are 20 bill of ladings which have been issued.
Your vessel is from Australia.
My vessel is from Australia.
Yes.
It has reached, Lord, Calcutta, the Haldia, I think. It's Haldia. It's reached Haldia. It's lying at the sandhead. Now, Lord, when it reached the sandhead, Lord, the broker, the shipping agent, Lord, it filed the import general manifest. That your lordships will find, Lord, page 99. On 99 onwards. These are the import general manifests which were submitted, and according to the Customs Act, this has to be submitted, Lord, prior to the arrival of the vessel to intimate that these are the goods which are coming. So this was submitted, and, Lord, subsequently the bill of entries were also filed. Your lordships will find that at paragraph 16, Lord, I have averred that these bill of entries were filed. Now, Lord, after this, there was a dispute with regard to the importers, because accepting the goods, they said that they don't want to accept the goods. So, Lord, there was mutually, Lord, there was a termination of contract, and, Lord, page 115, your lordships will find that I have recalled the documents from the bank, because, Lord, these are, Lord, the payments are to be made through the bank. Page 115, your lordships will find, this is my letter.
The contract was cancelled between you.
Between the importers and me.
And the exporter.
Yes. And kindly see, Lord, page 1115 at the bottom. Please urgently courier documents back to this office. Please confirm your actions and advise courier details to enable tracking. I have called for the bank's documents because, Lord, the bank payment, it had to be a bank transfer. So now, Lord, we apply to the customs authorities.
You are the consignor.
I'm the consignor. And consignees are, Lord, the respondent numbers 7, 8, and 9.
Very yes.
They are. I have served them also.
Yes, yes.
And, Lord, 10, Lord, is the shipping agent.
Right.
Now, Lord, first, my lord, the shipping agent, my lord, approached the customs authorities. Please come to page 117. Page 117.
Yes.
They say that please cancel the import general manifest. They say that this is to inform you that we as agents only had filled IGM of MB Darya Ganga on 23rd May 2023 and vessel had arrived in Sandheads on 5th of June to discharge 24,038,760 metric ton lentils in bulk. Vessels arrived at Sagar on 5th June and inward formalities final entry was granted on 305 hours on 6th June. Since then, vessel was waiting at Sagar anchorage to start discharge operation by receivers through their handling agents. Our principal has informed us that the receivers has not yet made the payment for cargo. In the meantime, port has instructed us to ship the vessels from Sagar to Sandhead as vessel was not working to accommodate other vessels. We have taken shifting permission from the customs authority after making necessary port payment and port shifted the subject vessel to Sandheads on 15 June. Now our principal wants to sell out the vessel to any other Indian port as buyers have not paid for the cargo and are refusing to accept the cargo. In view of the same, we on behalf of owners, Spectrum so-and-so, request you to cancel the IGM, enable them to arrange for selling of the vessel. So this is not what is stated in.
So he had crossed the Sandheads.
No, it
came to the anchorage.
It came to the anchorage, but it was sent back because Lord, the discharge was not taking place. So Lord, I'll show from the Customs Act until Lord, they give a permission to unload the goods in the custom storage, the import Lord doesn't get complete. So Lord, that situation had not arisen. And Lord, once we write that, then Lord, the reply of the customs is at page 120. Your Lordships may kindly take page 120. Please refer to your left such and such. You have informed that IGM had been filed on 23rd May against the subject vessel and the vessel had arrived Sandheads on 5th June. Checked the ADI system and found there are 20 line numbers of bills of entry have been filed against each and every line number by 3 importers against the said IGM. 9 bills of entry filed by Swiss Singapore, 6 by Taj Agro, and 5 by Uma Exports. These are the importers. In this factual position, it cannot be cancelled. Then, Lord, importers, they also, Lord, send in request. Your Lordships will find from page 122 onwards. Kindly, Lord, see. Page 122. Yes. First paragraph, IGM in subject along with the mentioned BL and line of cargo, etc. However, due to unforeseen circumstances, we are unable to take delivery of the subject cargo. As such, if the shipper wants to sell the cargo of the subject BL lines number to any other party, we have no objection, and any other party, we have no objection on the same. And Lord, same letters are issued by page 123 and 124. Your Lordships will find the other importers have also issued that letter. Then, Lord, on 27th of June, the importers have also applied for cancellation of the bill of lading. From 125 to 127 to 127, your Lordships may kindly come to. 127 to 129, they have also, Lord, applied for cancellation of the bill of lading. Now, Lord, this is where the whole thing is stranded. Now, Lord, we are, Lord, incurring damages because, Lord, the ship I have hired, it's not my ship, I have hired the vessel. And Lord, we have found a buyer in Tuticorin. So, Lord, the ship is not going to leave the Indian waters. It will travel to Tuticorin. Tuticorin, Lord, we have found some buyers. We want to now, Lord, send the vessels. And Lord, the same formalities can be done, Lord, in Tuticorin. And Lord, there is, in fact, no, Lord, violation of any of the provisions of the Customs Act.
Do they have any revenue claim against you?
No. As of now, Lord, nothing. Because unless the import is complete, I'll show you, Lord.
Have they in writing communicated to you anything? The reason for this?
Nothing. They're just sitting on it. This is my cause of action is on this.
So they have to give a permission to a permit, issue a permit.
Yes.
To leave.
They have to cancel this and give a permission. I'll just show your Lordship, Lord.
I'll go into that. We'll continue after the recess.
Yes.
Yes, sir.
Hey, your lordship can take it.
দেখাচ্ছিলেন না এখানে থাকবে না গো কাস্টম সেক্টর মামলা আমি নিই
From section 29.
Yes.
Your lordships kindly, my lord, come to section 29.
Right. আছে ready. Ready. মিশা করকে
29, Lord, when the vessel arrives, this is not what has to be done. The person in charge of a vessel or an aircraft entering India from any place outside India shall not cause or permit the vessel or aircraft to call or land for the first time after arrival in India or at any time while it is carrying passenger or cargo brought in the vessel or aircraft at any place other than the customs port or customs airport as the case may be, unless is permitted by the board. So, my lord, whenever the import takes place, it has to enter a customs area. That's custom protected area. Then, Lord, it says the provisions of subsection 1 shall not apply in relation to any vessel or aircraft which is compelled by accidents, etc. We are not concerned. Then, Lord, please see 30. 30 is, it says, the person in charge of a vessel, aircraft, or vehicle carrying imported goods or any other person as may be specified by the central government by notification in the official gazette in this behalf shall, in the case of a vessel or an aircraft delivered to the proper officer, arrival manifest or import manifest. So, Lord, this is before pre-arrival. This is what has to be given to the officers. Then, Lord, it says, prior to the arrival, the vessel or aircraft as the case may be, and in case a vehicle and an import report within 12 hours after its arrival in the customs station. Then, Lord, or the import report or any part thereof is not delivered to the proper officer within the time specified, then, the Lord, section 30. Then, Lord, please come to 31. It says imported goods not to be unloaded from the vessel until entry inwards granted. The master of a vessel shall not permit the unloading of any imported goods until an order has been given by the proper officer granting entry inwards to such vessel. No order under subsection 1 shall be given until an arrival manifest or import manifest has been delivered or the proper officer is satisfied that there has been sufficient cause for not delivering it. Now, Lord, we have gone up to 31. Then, Lord, 32. Imported goods not to be unloaded unless mentioned in the arrival manifest or import report. No imported goods required to be mentioned under the regulation in an arrival manifest or import report shall, except with the permission of the proper officer, be unloaded at any customs station unless they are specified in such manifest or report for being unloaded at that customs station. Then, Lord, your lordships may kindly also take 33. Unloading and loading of goods at approved places only. It says, except with the permission of the proper officer, no imported goods shall be unloaded and no export goods shall be loaded at any place other than a place approved under clause A of section 8. This clause A under section 8, your lordships can check up. Lord, it says a customs bonded warehouse. And Lord, that is where, Lord, unless the unloading takes place, really, Lord, the import is not complete. Then, Lord, your lordships may kindly also take note of 45, section 45. This is, Lord, post, Lord, customs warehouse removal. Section 45, 46, and 48. These are, Lord, post customs arrival, but say 46 deals with the bill of entry. Your lordships may kindly take note of 46. The importer of any goods other than goods intended to transit or transshipment shall make entry thereof by presenting electronically on the customs automated system to the proper officer a bill of entry for home consumption or warehousing, provided that the Commission of Customs may, in case where it is feasible to make entry or presenting electronically, etc., allow an entry to be presented. So, Lord, this is the entire procedure. First, Lord, the import manifest, that, Lord, the shipping agent produces before arrival. And then, Lord, on arrival, they are given an inward, Lord, permission that your lordships have entry inward, that is, Lord, 31. And, Lord, subsequently, 32 is the unloading. So, my lord, before the unloading has taken place, Lord, the contract could not be executed. In fact, the importers have cancelled the contract, and that cancellation is also accepted because, Lord, I'm really stuck with this goods now. Now, Lord, one other provision which I wanted to draw your lordship's attention to is 149. Which permits amendment of documents. So, my lord, I can also change the port of discharge from Haldia to Tuticorin. That is also permitted. 149 is the provision for amendment of documents. I have asked for cancellation, Lord, because I will issue a fresh manifest which can be presented in Tuticorin. But Lord, this is permissible. It says, save as otherwise provided in section 30 and 41. The proper officer may, in his discretion, authorize any document after it has been presented in the customs house to be amended, provided that no amendment of a bill of entry or shipping or bill of export shall be so authorized to be amended after the imported goods have been cleared for home consumption. That is, Lord, post customs go down. If the goods have been cleared, obviously, Lord, there can't be any amendment. That is an irreversible situation.
It speaks of an amendment of that
of the manifest,
but not a cancellation.
Not a cancellation. I am saying, Lord, this permits, I can, Lord, also seek an amendment of discharge of goods in the
instead of Haldia to Tuticorin.
To Tuticorin.
That amendment you can. Yes.
That also I can. Now, Lord, cancellation is permitted, Lord. I'll show your lordship.
If you cancel and go away, I mean, there may be such a situation.
No, I can give an undertaking also. I can give an undertaking that, Lord, I'll travel to Tuticorin. As of now, because, Lord, there is no customs duty involved. These are, Lord, lentils, Lord, where no customs duty. This comes under the open general license. Right. So therefore, Lord, there's no involvement of any customs duty. Yeah, there is. And in fact, Lord, even if I go away, I need permission to go, because, Lord, once having entered the sanded, Lord, I cannot, without a pilot, Lord, guiding me, I cannot, Lord, go to the high seas. Right. The situation is such that, Lord, an overseas vessel, they can't, Lord, go back on their own. So, and Lord, I need permission because, Lord, all my documentation are there in the port. So, Lord, I need either, Lord, it to be cancelled, or, Lord, I need, Lord, a permission, Lord, to amend it, to discharge it, Lord, in Tuticorin. That is also, Lord, acceptable to me. I am saying, Lord, this is a desperate situation. I am spending, Lord, 20 lakhs a day as demurrage. Because, Lord, I have, Lord,
stuck here.
I'm totally stuck. And, Lord, I have hired a vessel which I have to release. I can't, Lord, till eternity, Lord, I can't hold on to that vessel. That vessel owner, Lord, has also, Lord, written letters saying that the vessel be discharged. Now, Lord, on the question of, Lord, cancellation, whether, Lord, the cancellation, 2000. Lord, I show, Lord, there is a practice, Lord, notice. Lord, this is a public notice. They issue it. Okay, copy. Just give him a copy. Lord, please come to.
Sir, you are for the customs department. Yes.
Please come to, Lord, this is, Lord, para 29. Para 29.
Yes.
Short shipment, shutout, cancellation, back to town permission. It says ACDC so and so will give permission for issuance of short shipment certificate, shutout, or cancellation of bill of entry on the basis of an application made by the importer. The bill of import particulars would need to be cancelled, deleted, modified in system before such permission. Lord, if your lordships looks at, Lord, the letter of the customs once again, I'm sorry, Lord, I'm really troubling your lordship.
No, please.
Kindly, Lord, see the reply of the customs once again, page 120. Lord, what they were trying to do is that they were trying to protect the Indian importers. Your lordships may see, they are saying that we can't cancel your import manifest because the interest of the importers are involved. They say that 20 bill of ladings are there. It can't be cancelled. That is what the stand taken is.
Mr. Kaur, are you agreeable to amendment to Tuticorin
Yes, I am Lord open to
instead of cancellation? Are
Yes,
you
yes.
amenable to that?
Yes.
I'll just, I'm just taking that assurance.
Kindly give him 1 minute.
Yes.
Lord, I understand to seek an amendment, we'll have to produce an agreement with the buyer.
Oh,
So
that is also
that-
not sure.
That,
Tuticorin is also-
that, Lord, today I don't have.
You are in stage of negotiations.
Yes,
with
but
Tuticorin.
Lord, I can give an undertaking to the court that, Lord, I'll take the vessel to Tuticorin.
Mr. Kaur, is there anything to prevent you from, I mean, with a permission, to leave the country even?
No.
I mean, I don't think there is anything.
Absolutely.
The perishable goods you have brought these, somebody does not purchase, you are at loss in fact.
I have to take it back. And bro, I can't, Lord, discharge it on high seas also. Then also, Lord, for pollution, I have to pay.
Yes.
So I have to, Lord, take it back to the port, Lord, where from it started.
So the importer who cancelled is in for a big damage claim.
Yes, actually, Lord, I am trying to save myself. I am in a soup.
Yes.
I am in a complete soup. I am trying to save myself. And Lord, even if the Tuticorin, Lord, does not mature, I can take it back home.
Very well.
I really, Lord, want to take it back home. If it doesn't mature, doesn't mature. But Lord, this is where we are. And Lord, two things, Lord, I wanted to point out. That, Lord, first point, Lord, on the maintainability, your Lordship, Lord, has very, the first principles are very clear. But Lord, there is a judgment of Justice Aniruddha Bose. I thought, Lord, I'll just place it there. It is followed by, if your Lordships, Lord, kindly, Lord, come to the page 3 of this judgment.
Maintainability on what ground?
On the ground of maintainability of the writ petition by a foreign company.
Oh, that.
That. This is what fell from my lord. Article 14, Article 21 talks about persons.
Yes.
But Lord, so far as
citizens.
Not citizens. 15, 16, 19.
Citizen.
That talks about citizen. That is the basis of this judgment.
Yes.
Page 3 onwards, this is what has happened. And Lord, there are 2 Supreme Court judgments also on the same principle. I thought, Lord, I can give your Lordship the reference, but this is the first principle.
Can Mr. Kaur, because this was, I dealt with this regarding a foreign national. No, that was long time back. I don't recollect the judgments basically. But I only remember that this regarding 14 and 21, probably this does not apply because it's a person.
That's absolutely.
And which is in consonance with the norms of international law and
this is not
all the conventions. And all.
Absolutely.
Yes.
This is because otherwise,
Correct. Yes.
otherwise, Lord, it will lead to chaos. Because if I go to Italy today for a,
Yes,
for a
exactly.
visit,
Exactly.
I won't be protected at all. I can be murdered there. That is not what the concept is. The
Yes.
concept is to give certain additional privilege to the citizen.
Yes.
But at the same time, Lord, not to ignore, Lord, the persons who are non-citizens or aliens.
Yes.
Now, Lord, that being the position, this is Lord what I want. If your Lordship kindly look at my prayer. Page 23.
Mr. Dev, would you be taking the point of maintainability on Article 14 and 21? I mean, foreign national. If you take that, then I'll ask Mr. Kaur to cite his judgments. Take your call on that. You didn't even know about this object.
This is, my lord, Article 19, my lord, because they are calling about, they are
Mr.
referring to their
Your Court
business.
better cite your judgments. Yes. Fully agreed. Yes. You can
It's
take
not
that
relating to Article 14 or
one. You
20.
can take that one. Yes.
Lord, I don't carry on business here. I cannot enforce my contract. And Lord, I cannot enforce my contract. That's a high seas contract, which I could not enforce by reason of the cancellation by the importer. So Lord, I want to take my vessels out.
Yes.
This is nothing to do with Article 19. And they are sitting on the vessel.
You're rather wishing not to do business here. I mean,
yes.
it's contra 19.
Absolutely.
You're saying I won't like to do business here, I'll take back.
Yes.
They have said that they want to do business at Tuticorin with another purchaser in respect of the same goods.
So
So that the Tuticorin officials will consider. What is your headache on that?
I will submit mine.
Because now they're trying to cancel or amend this present, whatever that is called. I mean,
Manifest.
manifest.
Manifest and the bill of lading.
manifest. So that's not a cause of action. That's not a ripe cause of action for your interdicting their business. They're trying not to do business here. Anyway, Mr. Court, cite your judgment.
Wait. Please
Just give the citations at least here.
I will just kindly see page 3 of this judgment. The second paragraph. On the point that a foreigner or a foreign company is not entitled to maintain a writ petition, there is no specific bar in the constitution that prevents a corporation incorporated outside the country to maintain a petition under Article 226 of the Constitution of India. Article 226 does not lay down any eligibility criteria based on citizenship of the seeker of the constitutional remedy. The basic requirement for invoking the jurisdiction of the writ court is that the legal right of the complainant should be breached by any person or authority who fits the description of a state under Article 12 of the Constitution of India. In exceptional cases, a person or authority who is not state within the meaning of Article 12 of the Constitution can also be subjected to jurisdiction of the writ court. A person who is not a citizen, however, would not be entitled to enforce rights which are preserved for citizen of this country only. Then, Lord, please come down. These decisions are not relevant. Last 5 lines. The sentence starting with the word, but in the event. Has your Lordship got that? Last 5 lines. But in the event an incorporated company being a juridical person suffers an adverse order emanating from a public body, having been passed without authority of law, then such a company would be entitled to apply for relief under Article 226 of the Constitution of India. Their claim, however, would not be based on any right preserved or guaranteed for citizen only under the Constitution or under any other law. This position would not change in respect of a company incorporated outside this country. A foreign company in any event has a right to sue, and there is no bar under civil procedure code also in that regard. In the Constitution of India, rights under Article 19 can be enforced by a citizen alone. So far as Article 14 and 21 are concerned, the expression citizen has been omitted, and the fundamental right guaranteed under these articles protect the citizens and non-citizens alike. For preliminary objection on maintainability of this petition on the ground is accordingly rejected. Now, Lord,
even 19, Mr. Court, does not exclude specifically non-citizens.
No, they don't.
It confers a right on a citizen,
Correct.
but if you can show there are ingredients of other articles or even directive principles, Mr. Court, there is no reason why it should not be afforded to non-citizens also.
Absolutely.
I mean, not in Article 19 form.
Absolutely. Not in Article 19 form,
19
but
form.
Parameteria. The rights parameteria.
Yes.
Of course.
Yes.
Of course. Lord, that
It does not debar a non-citizen from getting the right.
Absolutely.
Which it cannot in any.
No, so far as Lord, the fundamental rights is concerned, he can't. That's another question. But Lord, the rights, Lord, otherwise, a legal right, protection of a legal right. Here, Lord,
Article 21, is it applicable here? You are a juristic person.
I am a juristic person, but Lord, what
Personal
it says,
liberty or right to life does not apply to you directly.
not directly, but Lord, my
14
liberty, so far as the liberty is concerned, and Lord, this is absolutely an arbitrary action because Lord, they are sitting over it from June. They only one response they have said that we cannot because there are importers who have put in their bill of lading. I can understand they were trying to protect the interest of the importers, but Lord, here what is the fundamental reasons why they are not acting on it? Because Lord, now the importers say that cancel it. We don't. Of course, the contract is cancelled. They cannot ask for anything else, and Lord, they are not entitled to any customs duty also. So Lord, what are they? Why are they sitting over it? There is no explanation at all. Absolutely no explanation. So Lord, my humble submission would be that Lord, at the other 2 judgments, Lord, I'll just give the reference. I need not the Supreme Court judgment. There are 2 Supreme Court judgments. 2000 volume 2 SCC page 465. 2000 volume 2 SCC 465.
Yes.
Paragraph 27 to 30 and 35. And Lord, 2016 volume 6 SCC 456. Para 426.
2016?
16-6. SCC
pages
456. One is 465, the other is 456. Paragraph 426. Lord, this is to the same tune. What Mr. Justice Bose said, Lord, that is to the same tune. And I'm sure, my lord, I missed out on the judgment that your lordship is talking about.
No, that's a
But I missed
on a
it out.
different, entirely different.
But here, my lord, the issue is, my lord, a foreign company
Yes.
who's stuck up with.
So I refer to that judgment because there all these judgments were cited. That's why.
I see.
That was on a different footing.
I see. So, my lord, now, my lord, the law is quite well settled. Now, my lord, I am, my lord, saying, my lord, two things. First is, my lord, insofar as this, my representations are concerned with regard to cancellation of the manifest, and, my lord, the importers request, my lord, that they said that obviously they don't want, that can't, my lord, lie idle forever. And, my lord, they should cancel the manifest and, my lord, permit me to sell. This is the short point that I'm asking for. Your lordships may kindly
There is
see.
no, basically there is no reason also at page 1.
Nothing.
Since there are 20 line numbers and bills of entry, cannot be cancelled.
I presume, Lord, they are trying to protect, Lord, the importers.
We have also annexed the importers communication.
And that is nullified by the importers communication now. So, Lord, that's where it got stuck, and then it's not moving from there. And there in the ship, Lord, the captain is there, the crews are there, the ship, they're there, and I have to look after them also, because obviously, my lord, their day-to-day running expenses, their food, supplies, etc. Everything has to be taken care of. So I am saying, Lord, kindly, Lord, permit, Lord, order in terms of prayer, so that, Lord, we can sail.
Yes. Yes.
My lord, in this matter, my lord, the vessel arrived at Sagar Anchorage and completed the boarding formalities on 6/6/2023. And thereafter, entry inward was granted to the goods on 5/6/2023.
What was granted?
Entry inward.
31.
That means, my lord, the vessel is in the customs area. Now, lordship, in the meantime, my lord, 20 bills of entry have been filed by the 3 importers along with their IGM. Now, these bills of entry are under the process.
Bills of lading.
Bills of entry.
Entry.
Section 46.
Which has been filed under Section 46 of the Customs Act. All right, these goods are red lentils, which have been imported as per the mandate of the FSI Act, and as well as the requirement of the planned quarantine. Samples are needed to be drawn up so that those samples can be tested under the FSI Act and planned quarantine provisions, my lord. Unless and until these goods, my lord, passes the test under the FSI Act and the planned quarantine provisions, but these goods cannot be allowed to be imported. We have on
they are seeking a cancellation of the import.
Now that since they have filed the bills of entry, that cancellation.
Their entry point, if they try to enter it into some other point, suppose Tuticorin, those authorities will be, or you will also be dealing with there in Tuticorin.
Section.
But the present, they're asking for cancellation and going away.
Section 23 is standing on the way. I will show to your lordship. I will show to your lordship. Before that, lordship. Since the bills of entry have been passed, have been filed, and the bills of entry are under the process, and it could not be processed because of the deficiency on the or non-cooperation on the part of the importers to not allow samples to be drawn up. We have on umpteen number of times given them notice, kindly allow us to draw the samples. So
since
that
they don't want to have it sold here, what is the question of testing their samples?
Because there is something wrong, which has been detected and which needs to be cured. That is the reason they are now backing out of it.
Are you the authority for that?
Yes, ma'am.
Customs?
Yes.
What is wrong?
Lordship, kindly comes to Section 23. We are also.
There may be gold inside the lentils.
No. We have already, my lord, started an investigation into the whole issue, my lord. Lordship, kindly comes to Section 23 once.
23.
23.
Yes, Mr. De. 23.
Without prejudice to the provisions of Section 13, where it is shown to the satisfaction of the Assistant Commissioner of Customs or Deputy Commissioner of Customs that any imported goods have been lost otherwise than as a result of pilferage.
Sorry. Give me half a minute.
23. Lordship, 23.
I'm sorry. Yes, please continue. 23.
Without prejudice to the provisions of Section 13, where it is shown to the satisfaction of the Assistant Commissioner of Customs or Deputy Commissioner of Customs that any imported goods have been lost otherwise than as a result of pilferage or destroyed at any time before clearance for home consumption. The Assistant Commissioner of Customs or Deputy Commissioner of Customs shall remit the duty on such goods. I'm not on this, I'm on subsection 2. The owner or any imported goods may, at any time before an order for clearance of the goods for home consumption under section 47, or an order for permitting the deposit of goods in a warehouse under section 30 has been made, relinquish his title to the goods, and thereupon he shall not be liable to pay the duty thereon. So they have a right to relinquish it, but there are certain conditions when they can relinquish it. So mere cancellation of the agreement will not do. Lordship kindly takes the proviso part. Provided that the owner of any such imported goods shall not be allowed to relinquish his title to such goods regarding which an offense appears to have been committed under this act or any other law for the time being in force. Now Lordship kindly takes the writ petition. Lordship kindly comes to page 112, 113 and 114. The importers have unequivocally said and written in their letters that the goods are of such inferior quality that the goods cannot be transacted. My lord, we suspect that there is an offense to the tune that the goods will fail the test of FSI and PQ, plan quarantine. And that is the reason, my lord, they are not allowing the samples to be drawn up.
How could the importers presume that?
Of the importers, because the importers have filed the
They may
bills of
have an
entry.
apprehension on that, Mr. De, but how can they know that?
And there is a letter issued from one of the importers asking for us to investigate into the issue, alleging that in the past also such inferior quality of goods have come to India, and India has been used as a dumping ground for dumping all those goods. Therefore, it's more relevant over here and significant in view of such letters that we investigate into it and get to the root of it. Therefore, my lord, we have
disclose to them exact reasons. You are saying 20 bills of exchange, bills of such an entry.
Because unless and until the 20 bills of entries are finally assessed, and nothing can be done.
If they don't want to export the goods to India, then there is no question of your going into these questions of offenses, etc. Maybe, yes, they try to preempt you from having an examination. But if they don't want to sell it here, then does your jurisdiction come in?
The test of import will be the same whether it is Haldia, Kolkata or Tuticorin.
Yes.
The taste will remain the same.
Unless they try to import it, try to export it. The place of import, there is no place of import now because they're not wanting to export it at all.
They have proposed the place of import to be Tuticorin.
They are asking for a cancellation now.
They are asking for the cancellation of the IGM because the IGM is related to Haldia and Kolkata. They want to get it done at some other place. So now when the bills of entry are in process and the bills of entry are alive under examination and could not be assessed finally because of the reason that we have given notice to the importers thrice and there is no response from the importer's side for drawal of the samples. The drawal of the samples will allow us to go for the test further. The test will show whether the goods fail in the standard of FSI.
In Tuticorin, you don't have that mechanism. In Tuticorin, whenever they try to export the goods or make it or have an influx of the goods into India from whichever port, that port must have a customs there.
They have, even in Tuticorin, they must be having the test.
Must be having. So whenever it is done, the moment they try to have it enter into India, that moment you can take out your proceedings.
No.
If they don't want to export it to India, then where is the question of your assuming?
The bar is section 45. Because section 45 says when the bills of entry are pending, the goods cannot be dealt with otherwise.
Show me that.
Yes, ma'am.
23 proviso comes in, provided that the owner of any such imported goods shall not be allowed to relinquish his title to such goods.
Because
the question of 23 comes in, Mr. De, only when the goods are imported.
Yes, goods have been imported because bills of entry have been filed. So they are seeking for importation of the goods. They have already filed their bills of entry. That is why
import has been defined here in this act.
Yes.
Show me that once before going to the other section.
Imported goods.
When does it?
Lordship kindly comes to section 2, subsection 25.
Yes.
Imported goods.
Right.
And import is also defined. Lordship kindly comes to subsection 23.
Yes.
Import with its grammatical variations and cognate expressions means bringing into India from a place outside India. So it's a very wide term. So they have already brought it into India. They are into Indian territory, more precisely in the customs area. They have already filed their bills of entry, thereby showing their intention to getting the goods imported.
Do the sandheads fall in the high seas?
My lord, we have
Open
already,
seas.
no, it's not high seas. We have already allowed them to, for inward movement, we have given them the permission.
Have they shifted back to the sandheads from Sagar?
Probably. I'm not sure.
If they have, then they are on the, are they on the high
Sagar
seas?
Sagar is more closer.
No, yes, the sandheads are the sandheads on the high seas or neutral zone or whatever?
Within the custom, subject to correction again, my lord, I believe it is within the customs area. Again, subject to correction and confirmation.
What is the law of the open seas? I mean, sandheads we have to
They can, my lord, have any new contract on high seas.
Anyway,
But they cannot,
import is pretty wide.
new contract when they enter in customs area, and more so when bills of entry are pending.
Show me section 45, Mr. De.
Yes.
definition
Lordship, before that, it's pertinent that I should show to your lordship the definition of importer also.
Definitely.
Imported goods and importer.
Right.
Imported goods, lordship kindly comes to subsection 25. Imported good means any goods brought into India from a place outside India, but does not include goods which have been cleared for home consumption. So when the clearance for home consumption is pending, it is coming with the meaning of imported goods. Over here in the instant case, the status is same. It is imported goods because it is, my lord, clearance has not been given for home consumption. They have shot for the clearance because bills of entry have been filed.
This is the first section you should have cited, Mr.
Lordship, now if your lordship kindly comes to
An importer is also there.
Importer is defined in subsection 26.
Yes.
Importer in relation to any goods at any time between their importation and the time when they are cleared for home consumption includes any owner, beneficial owner, or any person holding himself out to be the importer. So the three importers have hold themselves out to be the importer.
Yes. What else?
Now, lordship kindly comes to page section 45. Clearance of imported goods is the heading of the chapter.
Yes.
Save as otherwise provided in any law for the time being, enforce all imported goods unloaded in a customs area shall remain in the custody of such person as may be approved by the Principal Commission of Customs or Commission of Customs until they are cleared for home consumption or for warehouse or are transshipped in accordance with the provisions of Chapter 8. So there are three options what that can be done when
For unloaded goods.
no, these are not unloaded goods, but these are there.
This is for unloaded goods, 45.
Further movement from after being unloaded.
Probably this is not applicable, Mr. De.
No, lordship kindly comes to subsection 2.
2 is circumscribed by 1.
The
One
person
says
having
save as otherwise provided in any law.
Customs area.
All imported goods unloaded in a customs area.
Yes.
all of the goods are lying within the customs area because the goods are with
Not unloaded. No, no. It's on their ship.
It's on their ship.
Unless those come off the ship, they cannot be said to be unloaded.
That's true, my lord, but they are that is within the ship. And bills of entry have been filed in respect of these goods.
Unless it is unloaded, 45 does not come in. 45 1 says if it is unloaded, then such and such. That is the difficulty. Are you saying that 45(2) is independent?
Customs
The
area. is
person
defined.
having custody of any imported goods in customs area, whether under the provisions of subsection 1 or under any law for the time in force. So subsection 2 is more wider. It is either under subsection 1 or any law for the time being in force. Shall keep a record of such goods and send a copy thereof to the proper officer. Now B is very relevant in the instant case. Shall not permit such goods to be removed from the customs area or otherwise dealt with, except under and in accordance with the permission in writing of the proper officer or in such manner as may be prescribed. So it cannot be dealt with.
This is Mr. They to avoid pilferage and all. I mean, inward movement, as Mr. Kaur put it. Just look into the entire intersection. Again, 3 says, notwithstanding anything such and such, pilfered after unloading, that apprehension has been.
No, when unloading, then to contain pilferage, subsection 3 has been
Either
interrupted.
under subsection 1 or under any law for the time being in force. There is no other law, I mean. So either it has to be, if it is the Customs Act, then it has to be 45(1). This is for unload. Anyway, I'll record your submission. Section 45, yes.
151, section 141.
Now, Lordship kindly takes section 45, kindly reads it with section 141.
145.
141. Conveyances and goods in a customs area subject to control of officers of customs. All conveyances and goods in a customs area shall, for the purpose of enforcing the provisions of this act, be subject to the control of officers of customs. The imported or export goods may be received, stored, delivered, dispatched, or otherwise handled in a customs area in such manner as may be prescribed, and the responsibilities of persons engaged in the aforesaid activity shall be such as may be prescribed.
Control of customs.
So the control of customs is over there. Now, Lordship kindly takes the trouble to come to section 46, subsection 4A. The importer, section 46, subsection 4A. The importer who presents a bill of entry shall ensure the following, namely, the importers have filed their bills of entry. Now, the importers are duty bound to ensure all these formalities. A, the accuracy and completeness of the information given therein. B, the authenticity and validity of any document supporting it. And C, compliance with the restriction or prohibition, if any, relating to the goods under this act or under any other law for the time being in force. The compliance and restrictions which I, my lord, trying to refer to your lordship, is the testing to be done under FASAI Act and plan quarantine provisions, which they have failed to do so in spite of 3 notices.
You also cite those statutes, sir. The specific provisions. Because you have indicated nothing in your response to them. There is nothing on record to indicate that you have even any apprehension regarding those acts.
No, we have given notice to the importers for drawal of the samples.
To them?
Yes, not to them, but to the importer, because bills of entry have been filed by the importer.
We cannot go by apprehensions in thin air.
Lordship, may I just read the notices that we have sent to the importers?
Importers' notices, are they relevant? Because they are the ones who are holding the goods. They want to go out. Whatever you wrote to the importers, even if the importers admitted anything, that is not binding on them. So they have written to you for this cancellation. Their cause of action is on cancellation. Suppose whatever may be your apprehension for whatever adverse inference you draw against them for the importer's conduct, that is not binding on them. What response have you given to them that yes, we apprehend that this is happening?
For us, the most important piece of document was the bills of entry which have been filed by the 3 importers, because the bills of entry has to be brought to its logical conclusion. Now, the bills of entry can be finally assessed and brought to its logical conclusion only after drawal of samples and after testing. Now, we are into the process of drawal of sample and for testing, which have been prevented by the importers. We have given notices on 24/7/23, 14/7/23.
You want to refer to any section for that? Bills of entry have to reach their logical conclusion, cannot be interdicted in the interregnum.
Lordship, take the trouble to take section 17.
17.
17. Section 17, subsection 2. Yes, subsection 2, my lord, I'm pleased. Right. The proper officer may verify the entries made under sections 46, because bills of entry are filed under section 46. Entries made under section 46 or section 50 and the self-assessment of goods referred to in subsection 1. And for this purpose, examine or test any imported goods or export goods or such part thereof as may be necessary. Therefore,
does that purpose come in?
Yes, my lord. Because for
revenue purpose does not come in.
Assessment of duty, because the bills of
one also.
Yes,
assessment of duty for that purpose.
Yes, an importer entering any imported goods under section 46. Here, the importer has imported the goods or seeking to import the goods by filing the bills of entry under section 46. The bills of entry are pending.
That is for the purpose of assessing duty.
Yes, my lord.
Where is the duty if they don't want to export it?
My lord, the duty can be nil duty or the duty can be something. but it has to be assessed because the bills of entry have been filed.
So can you use this testing sampling for the purpose of assessment of duty to fish out evidence for other offences which may have been committed by them?
I'm not on
Even
that.
if they have committed those offences.
I'm not on that, my lord. What I'm humbly trying to submit to your lordship is that these tests have to be done prior to the bills of entry are finally assessed.
For the purpose of assessment of duty.
Yes, my lord, because bills of entry have been filed only for the purpose of
There
assessment
is no
of
question
duty
of
and for
assessment of duty now. They want to withdrawal of that.
No,
They
when
don't want to sell it at all.
or when the bills of entry have been filed, when the bills of entry have been filed, my lord, it has to be assessed and it has to be brought to its logical conclusion. And for
It's
that,
like saying, Mr. They, that if I apply for a certified copy, it has to reach its logical conclusion even if I don't proceed with it. It's like saying that yes, you have to pay the assessed duty because I have assessed, because you have applied, I have assessed the duty, you have to put in the necessary fees and you have to get the certificate.
or there might not be.
I don't want to take the set. They don't want to sell it here.
Or in
They
the
want to go back.
or in the instant case, there might not be any duty, but it
Why are you indirectly indicting them? Directly indict them,
but in
charge them of any offense if they have committed and have them arrested. But why this roundabout process using the customs? It's a fashion now, Mr. There, to use some one authority to fish out evidence for another. And you cannot fish out evidence using the custom. I mean, the customs can fish out evidence for the police authority. Let the investigating agencies investigate and come to a logical conclusion if there is any basis. But customs duties for the purpose of assessing duties. Assess your duties for that purpose. You can test, sample, do whatever. They don't want to sell. You want to assess the duty even then. And you say it has to reach its logical conclusion. There are investigating agencies for that. Involve them, let them have their field day. I mean, 17 is specifically for assessment.
we are already into it. We are already investigating the whole issue, lordship.
Customs.
Yes, under customs that we can do so, lordship, and we are doing it.
FSAI violation also.
Or FSAI,
Other acts violation, how can the custom deal with that? You are saying the other acts are being violated.
or other because for this, my lord, unless and until lordship kindly takes the trouble to come to subsection 2 or 17 one more time.
Yes, absolutely.
An importer, I'm reading subsection 1, then I will place subsection 2.
True.
An importer entering any imported goods under section 46 or an exporter entering any export goods under section 50 shall, save as otherwise provided in section 85, self-assess the duty, if any, leviable on such goods. They have filed the bills of entry. Now comes subsection 2. What is required to be done if there is any restrictions, if there is any test, they have to overcome those states and restrictions. The proper officer may verify the entries made under section 46 or section 50 and the self-assessment of goods referred to in subsection 1, and for this purpose examine or test any imported goods or export goods or such part thereof as may be necessary.
How do you interpret for this purpose?
For this purpose, my lord, we need to examine the goods, whether the goods passes the test of FSI or plan for intent.
For this purpose, the purpose has been stipulated there in the previous paragraph for the assessment of duty.
Yes, my lord, for the
That is the only purpose for which you can sample.
Yes,
Examine or
the
test.
assessment of duty is the question comes only when they file their bills of entry. Unless they file their bills of entry, then my lord, the question
Anyway,
assessment
yes.
of duty will not arise. The
Very
assessment of duty may be nil, or the assessment of duty may be any amount.
right.
Now, lordship kindly takes section 11, subsection 3. Any prohibition or restriction or obligation relating to import or export of any goods or class of goods or clearance thereof provided in any other law for the time being in force, or any rule or regulation made, or any other or notification issued thereunder, shall be executed under the provisions of that act only if such prohibition or restriction or obligation is notified under the provisions of this act, subject to such exceptions, modifications, or adaptations as the central government deems fit. Therefore, my lord, the restrictions and prohibitions are to be looked into and to be taken care of. Therefore, my lord, those states are to be done, and those states' results are required for finalization of the bills of entry. Because they cannot be allowed to hop around from one place to other place. Now
Why
that-
can't they?
Uh,
They want to hop around. Let them hop around at their expense. They're expending fuel for that. Let them hop around. What is your problem?
Section 45 is the bar. Section 45 says that when the bills of entry are pending. the goods-
Section 11.3, does it say what you are saying? Please read 11.3 again.
Yes, ma'am.
Any prohibition or restriction or obligation, etc., relating to import,
Import or
export.
export of any goods or class of goods or clearance thereof, provided in any other law for the time being enforced, or any rule or regulation made, or any order or notification issued thereunder, shall be executed under the provisions of that act only.
Shall be executed under the provisions of that act only, if it is any other act.
Yes. If such prohibition or restrictions or obligation is notified under the provisions of this act.
I
Notified
mean,
under the provisions of
FSAI
this
Act has been notified under this act.
No.
If it is not notified, you cannot look into it. And
No.
if it is notified, even then it has to be under the provisions of that act.
Lordship, this has to be read along with section 17 subsection 2, because section 17 subsection 2 says tests or restriction, examine or test.
If it was section 17, Mr. De, it would be Justice Nizamuddin.
That is why I raised this.
This is
point.
not section 17.
Because
There is no question of assessment of duty. You are wanting to sample because they have entered into your cave.
Because one of the bills of entry.
Cave or cove, whatever.
Because of the bills of entry are pending its finalization, that is the reason why the whole issue has cropped up.
Anyway.
And whenever they are filing the bills of entry, they initially self-assess the goods and they file the bills
Is
of
there any
entry.
part to bills of entries being cancelled? You are saying they have to reach their logical culmination. Once an application is made, it has to reach its culmination.
Or subject to correction, my lord, the bills of entry cannot be cancelled at this stage, or it cannot be cancelled because it has to.
Show
be-
me something in law to substantiate that. Something, whatever. Where is the provision regarding bill of entry? At least show me that.
My lord, the
There may be
provisions are section 40, provisions of section 46. Even section 46(4)(a) I have placed before lordship. Section 46(4)(a) also talks about one of the compliances with the restrictions or prohibitions, if any, relating to the goods under this act or under any other law for the time being enforced. So even under FSAI or planned quarantine is putting some conditions. Section 4(a) of subsection 4(a) of section 46 takes care of it. Those are mandatory. They have to overcome that first. The restrictions and prohibitions and tests, all these issues are coming up in 3 sections, that is section 11 subsection 3, section 17 subsection 2, as well as when the bills of entry are filed under section 46 subsection 4(a). And section 23 says that when an offense seems to have been done, it cannot be released. A restriction has been imposed under section 23. And from their conduct, it seems that some offense has been done. Section 46 deals with the bills of entry and its modalities. And section 46 subsection 4 further states and puts an onus upon them that they should make truthful statement about the bills of entry. May I just read it for your lordship's convenience? The importer, while presenting a bill of entry, shall make and subscribe to a declaration as to the truth of the contents of such bill of entry, and shall, in support of such declaration, produce to the proper officer the invoice, if any, and such other documents relating to the imported goods as may be prescribed. So over here, my lord, the testings are very much required.
What are the provisions you're relying on, the FSAI Act and whatever? Give me the specific sections. What is the FSAI Act, by the way?
A Food Safety Act, my lord. Food Safety and Standards Act 2006. Import of all such edible foods products, including tea, domestic sale and manufacture of which are governed by Food Safety and Standards Act 2006 and rules thereunder.
Which is the authority to investigate under that? Customs.
Or customs can see if whether any infraction has been done or not.
How can the customs see that? What is the exact scope of operation of the customs?
Subsection 4A of section 46 gives us the right to see whether any infraction has been done or not. The testing is one such process. Because Lordship, the language is compliance with the restrictions or prohibition, if any, relating to the goods.
C, 4C.
Under, yes, C. Under this act or under any other law for the time being in force.
Right. And what other act, Mr. De?
Under Food Safety and Standard Act 2006.
Apart from that, what other act? You said 2 acts.
And other is Plant Quarantine Regulation of Import into India
What?
Order 2000.
Plant
Quarantine. Regulation of Import into India Order 2003.
Have you got copies of those?
I have only one copy, but it's an extract.
You can take out
not
photocopies.
in details, not in details. I can.
No, just take out photocopies and
I shall.
regulations.
Under Plant Quarantine.
Regulation.
In bracket, Regulation of Import into India Order. After the bracket, it comes Order 2003.
Right. It's a Government of India circular or order, government order.
It's an order.
Right. So you say there is violation of these two under 46(4)A, you can. And since they are importers of goods, and the goods are within our territory, so you can do that.
And Lordship, another thing I have already, my lord, submitted to your Lordship. Under section 45, there is a restrictions. They cannot deal with the matters when the bills of entry are pending.
They cannot?
They cannot deal with the matter, the goods or the matter when the bills of entry are pending for adjudication or for final assessment.
Right.
These are my submissions. These are the grounds.
And what about foreign national maintaining?
Since section 19 does not allow them, there is a
19 does not allow.
19 does not allow them, there is a bar.
Get your point, yes.
And at the cost of being chastised by your Lordship, I have brought the appellate side rules. Already your Lordship has indicated.
Yes, I wanted that actually.
I just want to show to your Lordship one thing.
Yes.
Subject to what my Lord says, my Lord. Again,
141.
Lordship kindly comes to page 141. Under the heading revenue, what are the subjects which comes under revenue has been given. Revenue includes income tax, sales tax, cess, customs, foreign exchange, excise, miscellaneous. It's at page 141 and 142.
Yes. Yes. 123040. Yes, thank you. Appellate side rules structure like this. Plus custom sector দিয়ে দেবে একটা বলে দেবো. Yes.
One fundamental point is that the property in the goods have not passed to the importers. Kindly see page 33 because I have not received my
No,
price.
that has not passed. There is no doubt on that, Mr. Kaur. But the difficulty is for you. Yes, you are in customs zone.
Yes, I'm in customs zone. Lord, I'll deal with this point.
46 and 45 particularly.
I will before that, please take note of section 2, subsection 11, which describes what is the customs area. That is the most important aspect. Section 2, subsection 11. Customs area means the area of a custom station or a warehouse and includes any area in which imported goods or exported goods are ordinarily kept before clearance by customs authority. So, my lord, I will have to unload the goods, keep it somewhere, get the clearance, and then only, my lord, I will get it. Your lordships will get this.
No, but imported goods, please see 25. Imported goods are of a wider footing.
That, my lord, I'll deal with.
Wherever imported goods are kept, and imported goods include any good brought into India from a place outside India.
Provided, my lord, the import is complete.
Provided that rider is not there in
no,
the
I tell you that is my lord explained by a 3 judges bench of the Supreme Court. I'll just place that judgment because my lord, unless import is complete, Lord, a goods lying in a high seas Lord, can't be allowed to be, they are not allowed entry, because if your lordships come back to section 31 once.
Sanded is sanded high sea.
Yes, this is near the high sea, Lord, there's a parking bay. That is where the ships are parked. Because, Lord, they are not allowed to come in unless.
You commit an offense in Indian law in the high seas, would you be prosecuted by India or would you not be?
Lord, if it is, Lord, on waters outside the Indian territory, the territorial waters is what guides, Lord, a crime. If I'm not, if a crime is committed, it will be based on a territorial water. If I have committed.
So none of you have addressed the issue, Mr. Kaur, whether the area where the ship is now, whether that is high sea or not.
I'll just, Lord, immediately address that, because I find, Lord, my learned friend has made a lot of submissions on various sections. I'll take your lordships to this section. But, Lord, first, kindly, Lord, look at section 31 first. Please come to 31. Says the master of a vessel shall not permit the unloading of any imported goods until an order has been given by the proper officer granting entry inwards to such vessel. My learned friend has harped on this, that, Lord, the entry inward has been given. Now, Lord, let us say we have reached up to 31. Then, Lord, please see 32. No imported goods required to be mentioned under the regulations in an arrival manifest or import manifest or import report shall, except with the permission of the proper officer, be unloaded at any custom station unless they are specified in such manifest or report for being unloaded at that custom station. So, Lord, we have reached up to 31, but 32 did not take place. The import, Lord, I would not permit my goods to be unloaded unless I am paid. At that stage, Lord, the contract got cancelled. So, Lord, the jurisdictional point that my learned friends are taking with regard to sample, etc., it has not passed on to the importers. Now, Lord, please take the sections which my learned friend relates. Custom stations, kindly take 213, section 213. Kindly take section 213. Custom station means any customs port.
Any customs.
Not covered.
Or land customs station. Or land customs station. Lord, I have to unload the goods at a place. Lord, I am in the sea. Where will I unload the goods? My learned friend says, you are in customs area. Very well. Can I unload the goods there? I have to bring the ship to the point, Lord, where I can unload. So, Lord, I have not reached the unloading point. That is why I showed your lordship section 32. I have come up to 31, but 32 is not there. Now, Lord, your lordships may kindly come to the sections that my learned friend relied upon. Please see section 23 and 45. These are the two sections, Lord, on which my learned friend has heavily relied. Let me, Lord, show section 23. Kindly, Lord, see, without prejudice to the provisions of section 13, where it is shown to the satisfaction of the Assistant Commissioner of Customs that any imported goods have been lost, otherwise than in result of pilferage or destroyed at any time. This is not applicable for us because, Lord, it has not landed as yet. Question of pilferage does not arise. Then 2, the owner of any imported goods may, at any time before an order for clearance of goods for home consumption under section 47. Home consumption is, Lord, from custom station when it is, Lord, taken out for consumption. It says at that stage or an order for permitting the deposit of goods in a warehouse under section 60 has been made, relinquish his title to the goods and thereupon he shall not be liable to pay duty. Lord, these are all, Lord, post import. Kindly see, owner of any imported goods. The importer has to be the owner of the imported goods. And he must have, Lord, unloaded the goods in the customs warehouse from which it is trying to take the goods away for home consumption. This is the situation. 23.
The owner of any imported goods is you up to this point before the clearance is granted.
Clear?
It's an imported good. You are the owner. This rather confers a right on you to relinquish your title. But this is subject to the proviso, which Mr. They also relies on,
Provided
which says
owner of any
Shall
such
not be
import.
allowed, you will not be allowed to relinquish your title regarding which any offense appears to have been committed.
Lord,
Under this act or any other law.
I have
That
not,
is what.
this is not a situation where, Lord, the goods have been imported. Lord, I am not the importer of the goods. I am the owner of the goods. I am the exporter of the goods. The import is not taking place. That is the situation I am in. Please kindly have a look at, Lord.
No, 225 says imported goods means any goods brought into India from a place outside India, but does not include goods which have been cleared for home consumption.
Lord,
So as of now, you are the owner of the imported goods.
Lord, I am the owner of the goods. But
Of the
Lord,
imported goods under 225.
very well. Let us accept the fact.
You can relinquish your title.
I can relinquish my
But
title.
you can't if these things happen, the other offenses are there regarding any other act.
Right. But Lord, this jurisdiction, the customs gate, Lord, once the import is complete, your lordships may kindly, Lord, once again come to the question. First, Lord, 23(1). It says, without prejudice to the provisions of section 13, where it is shown to the satisfaction of the Assistant Commissioner of Customs that any imported goods have been lost otherwise than a result of pilferage or destroyed at any time before clearance for home consumption. Lord, clearance from home consumption, kindly, Lord, come to section 13 now. Please come to section 13. It says, if any imported goods are pilfered after unloading thereof, and before the proper officer has made an order for clearance for home consumption or deposit in a warehouse. So, Lord, unless 13 is complete, Lord, 23 does not apply at all. Lord, with greatest of respect to my learned friend, Lord, all the sections he has shown, please come to section 45. This all contemplates when, Lord, the jurisdiction is taken by the customs by, Lord, unloading of goods. Kindly, Lord, see section 45. I don't know, Lord, why they are resisting it so much, because, Lord, I don't want to get the goods imported. Kindly, Lord, see 45. Restriction on custody and removal of imported goods, save as otherwise provided in any law for the time being in force, all imported goods unloaded in a customs area. Now, Lord, again, your lordship sees the definition of customs area in section 211. Shall remain in the custody of such persons as may be approved by the Commission of Custom until they are cleared for home consumption or warehouse or transfer. Lord, I have not been paid my price. My goods, they want to take control of my goods. This is an impossible situation. I say, Lord, even 45, my learned friends have relied upon 45 extensively. Kindly see 45, 45 too. These are situations where the imported goods has reached the customs area. Control is with the customs. Goods having been unloaded from the vessel to the customs area. All the sections, your lordships may kindly see section, Lord, 141. Section 141, on which my learned friend has relied. Again, Lord, it says, all conveyances and goods in a customs area shall, for the purpose of enforcing the provisions of the act, be subject to the control of officers of customs. So, Lord, we will again have to look at the customs area. Section 2. 141(2). Kindly, Lord, take yes. The import or export goods may be received, stored, delivered, dispatched, or otherwise handled in a customs area in such manner as may be prescribed and the responsible person. These are all, Lord, post-unloading situations. All. Every section, Lord, my learned friend has relied upon is a post-unloading section. And Lord, even the testing, the samples, kindly, Lord, have a look at section 17 now.
What about 46(4)(a)?
46(4)(a). Kindly, Lord, have a look at 46(4)(a). This is, Lord, 46 is first, Lord, when the importer wants to bring in the goods, he has to first, Lord, put in the bill of entry. That is 46(1). Then Lord, kindly see the proviso. It says that it can be allowed to be presented in any other manner, right? Then Lord, please come to 46(4)(a). It says the importer who presents a bill of entry shall ensure the following, namely A, B, and C compliance with the restrictions prohibition. Now, Lord, the point is that these compliances are when he is not actually importing the goods. If he is not importing the goods, none of these applies. Question of how can the question of the importers ensuring this applies when he is not importing the goods? Lord, I really, Lord, I really will not fail to understand the argument that, Lord, although the import is not taking place, but Lord, the Customs Act has to be, Lord, complied with in its entirety. This is, Lord, the crux of the matter. Lord, I'm saying, Lord, again, that, Lord, I never expected that there'll be so much of resistance, even if I don't want to import the goods. I don't want the goods to be imported. Lord, if your lordships kindly have a look at, Lord, the one other section. Kindly, Lord, come to subsection 4. The importer, while 46 subsection 4. The importer, while presenting a bill of entry, shall make and subscribe to a declaration as to the truth of the contents of such bill of entry, and shall, in support of such declaration, produce to the proper officer the invoice, if any, and such other documents relating to the imported goods as may be prescribed. These are all when the importation is maturing.
In this context, you are the importer. You are not the importer.
I am the exporter.
Now, who presented the bill of entry?
The importers.
Now, here there is a subtle dilemma, Mr. Kaur, because if you look into the definition section,
yes,
2220 defines exporter. That is for the purpose because customs covered both exports and imports by Indians. So that in 20 exporter in relation to any goods at any time between their entry for export, that pertains to exporting goods. Indians export. Now in 26 to 26, importer is defined. Importer is in relation to any goods at any time between their importation and the time. Importation has also been defined. Import means bringing into India from a place outside India. You have brought it into India from outside India. Now, importer in relation to any goods at any time between their importation and the time when they are cleared for home consumption, which is your case. It is in that scenario, the goods. It has come into India.
No, Lord. Subject to correction again.
Yes.
Lord, my situation is my goods are in the vessel. It's lying in the sandhead. It has not been unloaded as yet. It has not been unloaded as yet. Now, Lord, so far as the importer is concerned, there are 3 importers, 7, 8, and 9. They have, Lord, put in their bill of entry. But as on the date when the bill of entry was put, there was a contract by which they were willing to accept the goods. The situation changes. Once the Lord ship comes, by that time the situation changes. They don't want to take the goods.
Yes.
This is the situation they are in. And Lord, your lordships may kindly see. Now the crux of the matter is, was the import complete as on the date my ship entered the sandhead or came to the sandhead? That's the short point, because Lord, all the sections that my learned friend has shown talks about the customs area, goods being in customs area. Because Lord, until the goods reaches the customs area, even a dutiable goods no duty is paid. It is only when, Lord, the goods reaches the customs area, the formalities with regard to the...
Mr. Kaur, do you say that you are not bothered with the bill of exchange at all?
I am not. Bill of entry. I am not.
Bill of entry, I'm sorry.
It is not my document.
Very good.
My document is...
You want your import manifest that to be cancelled.
That's all. That's all.
From your end, that is what you want.
Absolutely.
Regarding the bill of exchange, it has been initiated. Let it be taken care of by the importer.
By the importer, whatever steps they want to take, let them go against the importer. I have no difficulty, because it is at the instance of the importer that I am suffering. Today, Lord, my sufferance is at the instance of the importer. So, Lord, I am not bothered with the bill of entry at all. And Lord, on that the question, Lord, when the import is complete, kindly give that judgment. Lord, kindly have a look at this. Lord, this is a 3-page judgment.
Yes, yes, that please judge.
2000 volume 10 SCC page 228 at an extra copy থাকলে দিয়ে দাও. Lord, kindly come to paragraph 6. Lord, kindly take the last 6 lines. The sentence starting with the word, the import would be completed. Has your lordship found?
Yes.
Only when the goods are to cross the customs barriers, and that is the time when the import duty has to be paid, and that is what has been termed by this court in sea customs case as being the taxable event. So, my lord, the importation is the taxable event. And Lord, importation is complete when it reaches, Lord, the sea customs, when it goods cross the customs barriers. Crossing the customs barrier is when it is released for home consumption. That is the stage, Lord, when the import is complete. And Lord, today, Lord, it is in the ship. And I am only concerned with my manifest. I want, Lord, my manifest to be cancelled. This is my humble
So the definition of imported goods very well takes care of the point that the goods have become amenable to home consumption. Once the goods are ready for home consumption, it is no more imported goods. This has been defined in the definition itself.
Mr. Kaur, I'll try to be as fast as possible on this because this is the only legal point involved.
Only
I'm not directing affidavits in this. I'll pass my order. I'll take 1 or 2 days.
No, absolutely.
These so many
Absolutely.
I told you because you have an urgency here. Yes.
Absolutely, my lord. That's the reason, Lord, I have been extremely candid to your lordship.
I'll close it. Arguments are concluded. Judgment is reserved in the matter. If it is satisfied today, we kept on record. Mr. They please, if you can, please hand over those. The Fasai and the.
Copy I'm handing over, lordship, but there is a marking.
Thank you for that. এটা ওর মধ্যে ঢুকিয়ে দাও সব নিয়ে সব ব্লক স্টক ব্যারেল পাঠিয়ে দাও ডাকো অ্যাভেলেবল তো আমাদের হ্যাঁ আনতে পারি yes এবার তো অরিজিনাল
Item number 23, your lordship. This matter has been mentioned, your lordship. I've been served with a notice whereby within 7 days I have to return my credential certificate that is expiring today, your lordship. Today, your lordship.
এটা নিয়ে নাও এমিরেট
23.
Yes.
23, your lordship, appear for the petitioner.
This is the last appellate side matters. Appellate side matters are released. After this, I'll take up origin.
Lordship, this is my affidavit of service. All the respondents have received.
Yes. Anybody appearing for the respondents? You are appearing to appear for
KMDA. Lordship, KMDA is the answering respondent, your lordship.
Yes. What is the matter?
Lordship, the impugned memo is at page 176. Lordship. This is dated 27th July 2023. It is issued by the Chief Engineer SD and SWM Sector KMDA. Respondent number 4. Subject is withdrawal of credential certificate issued by such and such KMDA. Sir, in inviting reference to the above mentioned subject, I am directed to inform you that your reply given vide memo number such and such dated 26 June 2023 is not satisfactory in response to the show cause notice issued from this end vide memo number such and such dated 23rd June 2023. I am therefore directed to inform you that as per directions of the competent authority that the certificate issued to you from this end vide memo number such and such dated 6 September 2021 is hereby revoked. I am further directed to request you to return the original certificate within 7 days positively. So, Lordship, what has happened, your Lordship? This was pursuant to a tender, your Lordship. I have participated. Lordship, the tender is at page 55.
Yes.
Lordship, may kindly takes page 55. This is issued by
the Kolkata Metropolitan Development Authority. Lordship, at the very first, in block, it is written bio-mining of legacy waste and land reclamation of dump sites utilizing scientific method located at different municipalities across West Bengal on turnkey basis. So this is the KMDA which has its clusters where under the several municipalities which are coming under, and I had pursuant to the tender, accordingly I've qualified, and your lordship, work orders for several such municipalities was issued, which are from page 135 onwards. Lordship, may kindly takes page 135. Lordship, this is dated 17th of February 2021. So Lordship, pursuant to the work order of February 2021, which was issued in respect to your Lordship, kindly take subject, letter of intent come work order for the work of biomining at Bankura and Sonamukhi municipality in Bankura district. Lordship, this is for the district of Bankura, and as such of this same date, there are several similar work orders issued, which is at the next is at page 140 for Bhattacharya, Halishahor, Kachrapara, and Garulia municipality, that is page 140. The next such work order is at page 145. Which is for Chandannagar, Hugli Chinsura municipality.
Yes.
The next is at page 150. Kalna Memory municipality at Purbo Bardhaman.
Yes.
And then page 155. 155, it is for Moheshtala, Bojboj, Diamond Harbour municipality in South 24 Parganas. So all these zones are coming under KMDA. Lordship, and the last is at page 160 for Panihati, Khordha, Titagarh, and Barakpur municipality in the North 24 Parganas. So these were the respective areas which KMC considered and had accordingly given me the work order. The Lordship, what has happened? I was working pursuant to this work order. The
This
date
was
is
by a
very
single tender.
single tender. Lordship, this was Lordship, these work orders were issued in the month of February 2021, and I was continuing with the work. Ultimately, your Lordship, page 165.
Yes.
Page 165. Dated 6 September 2021. This is the credential certificate which they have sought to cancel. Lordship may very kindly takes. This is to certify that MS such and such, having registered office at such, have successfully set up and have been operating 5 municipal solid waste treatment facilities for bioremediation and biomining of legacy waste of dump sites utilizing scientific method on turnkey basis, each with a capacity of 600 metric ton per day at following locations across West Bengal. So my first submission is that, your Lordship, this credential certificate was issued in the month of September upon observing my work done from the month of February 2021, and these are the respective municipalities.
Yes.
And it was also specifically recorded that this working on scientific method with the capacity, your Lordship, this capacity word is very essential, capacity of 600 metric ton per day. They were satisfied. I have rendered work for this municipality, and this credential certificate was issued. Lordship, the next portion. They have successfully completed bioremediation of legacy such and such 6.10 lakh metric tons up to 31st July 2021 at the following sites across West Bengal. So, Lordship, placing this, your Lordship, this certificate is issued by KMDA, a statutory body. This certificate was issued pursuant to the work order, observing my work, an inspection done, and then this work order was issued. What happens, your Lordship, thereafter? Suddenly they realizes the very next page, Your Lordship, 166. They realize on 23rd June 2023, that is after almost 2 years, a show cause is issued. Lordship, the basis of the show cause is no complaint. Just a whim of the KMD authority and a show cause comes.
What is the allegation? in this?
Lordship, may I place it? Whereas KMDA had issued work orders for 6 clusters consisting of 17 ULBs across the state of West Bengal for executing of the work of biomining using scientific method. So they admit the first thing. And whereas the certificate in question was issued wherein it was mentioned that you have successfully set up and operating 5 municipal solid waste treatment facilities for bioremediation and biomining of legacy waste with 600 TDP capacity and also successfully completed bioremediation of legacy waste of 6.10 lakh MT. So this is reflecting of their certificate, this language. Lordship, the next para, which is very important. And whereas it is found from the records that neither you have completed 6.1 lakh MT bioremediation, nor you have set up and operating 5 municipal solid waste treatment facilities with 600 TDP capacity by that time, and you were fully aware about the fact. This cannot be treated as credential certificate. Lordship, pausing here for a moment, Your Lordship. A certificate is issued upon inspection after a span of 2 years without any complaint, without any nature of hearing, without any inspection, nothing. This order has arisen only out of this sheer whim and their fancies, Your Lordship.
Please, Ghosh, let us complete with this
Lordship.
show cause. Yes.
And whereas it is learned that you are submitting the certificate in question as credential certificates to various organizations during participation in tender, submission of such document for tendering purpose is enough to create doubt in the mind of the officials of the organization where you are submitting the certificate in question. It also affects the image of KMDA in public domain. Now, therefore, the undersigned is directed to show cause as to why you have used this certificate instead of immediately bringing it into the notice of the competent authority of KMDA for appropriate course of action under KMDA's end, and the undersigned is further directed to show cause as to why the aforesaid alleged certificate as submitted by you as credential certificate will not be cancelled by KMD authorities. Your reply is in writing from you or any person authorized from your end for this purpose should reach the undersigned within 5 days from receipt of this letter. So thereafter, I offer my reply, which is at the next page, Your Lordship, page 168. This is my detailed reply, and the outcome is that the order of page 176, 27 July 2023, where no reason, no hearing, nothing, and it comes out to be the credential certificate has to be returned, which was issued in the year 2021. I have worked my 17 areas, Your Lordship, with regard to this credential certificate, which was issued with respect to 17 ULBs across the state. They are existing, the service is being provided, the certificate is issued by the KMD authorities, no complaints ever raised, nothing has weighed in between. It's a sudden show cause of 23rd June and a cancellation, which is absolutely a non-speaking order. 27 July 2023, Your Lordship, it's an absolute non-speaking order, which only says that your reply is not satisfactory and hence you have to return the credential certificate within a span of 7 days.
So page 173 onwards is your, you have annexed the guidelines regarding environmental standards
Lordship.
to show that you have complied.
Lordship, that has nothing to do with the
Directly
credentials,
nothing.
no, Lordship.
Okay.
It is, the guidelines are with regard to my functioning. Lordship, the show cause nowhere states that there is any violation of any of the guidelines.
You are not given any hearing, but you are given an opportunity to reply.
Only a reply.
Very.
Lordship, and Lordship, the reason of placing the show cause, your Lordship, the show cause could have been issued that there was any violation or on the basis of a complaint received. Lordship, the show cause states that I have given you the certificate on the understanding that you have done such and such work. And that certificate, they have never felt that it was issued wrongly or there was any misrepresentation on my part. Never felt that. And it continued. Suddenly, after a span of 2 years, there was a sudden necessity to feel.
Is there any bar anywhere in the tender terms or anywhere that you cannot use these credential certificates for other tenders? But that is also one of the grounds.
Lordship, it is a certificate I am issued. Now, what is the statement? This is also very striking. You are placing it before other tendering authorities. Is there any bar on a company functioning in the state of West Bengal? Can that company not place that credential certificate in regard to other tenders in other states? My answer would be, your Lordship, they can and they will. Because for the other tenders which are floated in state of West Bengal, they also invite show your credential certificates for the work done.
Apparently, that is the purpose of a credential certificate.
Lordship, I'll be only relying on one judgment.
Yes.
$785. 785. Lordship, 2010 4 SCC 785. Lordship, I'll only place one paragraph, your Lordship, and I'll hand over the book, your Lordship.
Yes.
The entire judgment speaks of the non-speaking order. Any order which has to be passed, it has to be passed with a reason. In exercise of the powers of judicial review, the concept of reason.
Which paragraph is this?
Lordship, I'm reading para 12. Lordship, this judgment perhaps refers to all the judgments regard to that. Orders, actions has been enforced equally by the foreign courts as by the courts in India. The administrative authority and tribunals are obliged to give reasons, absence whereof could render the order liable to be assailed, your Lordship. Thus, it will not be far from an absolute principle of law that courts should record reasons for their conclusion to enable the appellate or higher courts to exercise their jurisdiction appropriately and in accordance with law. Lordship, the judgment speaks about any nature of order, be it passed by the authority, any statutory authority, be it passed by any.
But there are also other judgments.
Other judgments.
Against you that in every case there need not be an empty formality if it is not required otherwise. But generally that is the settled principle of
Lordship.
reason.
Lordship.
Very.
Lordship.
So let us hear Mr. Bandhu.
Lordship.
Yes.
Mulad, on facts, Mulad, I'll address on facts first. Mulad, kindly takes from page 135, which my learned friend placed, the work orders. Mulad, the date of the work orders are from 17th February 2021. All these work orders have the same date. But kindly takes as an example, page 137, clause number 10. And this Mulad is for Bankura and Sonamukhi municipality.
Right.
That the time for completion of the work is 18 months, 3 months for machineries installation and 15 months for biomining from the date of issuance of formal work order. This is the work order. That is from February, the time is starting. 3 months is for installation of machinery. That is up to May. And 15 months thereafter to complete the work. Now, Malad, similarly, at a progression of every five pages, Malad, that is 142, 147, similar clauses are there, and your Lordship will find, Malad, on an average, apart from Malad, Kalna, all other Malad, the Bhattapara, Kachrapara, and Halishahar and Kalna, Malad, all others are 15 months to complete the work. These 4 are for 9 months. In any event, none are within September. Now, Malad, your Lordships will also find that the total volume of legacy waste, which is to be removed from these municipalities, Malad, is also mentioned otherwise in the tender, but I'll not take your Lordship through that, Malad, because in the Malad, the certificate, which is the subject matter of the writ petition, is already mentioned. So, Malad, what I'm trying to indicate here is that in February, the work orders are issued
till May is installation of the machinery, and then the actual work starts from May. The certificate is issued in September. That is only within 4 months of working. Now, my lord, kindly comes to the certificate at page 165.
7 months of working within.
No, 4 months.
Why do you say that?
February plus 3 months is installation of machinery.
Correct.
Then the work actually starts. Then kindly takes, my lord, the second box in the certificate. For Bankura municipality, the tendered quantity is 2,40,829 metric ton, and this is to be removed in 15 months. Within 4 months, my lord, the contractor appears to have removed 80% of the waste. Now, my lord, next one, Maheshtola, is 2,30,000, and the removal is more than 50% everything within 4 months. Basically, my lord, on an average, 70 to 80% according to the certificate, 70 to 80% work has been completed by the contractor already, which work is to be completed in 15 months. That is August of next year. August of next year, 15 months. Within September of that year, according to this certificate, it is completed. Now, my learned friend has repeatedly used the word credential certificate. Your lordships will not find from this certificate that it is in any way a credential certificate. At the most, even taking the certificate on face value and taking that every data in it is correct, what it says is that they have successfully completed remediation of legacy waste quantity of 6.10 lakh metric tons up to 31st of July 2021 at the following sites across West Bengal. So this is not this work of 80% completion is not in September. It is within 2 months of installation of machinery. In any event, kindly takes after that, we are satisfied with their performance so far. Whatever they have done, that is it is not a completion certificate. It is not a completion certificate. It is only a status certificate at the best. My learned friend gave an example that while participating in tenders, contractors, intending bidders need to give certificates, my lord. But rarely have I seen a requirement of giving a status certificate. Generally, the requirement is of a completion certificate. But what happened in this case is that after procuring this certificate, the petitioner participated in a tender in Cuttack municipality, projecting this to be a completion certificate. Cuttack municipality has cross-verified it from us. Now, this is according to the petitioner, it is on our whims. It is not so. On that confirmation that they sought, when we revisited the certificate, we saw that there are several discrepancies in that. For which purpose it was issued, that is to be ascertained by us also. For which purpose it was issued. But your lordships will kindly see that reason is also mentioned in the show cause notice at page 166. In contradiction to the submission, that is, it is absolutely on our whims and fancies. Fourth paragraph says that, and firstly, third paragraph, last line is important. This cannot be treated as a credential certificate. This credential, unless the work is completed, the credential, how can it be ascertained? I ask this question to myself. I can do 80% work for my client and then I can return the brief. I can say I will not do the work. That can I ascertain my credential unless I complete the work. And whereas it is learned that you are submitting the certificate in question as credential certificate to various organizations during participation in tender. Maybe not in so many words that which municipality, etc. they have done, but our basis is there. Submission of such document for tendering purpose is enough to create doubt in the mind of the officials of the organization where you are submitting the certificate in question. It also affects the image of KMDA in the public domain. They understand director show cause so and so. So, the basis is amply clear that why we have given it. At least the petitioner who has participated in the tenders knows where he has participated. It is not unknown to him. But then comes his reply. In the reply, the petitioner says, kindly takes 169, paragraph 4. I can take your lordship through the Central Pollution Control Board, the entire guidelines. But in short, they have admitted what is the process. That is in paragraph 4, it appears from the above that bioremediation is a part process. And biomining is the complete or total process. I will kindly come back to the certificate. 165. They have successfully completed bioremediation of legacy. They have not successfully completed the biomining. KMDA VDA, then I'm coming back to 169. KMDA VDA memo number so and so has issued certificate for successful completion of the part process called bioremediation and not for biomining, which is the total process. We received the work order of biomining of legacy waste and land reclamation of dump site method at 6 KMDA clusters comprising of 17 urban local bodies on 17th February 21. Clause 4.1, page number 26 of the tender states that the treatment and disposal of legacy waste so and so will be done by so and so. We started
whatever you have stated in your certificate, they are not deviating from that in their report.
They are not.
Basically, no.
What we are trying to say in the show cause is that you kindly do not use it as a completion certificate.
Now, you have made it very clear in your certificate. Two things are very clear.
Yes.
One is that they have successfully completed only the bioremediation of legacy waste.
Yes.
Up to that date. Up to July. 31st July. And the second aspect is the last sentence of your certificate, which says so far. Now, it's very clear. Now, up to this period, 31st of July 2021, I can accept your submission that it's not a completion certificate by any stretch of imagination.
Yes.
But why can't...
And also not a credential certificate.
What do you exactly mean by credential certificate?
Well, credential
it is not defined anywhere.
No, it's not. It cannot be defined here also. That
here also, right.
But the answer will actually take me to the legal point also. I'm coming to that.
Yes.
But the credential certificate has to be understood in the context of the tender where they have participated. Because that is the requirement is there. They have not disclosed that.
True.
When they saw in the show cause notice that we have mentioned that you have submitted this certificate in the various organizations, they have not disclosed the tender even before Lordship.
No,
that what was the requirement there?
What I was trying to say is this certificate, as you issued it, this contains truth. Nothing in this is incorrect. So
I will not make the submission. We are doubting that also.
It's not issued by you.
It is issued by us. Why? It may not be sacrosanct.
That you cannot now say on that ground. At least you cannot set aside.
Yes, but
this
certificate, does not induce them to change their stance in any event.
No.
But so, estoppel or promissory estoppel will not apply.
It is for the authorities who issue the subsequent tenders where they participate to ascertain whether this suffices their purpose or not.
That they have wrote to us. That they have written to us.
Whenever they write to you, you can clarify. How is the question of your image being turned?
No, when that has been written to us for cross verification, it has appeared to us also, that what they projected before other authority, it is a credential certificate for completion of the work.
But for that you cannot cancel that because it is true as it is true.
Then let me address that. The issue here is that.
Or we can put a rider that whenever they produce this, they have to clarify that this is not a completion certificate or something like that.
Issuance of this certificate the issue is that this issuance of this certificate is neither my statutory duty nor it is their statutory right that I must give a certificate.
No.
What is their right? Contractual right under the NIT is a completion certificate at best. So, what they cannot claim as a right, they cannot come before your lordships and say that now that it has been given to me, I will never return it. But probably that avenue itself is not available to them. First, they will have to show that getting this certificate was their legal right. But in a contractual relationship, they have asked for a status report. Let us take it that way. And we have certified that progress. That till now, they maybe, if the situation so arises, they can use it against me also. That till this point of time, you admitted I have done this work. There may be contractual problems also between us. But this, what is not their statutory right, they cannot take it and show it before another statutory authority or any authority or a public authority, private authority, that KMDA has certified that I am doing this work.
Suffer before that authority. How can you cancel that after issue?
No, but this usage, I can, because
that's an apprehension.
I have issued a certificate.
Yes.
I have issued a certificate which I was not statutorily bound to do.
No.
Today, I want to take it back. I want to take it back. What I am canvassing with your lordship is that they cannot come before your lordship and say that no, I will withhold that. I will not give it back. Malad kindly takes Malad the impugned order. What does it say? Malad kindly takes.
Lordship, at the very top
Arey,
of the impugned order
Take a seat.
written by you, credential certificate, not by.
Withdrawal of credential certificate issued by so and so. In inviting reference of so and so, your reply is not satisfactory in response to show cause. I am therefore directed to inform you that as per the direction of the competent authority, the certificate issued to you from this end is hereby revoked. I am further directed to request you to return the original certificate within 7 days positively. Well, they are here to say that I cannot revoke it and they will not return it. But this, even for that limited purpose, they will have to show some legal right. They can, a contractual admission, they are coming before a writ court trying to enforce something which is not even a legal right, let alone a constitutional right, a fundamental right. It's a contractual relationship arising out of the NIT and the work order. In that work order, I have given them a status report or a certificate. And I am today revoking it. They come before your lordship to say that I will not return it. But the issuance of certificate, if that right, if power is there, revocation, that power is also with me. They cannot say that I don't have that power. Otherwise, my lord, they keep on using it, which we think that it's a misuse. And whenever that clarification is sought, whether they give the disclaimer or not, we'll have to keep replying back to every authority saying that no, this is not a completion certificate. But first, at least, kindly, let us undertake the minimum exercise, that let them produce the tender in which they have produced it, and kindly let us examine the clauses whether that required a status report or that required a completion certificate. If that required a completion certificate, it will be ample
authority to do it.
But it will be.
You may say, yes, you are entitled to revocation. That is a good argument. But you don't have any authority what they do with your certificate before other authority.
No, you
have issued that certificate.
But we are not doing it on our own. The authority is writing to us. It is
a clarification every time. Every time a clarification is sought. Whenever some credential certificate or something is
right,
every time that is that does not. I mean, tarnish your image or something like that. Why?
But even assuming that part, that does not tarnish the image. Kindly takes the other part of it, other part of the show cause, that submission of such document, 166, submission of such document. No, sorry. It is learned that you are submitting certificate in question as credential certificate to various organizations during participation in tender. Submission of such document for tendering purpose is enough to create doubt in the mind of the officials of the organization where you are submitting the certificate in question. So this issue is to be remedied, my lord. But our only purpose is to remedy this issue. Otherwise, we'll have to write back to every authority saying what we meant. They have no, they cannot show any legal right that we were bound to give the certificate. They are only taking advantage of the fact that out of the contractual relationship, we have issued the certificate. They're trying to take advantage of the fact.
Why not estoppel in a sense?
Yes, because once we issue the certificate, we are not making them change their position in any way. This certificate does not induce them. They have not participated because of this certificate.
In any event, they would have participated. This is an addition.
Yes, because this is not a completion certificate at all. Unless, as I said, unless your lordship has gone through several tenders. It says that my work is for 1 crore. The credential must be 50% of the value, or 40% of the value, 20% of the value.
Right.
And that 20%, 30% is for a completed work. Nowhere, I have never found that you give me a status report that you are at least working somewhere, whether you complete the work or
not. Are they
not.
still doing this work?
Yes.
Yes.
Very
They're there.
Till
That
date.
contractual relationship is there.
Once the certificate is withdrawn, your lordship, thereafter, your lordship, we will be prevented
So,
from
Mr.
working.
Bandhaved, anything to add? You
No,
complete your
that is my.
Lordship,
Yes,
may I?
reply. Now only
See-
you, not Mr. Bandyopadhyay. So make use of your opportunity.
Lordship.
You have been disturbing him like anything.
I apologize, Your Lordship. Lordship, the very first, the certificate, whether it is a credential certificate or a completion certificate, Your Lordship, instead of going into that issue, Lordship, the language of the certificate is that this is to certify. So the KMDA chief engineer at that relevant point of time, a statutory body felt that now I can certify that the company has done this limited work till this period. And it has specifically recorded that only up to 31st July 2021, what has just been raised by my learned friend going into the issue of the metric ton of 240829, and they have completed within 2 months such 2 lakh work. Whether I'm putting this question to myself, is there any bar in my completing work? That's my first reply, Your Lordship. There was no by my second submission, Lordship, at that relevant point of time, the KMD authority never felt any dispute, any allegation, nothing with regard to my completion of this amount of work. This is a tender which is given for completion of certain metric ton. It is being misread, Your Lordship. It is 600 metric ton per day. Per day. Lordship, I'm once again keep giving stress on the word. 600 metric ton per day. So it is with regard to the work done till 31st July 2021 with regard to the work done for per day basis. So this interpretation is absolutely baseless. Now, Your Lordship, it is a credential or completion. Neither the tender do not provide for providing any completion certificate. There is no scope for providing any completion certificate. Lordship, in the year 2021, when this certificate was issued, neither I have sought for the same. It is the KMD authorities being satisfied with the work. It has certified.
How
It
do you
has
deal
not
with his
informed.
argument that you don't have a legal or statutory or constitutional right to have this certificate issued in the first place? So where is your right to challenge the revocation? I mean, their certificate they issued, they have revoked. Where is the scope? I mean, do you have a right under any law to have this issuance of certificate?
Lordship, now this certificate,
Yes.
it is coming as a matter of right to the petitioner, Lordship. Once this certificate was issued, certifying that I am in such a position, my right accrues from 6th September 2021. I'm putting this question to myself, whether the KMD authorities can come up and show a single letter where I have written that this certificate should be issued, it has to be issued, this needs to be issued. Nothing. The day the KMD authority decided, now we are going to certify that on 6th September 2021, he has completed this work. From that day, my right accrues. Now, once a certificate is being issued by the statutory authority, that can be revoked only by the statutory authority by showing any misrepresentation on my part. The ground taken in the show cause is that I have placed it before other authorities, whereby their image is tarnished. Lordship, that only raises one question, whether a statutory authority like KMDA, they might have several reasons to revoke my certificate. Can they take such a stand? Such a whimsical stand that it is tarnishing their image because this was placed before the Cuttack municipality. Whether the Cuttack municipality has made any complaint to KMDA in writing. If they have done so, let that be produced in course of today, Your Lordship. I shall withdraw my writ petition, Your Lordship. Let that be produced.
Don't take
No.
that risk.
Lordship,
Don't
nothing.
take that risk.
Lordship, perhaps I cannot, Lordship, make that submission in court, Your Lordship. What weighed in the mind of the KMD authorities to issue such a cancellation at a haste? 23rd show cause, 26th reply, 27th is the withdrawal certificate.
Right. Yes.
And Lordship, only one ground. It is the, Lordship, this order is a non-speaking order. And Your Lordship, with the term of credential or completion, Lordship, neither I wanted a credential certificate, neither I want a completion certificate. It is at their wish, they have exercised, they have given. Now, once this is withdrawn, Your Lordship, since I have submitted this on the promise, Your Lordship, what had fallen from Your Lordship, the principles of promissory
Estoppel does not
estoppel.
apply. Mr. Bandawat is correct on that. It does not apply because you have not acted on the basis of his promise.
Lordship,
So you would, in any event, you would have participated in the tenders. That's an additional
it's an addition.
arm in your armory.
Your Lordship, today I am given. Lordship, am I not entitled to enjoy the fruits of the certificate? If there was any misrepresentation on my part, the certificate could have been revoked immediately after September, in October, November, December. Why?
Let me take up the original set matters. I'll pass my orders not today because I'll take up the original set matters.
Lordship,
In the meantime, I'll stay operation, but I'll also give a restraint order on you so that you
Lordship,
cannot
Lordship.
use this certificate anywhere for the time being. I mean, I'll try to be very fast.
Lordship, what I'm humbly praying, Your Lordship, if Lordship, I may be given an opportunity to be heard before the authorities. Lordship,
That
they
would
haven't
go-
heard me.
But that will only be a post-decisional hearing, my lord. I don't think anything turns on.
Not post-decisional. If I set aside and direct a rehearing, also the same thing will be repeated.
Lordship,
Same
Lordship.
thing will be repeated. And they'll give the same
Exactly.
reasons.
I'll be praying for my interim relief of stay of this order. I rest my submission.
Learned counsel for the heard learned counsel for the parties, affidavit of service filed today be kept on record. Full stop, next para. The matter judgment is reserved in the matter. Full stop. Till disposal of the writ petition, comma, the operation of the impugned order of cancellation of the certificate issued to the petitioner shall remain stayed. Full stop. Simultaneously, comma, the petitioner shall remain restrained by an order of injunction from acting on or using the said certificate before any authority whatsoever in any manner, comma, also till the disposal of the writ petition.
Grateful to you, Lordship.
That stay of operation is because they wouldn't insist on the copy being had. Yes, thank you.
Grateful to you, Lordship.
দুটো হলো দুটো পাঠিয়ে দিও
My lord, most humbly, my lord, I'm mentioning one original side matter where my lord has passed judgment and order, but my seniors are online. My lord, kindly allow her to join. Miss Chet.
What do you want? What is your
My lord,
prayer?
there is certain corrections, my lord, and some clarifications required. My lord, my senior is online. Well, kindly allow her to join.
I'll record her presence. I'll put it as to be mentioned on any day which suits you.
As my
I'll make that correction.
my lord,
Let your senior be there.
Probably objecting, my lord has granted stay for 3
It
weeks.
has to appear in the list first. So I'm allowing the mentioning. It will appear as to be mentioned as soon as we can get hold of the file.
Grateful, my lord.
Maybe tomorrow also.
Will I pass on the mentioning slip, my lord, for the
Please
case
do.
details?
Please do. It will be on the list. I hope tomorrow. If not possible, then
So
day
very
after.
grateful.
Oblige, Your Lord.
Thank you very much.
Any mentioning? Any mentioning? No. Today's list, code application under 226, item number 1.
Yes, Mr. Bhatt.
This is my application.
Right.
At the present moment, I have questioned two-fold of argument here. One is whether I can be punished twice for a similar offense, where in respect of that offense, a suit is pending before this honorable court. Secondly, my lord, on the self-same question, I have been penalizing anything without giving me an opportunity of hearing whether this can be done. Now, my lord, lordship, kindly, the first time like to submit before lordship the backgrounds of this case. That I was, my lord, operating an account with the State Bank of India for my business purpose. Now, on the allegation of alleged fraud, an illegal demand was made, which culminated into, my lord, a suit for recovery against 57 respondents.
You had taken a loan.
I had taken a loan, cash credit facilities, and on the ground.
Cash credit, you did not repay that.
My lord, there is the allegations. My lord, suit is pending. I have filed my written statement over there. Still, the suit is pending. Now, on the instance of the SBI, my lord, a caution advice was issued by the RBI because of this fraud, caution advice. I was not in a position. State Bank of India stopped operation functioning bank. So, but to carry on my business, I approached the two different banks. My lord, in view of this caution advice, they refused to open any account. Then, my lord, I moved this honorable court. Now, in the suit, I made an interlocutory application.
Suit is their suit.
Their suit, State Bank of India.
Recovery.
Yes, suit for recovery. But a suit fair is, my lord, the recovery of the pair for suit for recovery decree for 22 crores and odd against the defendant number 1, 2, 3 jointly and severally. This is a main suit. Now, my lord, I approached this honorable court in an interlocutory in the suit. Now, I was allowed to open an account. They preferred an appeal. Appeal court said, no, you take steps against the caution notice issued by the RBI in a different forum. Then, my lord, I approached the Reed court. Reed court said, no, you can open the account with any other bank subject to the completion of all the formalities. They did not prefer any appeal against this order. I opened account. Then, my lord, to enhance my
So the caution advice remained. That was not quashed.
That was not caused, but because that will not affect me. That is the finding of the court. If your lordship kindly.
Welcome to that. After that, what happened? Just
Then, I was enjoying the credit facilities of 30 lakhs, up to 30 lakhs. Then I applied for enhancement from 30 lakhs to 1 crore. Then that application was refused with the plea that my name is appearing in the Central Fraud Registry of the RBI on the same issue where the suit is pending. And without giving me an opportunity, I made a representation before
Central Fraud Register.
Fraud Registry website. That is on the basis of a 2016 circular, my lord, without giving me an opportunity, without intimating me. And my lord, most interestingly, my lord, in another case before the Delhi High Court, the RBI took this stand that RBI, they do not stand in the way. If your name is appearing in the Central Fraud Registry, that will not debar you from applying for the other banks. Now, on the same ground, my lord, since my name is appearing, my application has been rejected.
What have we challenged in this petition?
That
Rejection or fraud registry?
No, for my name is been putting into the fraud registry without giving me an opportunity of hearing. Because this has been decided by the Honorable Supreme Court, my lord, on the such type of cases. Several cases were pending before the Supreme Court, my lord, said, no, my lord, you have to give the personal hearing to the borrower. Otherwise, my lord,
entry in the Central Fraud Registry, what is the part of cause of action which arose here?
Yes, my lord, because
the alleged action.
Yes, yes. My lord, lordship, why this? My lord, lordship, kindly turn to my lord, page 36. Page 36.
36, yes.
Page before that, my lord. Before that, page 32 once, my lord. Page 32.
32. Yes, 32.
This is an order dated 24th of August 1999, my lord. Since the impugned notification which was sought to be challenged was the issue on 8th of December 1980, therefore, considering the balance of convenience and inconvenience, no interim order is called for the aforesaid reason. However, I make it clear that this impugned notice will not prevent and prejudice any banking companies to entertain the application of the writ petitioner for granting fresh loans or opening any account acting in terms of this advice given by the Reserve Bank of India. This is the matter caution notice. At India, it would open for the bank concerned to allow the writ petitioner to open account in favor of the writ petitioner is according with law. Then, my lord, this
impugned interim order was refused, but this liberty was given to you.
This interim order stay of operation. I sought for stay of operation, my lord. I sought for stay of operation.
How else should the operation be stayed, Mr. Pan?
No, my lord, since my lord, that was debarring me from opening any account. That's why not to give any effect of the notification caution notice in opening my accounts. So, my lord, next, my lord, page 33. This application is disposed of by confirming the interim order passed on 24th August 1990. By the impugned notification, I do not find the petitioner has got any basis of apprehension. So this is the whole purpose, my lord. This was this, and all the parties accepted this order. Then, my lord, and subsequently, my lord, there is no allegation against me. There is no default even against me. Nothing sort of that. Now, my lord, I made an application If your lordship kindly turn to page 35 once. This is before the my lord, the Punjab National Bank XDLR branch.
Yes.
Please note that your proposal for enhancement of limit of rupees 30, this is the rejection. This is the rejection. 10 lakhs of your OD account such and such has been returned by our PLP Kolkata South PNB CO Kolkata South. The reason of return has been mentioned in the copy of the mail received from PLP Kolkata South. Copy of the mail has been attached herewith, which is self-explanatory. Well, kindly see the next one. This is my cause of action. While assessing the proposal and doing due diligence, it has been observed that fraud number such and such is showing in Central Fraud Registry portal against Madhumita Group reported by State Bank of India. Type of fraud is showing as fake LCS. The fraud is open as on date as per the CFR report. Hence, in view of the above observation, we are dropping the proposal with an advice to branch for resubmission of the proposal after settlement of the fraud issue. Well, kindly see.
One difficulty is that caution advice, the caution that does not go, that was never set aside.
The kindly
finalize the order, made the order absolute only on the premise that you would be able to transact.
But kindly see,
But that remains.
what I am on is this, my lord. Before put my name into the portal, I must give an opportunity of hearing by the RBI. That is the mandate, that is the guideline framed by the Supreme Court, my lord. If your lordship kindly have a look at this is reportable, my lord. I do not find that till today there is even reported in a. I will have the copy.
Can you give a copy to your?
Yes, man. I will.
Has already received my lord's consideration this judgment.
Already received?
My lord's consideration in another matter this judgment. I found out.
Now, my lord,
and this has been reported also.
Now, my lord, kindly turn to I skip over the relevant part. Only, my lord, kindly turn to their submission that has been recorded in paragraph 52 at page 39.
52, yes.
The RBI and the lender banks are contended that the master direction on fraud impliedly exclude the right to be heard. The objective of the master direction on fraud is to ensure timely detection and reporting of the cases of fraud. My lord, my learned friend, I'm thankful to my learned friend. This is reported in 2023-6 SCC, page 1. I have not received this book as yet. So I'm really thankful to my learned.
Yes.
Now, my lord, the direction contemplate an opportunity of hearing to a third party who is involved in the commission of the fraud actively, but do not explicitly provide for hearing to a borrower. Thus, it is argued that hearing to the borrower is excluded by necessary implications. Now, lordship, kindly turn to the paragraph 81. The conclusions are summarized below. No opportunity of being heard is required before the FIR is lodged and registered. Classification of an account as fraud not only results in reporting the crime onto institution, but also has other penal and civil consequences against the borrowers. Debarring the borrowers from assessing the institutional finance under clause 812(1) of the master direction of fraud results in serious civil consequences for the borrower. Such a debarment under clause 821 of the master direction on fraud is akin to blacklisting the borrowers from being unworthy of credit by banks. This court has constantly held that an opportunity of hearing ought to be provided before a person is blacklisted.
Double jeopardy, I don't accept, Mr. Pan, but this is sufficient unless they have given you an opportunity.
Yes. Now, my lord, what I did, I drew the attention of the ventilating all the grievances before the RBI. And my lord, for my satisfaction, if your lordship kindly have a look at the order of a judgment on the similar type reported in the my lord in a case before the Delhi High Court. That is at paragraph 14. It is Joseph ke din. Eta hocche Tirupati buildings. Tirupati buildings. Paragraph 14. This is the constant, this is the stand taken by the RBI in the similar issue. According to RBI, if bank identifies an account as fraud, then it is to be reported to RBI and
This
to
is
the
which paragraph?
paragraph 14.
Oh, 14.
Uh,
Yes, yes.
Last 4 lines of that particular paragraph. Once a fraud is reported by a bank, it is important that the other banks are sensitized regarding the fraud. In this regard, RBI issues caution advices to the banks mentioning the details about the concerned borrowers and related parties, and also about the modus operandi of the reported fraud, so that banks can exercise due diligence while dealing with the entities and individuals mentioned in the CA. In January 2016, Central Fraud Registry, a web-enabled database of frauds reported by banks, replaced the issuing the caution advice with a few exceptions. Access to CFR has been given only to the banks and select financial institutions. The Reserve Bank of India seeks to protect the banking system from being exploited by fraudsters more than one, and by using the modus operandi used on the first occasion again elsewhere. The RBI has stated it does not assess whether any report is accurate or not. The CFR made available to the banks in expressly for providing critical information for aiding credit assessment. The RBI does not impose a bar on extension of credit or banking facility merely on the reporting of a fraud. Thus, dissemination of the fraud report among banks is meant to facilitate exercising of caution by other banks about the reported fraudster, and the modus operandi followed.
This justified the order of Justice Sengupta.
Yes.
But up to that, I mean.
But my lord, kindly see, this has replaced, that caution notice has been replaced by this that fraud, the CFR. Now, my lord, that has not been given effect to, so far my concern is other than SBI, because suit is pending.
Very well, yes.
Now, there is, my lord, another judgment of Bombay High Court in the line of the Honorable Supreme Court.
Money.
এটা হচ্ছে তোমার রিজার্ভ ব্যাংক হিমামি মানে প্যারাগ্রাফ 13 here my lord.
Yes.
The conclusion or summary at 8.81 they've quoted the Supreme Court paragraph, my lord, that just now I have placed before your lordship. Relying on the same the judgment of the Supreme Court judgment.
Right.
And paragraph 13, my lord. The further, all banks are also at liberty to rescind, withdraw, or cancel any orders already passed under the master circular and which may be inconsistent with the Supreme Court judgment in Rajesh Agarwal, and to reinitiate the process consistent with the Supreme Court decision. We have not stayed the operation of the master circular, the Supreme Court. The Supreme Court has only read certain requirements into the master circular. It follows, therefore, that actions under the master circular consistent with the Supreme Court judgment and decision may be undoubtedly proceeded. So, my lord, at the present, my lord, I am praying for PRF, because I tell you, lordship, my lord, why? Because if your lordship kindly turn to the page 42. Immediately I not came before this court, my lord, against the non-consideration of this at P7, page 42. My lord, wherein I categorically, in my representation, page 46, in my representation, page 46, I categorically prayed. My lord, kindly see, my lord, page 46. This is my prayer, and that has not been considered by the RBI.
Very.
And my lord, I am praying, my lord, at page 22, my lord, of the writ petition pair.
If that this will not prejudice to.
Yes, my lord. That is the only pair before your lordship.
Yes.
RBI,
Your for?
I am the respondent number 3, State Bank of India. I was really hoping to, subject to Lordship's pleasure, that RBI. I can
RBI
make-
should be there. RBI has been served here.
Yes, but I have filed my affidavit of service earlier.
I can make my submissions.
You make your submissions on behalf of the RBI.
Why am I little? I
In
used
support
to-
of the RBI, where will I refrain?
I used to represent 10 years back, and Mr. Dhar, in fact, used to brief me in those matters. Anyway, yes, so wait. Now, this Rajesh Agarwal judgment, I will come to in a moment. Now, this guideline, 2016 guideline, which is the subject matter of Rajesh Agarwal, has two parts really. One is detection of fraud. Second is reporting of fraud. The CFR, the Central Fraud Registry that has been set up, that is really incidental. I will show why. Now, detection and reporting of fraud is up to the banks as per those guidelines. CFR, putting it up in CFR and then doing whatever request to be done is up to the RBI. Reliefs have been sought as per quashing of that, putting up it, the website is concerned. That is not really as far as my concern really. That being said, my lord, Lordship would kindly consider that 2016 guideline, and in fact, all the matters that my learned judgments, my learned friend placed reliance upon, Rajesh Agarwal was considering for several matters. The Bombay High Court, the Delhi High Court, I have checked all of these. All of these were considering matters which required, the issue was whether before declaration of fraud under these 2016 guidelines, these natural justice provisions have to be read into. In fact, my lordship would find even the Honorable Supreme Court in Rajesh Agarwal was really on chapter 8 of those guidelines. Now, what is chapter 8? I will, my lord, please, just to say what's my argument. Chapter 8 is about detection of fraud. How to detect fraud and how to deal with this fraud internally in the banks. Now, chapter 8 read with the initial rules 3, 4, I will place those rules of those guidelines. Lordship would find that these talks about, what it talks about is really, all these authorities talk about is really detection of a fraud which has been newly discovered post these guidelines. Post coming into effect of this guideline on July 1 or this master circular on July 1, 2016. Now, these guidelines itself would show, and of course, Lordship knows that this is not the first time RBI or the banks are up to fraud, how to fraud to be detected and how to classified and all that. The guideline will still show there are 9 or 7 previous guidelines which has been merged in that guideline. Now, in our case, the case at hand, my lord, the fraud that we allege of took place sometime in 97-98. We file a suit. In the meantime, RBI issues this caution advice. Not us. RBI issues this caution advice. Of course, we had reported RBI issues according to the then prevalent mechanism. They challenge this, and I'm thankful to my learned friend. He has fairly pointed out the writ petition, division bench, all that. Now they challenge, admittedly, they challenge it before the Honorable Writ Court in this court. That caution advice, it not squashed. And if Lordship kindly takes up the writ petition, which is averred to in this writ petition and which copy of whereof has been supplied by my learned friend, they challenge this caution advice on the self-same grounds. In fact, Lordship would find, I must be very fair, that the caution advice also challenged on the grounds of natural justice violation behind their back, all this. But be that as it may, 99 writ petition, 2005 comes to a finality. Caution advice is not quashed, and none of these grounds require any adjudication. So, my lord, as far as these parties are concerned, the fact that SBI had detected fraud and SBI had identified a fraud, that has, my lord, reached a finality. That cannot be reopened. Suit might be pending. There might be, and my disciplinary proceedings are over, if that comes to that. There might be other proceedings before Death Recovery Tribunal. But as far as this inter-party are concerned, this matter has reached a finality. So when on July 1, 2016, this guideline, new guideline came in, The fact that fraud had been detected and identified was, my lord, no more in question. So there was really, my lord, nothing to be done under the guidelines of July 1, 2016. I had nothing else to do. In fact, my lord, this is my instruction, this is my factual instruction that I had not reported it afresh. But be that as it may, because they have proceeded there, not so much in the writ petition, their representations proceed on the basis that I have reported afresh to RBI, not so much the writ petition, to be fair. That is immaterial, because I had to, under these guidelines, once the fraud is already there, the detection of fraud is already there, I had to report. Unlike this judgment, what Rajesh Agarwal judgment deals with, and the Delhi High Court and the Bombay High Court following Rajesh Agarwal, I did not have any further step to take, because fraud has already there, finding of fraud internally, at least to that extent. So that is really my submission.
If that be so, why not the same protection should also be given? Because that was the final order. You say attain finality, or right on that apparently, because caution advice was never set aside.
No,
but the rider never set aside.
Yes.
But the rider was in the final order also. The rider was that this will not prevent, and that was submitted by the RBI also in the. So if that be so, why not the same thing should be followed? Why not F should be granted at least now?
May I, my lord, apropos that, may I have, my lord, a twofold answer. First, they have not sought to reopen the issue of quashing of that caution advice on the basis of this latest Supreme Court judgment.
No.
Whether they could have done it, that's a separate issue. They have not.
No, they haven't.
They have not. One. Secondly, if I am not too mistaken, the principal relief sought in the writ petition probably, yes, Lord would kindly see the relief sought. Principal relief sought, ABC.
Fraud entry is to be the reporting of the classification as fraud in the CFR portal, that should be cancelled. That is there.
That's it. But this, really speaking, I have to take instance in this regard. As far as SBI is concerned, SBI is of course not doing any further business with Madhumita.
Not that.
PNB is not a party. The representation to PNB, who had apparently refused the loan, PNB.
Do you say that the caution advice, this central fraud registry is a natural corollary of that? I mean, it has to be done if caution advice remains.
What I understand is this.
If that be so, then you are on a stronger footing.
Yes, what I understand is this: the caution advice remains, and the finding of internal reporting back in 98, 99, all those documents remain. I have been able to find out few of them as to what we had sent to RBI, and at that point of time.
No, is there are the circulars enclosed here? No,
no subject.
The
no
2016
subject to correction.
circular. Because does it refer to the previous? What was the previous guidelines under which caution advice?
Now, I actually tried to find it out back in 1998. I really could not find out. What I could find out, thanks to my officers, is that few documents that what were sent to the RBI back in 98, 99.
No, not your detection. I'm not on your detection. I'm on the provisions under which the RBI did this.
At that point of time.
Because you say the caution advice was also issued by the RBI itself, which
RBI,
they
not
also
me.
say,
Not me.
not you.
In fact, my lord,
You only reported.
yes. In fact, Lord, she would find from this 2016 guideline itself, caution advice. Lord, she would kindly take up that guideline once down. Just few provisions I want to place.
Can I keep this copy of the guideline?
Yes.
Because I'll mark it probably.
Yes. Now, clause 3.1.
This has been interpreted by Justice Chandrachud.
Yes.
In Rajasachi.
Yes. Yes. I am not
Give it to Mr. Pan. He will get a copy from the internet. With the court, you can always give.
No.
He has his resources.
I'm sure, yes. Anyway.
Central fraud registry,
Central
this
fraud
is 3.1, right?
A central fraud registry based on the fraud monitoring returns filed by the banks and the select FIs, including the updates thereof, has been made available, for which banks have been given access to user IDs and password. CFR is a web-based and searchable database.
Are the consequences given anywhere? The consequences of reporting? Consequences, central fraud registry, if it is marked as a fraud account,
Yes.
what will be the consequence?
In fact, Lordship would find my reading and of judgment that all the consequences as to how the banks should deal with before reporting.
In the circular, I don't find anything. I mean,
yes, no, there are, of course, there are provisions that other banks will consider that whether to give this or not. But what I'm on is that 3.1, next sentence. The practice of issuing paper-based caution advice has since been discontinued. So, my lord, CFR is not really a publicly visible or anybody and everybody can see, just like caution advice. Only the banks, and that way I understand, higher ups in the banks can see it. And the caution advice and the replacement of caution advice is central fraud registry. So as far as that central fraud registry's prominence in this guideline is concerned, is only this much. The rest is on detection and all that. That is chapter 8. Now, before that, she would kindly see 3.2.
The other matters are released. 3.2, yes.
Yes. 3.2. Banks need to furnish fraud monitoring return in individual fraud cases, irrespective of the amount involved, to RBI electronically using FMR application SBL system supplied to them within 3 weeks from the date of detection. So I am not there. This case is not there. Next, monthly certificate. Then 3.2.3, fraud reports should also be submitted in cases where Central Investigating Agency have initiated criminal proceedings suo moto and or where the Reserve Bank has directed that such cases be reported as frauds. This had happened for me back in 99, the second part of 3.2.3. And CBI has been investigating since 1999. Not suo moto, but it is there. This is now. Now, I should kindly turn to chapter 8. Now, before that, Lordship would kindly see the index ones, contents ones. Contents ones. I will try to this as little as possible. Chapter 1, chapter 2, chapter 3 talks about the central fraud registry. Chapter 4 is again on internal reporting mechanism of the bank. Chapter 5, we are not really concerned. Chapter 6 is guidelines of reporting frauds to police, which has been done much before. Chapter 7, we are not concerned with. Chapter 8 is loan frauds, new framework. This is what the Supreme Court is also on. And this is completely something, page 18. Page 18, bottom, in fact. Chapter 8. Based on the recommendations of an internal working group constituted by the bank, a framework for dealing with loan frauds was put in place with a circular dated so and so. The objective of the framework is to direct to focus the banks on the aspects relating to prevention, early detection, prompt reporting to the RBI. This has already been done. Now 8.3, I'm not placing, I'm just showing what's there. Early warning signals and red flagged accounts. There's no further scope in our case. I won't put my case so high, but it's really redundant in our case. So first submission, my lord.
So I'll grant if. I'll record the submissions. Prima facie case has been shown by.
Or she would record my contention that it should not be granted.
Learned counsel for the petitioner, Babu, or learned counsel for the petitioner submits that the Reserve Bank of India acted palpably towards the law and principles of natural justice in including the name of the petitioner as a fraud account in the central fraud registry maintained by the Reserve Bank of India under the master directions of the RBI on frauds, classification and reporting by commercial banks and selected financial institutions comma, dated July 1, 2016, bracketed, updated as on July 3, 2017, bracket closed. Full stop, next para. It is contended at the outset that the the said impugned marking of the petitioner's name as a fraud account tantamounts to double jeopardy, comma, since a civil suit is already pending at the behest of the State Bank of India against the petitioner for recovery of an amount of money, comma, on the basis of which the classification of fraud was made. Full stop, next para. It is contended that on a previous occasion, comma, the RBI had issued a caution advice on similar grounds, which was challenged by way of a writ petition before this court. Full stop, next para. In the said writ petition, comma, a learned single judge was initially pleased to observe that no interim order was called for. Full stop. However, comma, it was categorically made clear by the said impugned order that it would not prevent and prejudice any banking company to entertain the application of the writ petitioners for granting fresh loans or opening any accounts acting in terms of the advice given by the Reserve Bank of India. Full stop. It would also be open for the bank concerned to allow the writ petitioners to open accounts in favor of themselves in accordance with law, comma, it was further observed. Full stop, next para. By a subsequent order dated August 18, 2005, comma, the said writ petition, that is WP number 2067 within bracket W of 1999, was disposed of by making the interim order absolute. Full stop, next para. It is submitted that the present classification of the petitioner as a fraud account in the Central Fraud Registry is a mere continuation of the said caution advice, comma, the effect of which has virtually been negated by the orders of the coordinate bench. Full stop. That apart, comma, it is contended that the RBI violated basic tenets of natural justice in classifying the petitioner's account as a fraud account in the Central Fraud Registry without giving any opportunity of representation and hearing to the petitioner. Full stop. In such context, comma, learned counsel for the petitioners places reliance on State Bank of India and others versus Rajesh Agarwal and others, reported at 2023 6 SCC 1, where the Supreme Court observed that the master directions on frauds do not expressly exclude a right of hearing to the borrowers before action to classify their account as frauds is initiated. Full stop. The Supreme Court further observed that the principles of natural justice can be read into a statute or a notification where it is silent on granting an opportunity of hearing to a party whose rights and interests are likely to be affected by the orders that may be passed. Full stop, next para. Learned counsel for the petitioner also places reliance on a judgment of the Delhi High Court in Tirupati Buildings and Offices Private Limited versus RBI, comma, for the proposition that the RBI itself stated in the said case that it does not assess whether every report is accurate or not, and that the RBI does not impose a bar on extension of credit or banking facilities merely on the reporting of a fraud. Full stop, next para. Learned counsel also cites S.S. Hemani versus RBI and others, comma, where a division bench of the Bombay High Court reiterated the principle of the laid down by the Supreme Court in SBI and others versus Rajesh Agarwal and others, Supra. For sub next para, learned counsel appearing for the State Bank of India opposes the prayer for interim order. For sub next para, despite service, none appears for the Reserve Bank of India at the time of call. For sub next para, hence, interim orders are being passed in the absence of the RBI. For sub next para, the petitioners have made out a strong prima facie case for hearing of the writ petition on its merits, in view of the points raised, as recorded herein above. For sub next para, since such arguable issues are required to be decided finally, the petitioners are also entitled to an ad interim order in terms of prayer small f within bracket of the writ petition. Accordingly, the respondents the alleged entry of fraud in the Central Fraud Registry portal against the petitioner, issued by the Reserve Bank of India shall not be prejudicial and would not create any bar and or impose any ban or on extension, enhancement or grant of credit facility or loan facility in favor of the petitioners and or its group companies till disposal of the writ petition. The respondents shall file their affidavits in opposition within 4 weeks from date. Reply if any shall be filed within 1 week thereafter. The matters shall be listed for hearing on September 18, 2023.
Deeply obliged.
Thank you. If the RBI was represented, could have been disposed of probably by directing you to be given a hearing.
Right.
You have ascertained that good service has been effected on RBI.
My lord, I have filed my affidavit of service.
No, in the affidavit of service, please check up. তুমি দেখে নিয়েছো good service?
দেখে নিয়েছো,
দেখে নিয়েছো? Very good. Thank you.
Obliged.